Yes.
This is an application, my lord, for correction of a decree that was passed by your lordship. It was directed to go out of the list because the appellate court had stayed the decree. My lord, and liberty was granted to mention. Now, the appellate court had directed, my lord, the defendant to pay occupational charges, and in default, my lord, the decree could be put to execution. Now, they have defaulted in making payment of occupational charges, my lord. So, my lord, there's possibly, in my respectful sir, no bar in proceeding with this application, which is for amendment of the decree, because once the decree is amended, my lord, there's a correction in the decree. The correction is done, my lord. Then only we can. My lord, there's a misdescription in the schedule, my lord, which, my lord, inadvertently has gone into the decree also. That's why, my lord, difficulty. My lord, any day I have given notice, my lord. If may appear as to be mentioned, my lord, then possibly lordship can fix dates, my lord.
Okay. Is the commercial non-commercial?
Non-commercial, my lord. Non-commercial.
5 तारीख
5th December, my lord. I'm grateful, my lord. Deeply obliged.
Lordship, may I permitted to mention the matter for your lordship's leave for apply drawn up and complete a copy on order dated 8 November 2024, lordship.
When the order was passed?
8 November, lordship. Deeply obliged, lordship.
Yes.
With your lordship's leave, may I be permitted to mention a matter? My lord, it is item number 148 of your lordship's list. My lord, there was an order, the direction from the appellate court. There was an order from the appellate court for expeditiously hearing
this is
this
the
matter,
Lamartine
my lord.
matter, your
Lamartine matter, my lord. Your lordships, the submissions have been made, only the written notes have to be exchanged and the matter has to be raised. My lord, date was fixed prior to vacation.
No,
but
prior, after that also.
But thereafter, my lord, the matter was
after
made
that, not-
returnable on
not
the
after
21st of November. My lord, therefore, it is running in the list ever since 24th of November. But my lord, only thing that is left is, my lord, resolving the matter. My lord, notes have to be exchanged.
Datta has to not make concluding submissions.
My lord, direction was there.
Date fix किया था.
My lord, date and time was also fixed. Date and time was also fixed, my lord. But that was prior to vacation.
Prior to vacation. But thereafter that notification came, my lord, that all fixed matters not were that would appear in normal course.
Normal course.
After that, no date was.
Now, my lord, 6th of November, last order is there of your lordship. There, your lordship has directed the notes to be exchanged, and thereafter, my lord, can all be, my lord, reserve the matter, my lord, for orders, my lord. That is the only formality that is.
Not was to make his
My lord, the order records. My lord, order records notes.
Correct. Mr. Datta was making.
Yes, making his submission.
And this court is of the view. In the meantime, all the party exchange their written notes so that
my lord, notes are ready. If my lord could kindly give some preference to this matter, my lord, like your lordship was giving prior to vacation, my lord, this matter can be concluded, my lord. Orders can be.
Prior to vacation.
My lord, your lordship had fixed this matter. The date and time was given. Thereafter, my lord gave that notification that fixed matters will not be taken up, my lord.
That is prior.
That is prior. But thereafter, on 6th November, the matter was last taken up, where this direction was passed that notes be exchanged. If
date है date is नहीं कोई कैंसिल वाला नहीं है. The non-commercial, ना?
Non-commercial, my lord.
ठीक.
Listed 148.
क्या हुआ 345? ठीक है, काम करो. 4 तारीख को to be mentioned में लेके then we'll see.
My lord.
Fiction to 4th. I am fixing as a to be mentioned. I will see the diary then.
My lord.
4th December.
4th December.
But as to be mentioned.
My lord, may I be permitted to mention one matter? We have taken out an application under Order 9 Rule 13, and there was a direction to file the affidavit in opposition. We have received the opposition on
which year matter?
2024 month.
Order 9 Rule 13.
Order 9 Rule 13.
Expiry decree.
Yes, ma'am. We have received the opposition. Now it's time to file our reply. But difficulty is that, my lord, the defendants belongs to Bangladesh, Islami Bank Bangladesh PLC. They are facing some visa issues. They have intimated this letter, my lord. I am seeking, my lord, only 14 days more time to file my reply.
This is a 2018 suit.
But ordinary Rule 13 application is 2024.
But 2018 suit, it is to be go to the appropriate court.
Probate matter for inclusion in the list. For inclusion in the list.
Why?
Probate matter, non-contentious for inclusion have been done.
Fix in the testamentary.
Your lordship, kind leave to mention, there's a leave has been granted by your lordship by an order dated September 18, 24
wherein a typographical error has cropped up, your lordship. The pages have been mentioned. The order sheet is 182 to 494. It should be 180 to 494. Your lordship, we have carried out the correction in the main plane, but the department has requested us to make this correction from your lordship. That's why I'm humbly praying for the inclusion and for necessary correction to be done. Two corrections, your lordship, on first page.
After 3 months, you have
No,
come before the correction.
we have carried out.
The department has mentioned to you in the month of October itself.
No, your
Department
lordship.
came to me in the month of October before vacation. I have directed. Now you are coming to. Now I am not taking the matter.
Your lordship,
You are coming after the sleeping 2 months.
No, your lordship, I can clarify.
Department has informed this court just after the order, and it was informed to you also.
Lordship.
But you are not taking any steps. After 3 months, you are coming to the court for correction of the order of September 18. When you are not getting the decree
No, lordship.
and not getting the relief.
Your lordship, relief has been sought out. Kindly give me
So
one
it's
minute.
your wish. Whenever you want you will mention the matter before the court.
Apology, your lordship. Just for 1 minute.
Sorry.
Lordship,
Yes.
Lordship, once.
Sorry.
Ah.
Yes.
I'm
My lord, may I be permitted to mention, my lord, a testamentary suit of 2023, my lord. Here, my lord, I'm enjoying an interim order, my lord, which is due to expire tomorrow. Pleadings are complete in the matter, my lord. It's not in the list. It was supposed to be listed on 4th November.
Tomorrow, come tomorrow if it is not listed.
The
My lord,
reply
it's
was
a-
filed yesterday. 2-volume reply of the new documents was filed last
Okay,
night.
it is tomorrow till it is tomorrow. You go through their cause list. What is mentioned?
My lord, it's
Interim
not.
order is to be mentioned if
only-
it is not listed on 415.
My lord, only abundant caution, my lord, because tomorrow is a commercial day. It's a non-commercial suit, my lord. That's why I was mentioning. I'll come tomorrow, my lord. I'll come tomorrow.
Okay.
Okay.
You mentioned item number 1.
Yes. Why to be mentioned?
For extension of interim orders, my lord. Yeah, there's
On
an
the other side.
Your Lordship, I'm appearing on behalf of the defendants number 15 to 21, 31 to 36, and 43 to 56, Your Lordship.
I have filed affidavit.
Defendants.
They have filed affidavit.
my lord, yes,
Yes.
pleadings are complete in this matter.
Completed.
Pleadings
Yes,
are
Your
complete, my lord. Parties were looking towards settlement. That is why from time to time the matter has been, my lord, adjourned. My lord, the last extension of interim order has been granted on the 3rd of October 2024, extending the order up to today.
Yes.
This is in a partition suit, my lord.
Your Lordship, meanwhile, upon my instruction, I would like to submit that one of the defendants, defendant number 15, he has passed away on 22nd of November.
Give the details to the party.
I have received the details, my lord. Right to sue survives against the other defendants, so no abatement, but I will take the necessary action.
So appearing for the plaintiff. So 57, 58 you are appearing.
15 to 21, 31 to 36,
So
and
appearing
43.
for the defendant number 15 to 21, 31 to 36, and 43 to 56.
Your Lordship.
56. Full stop. Counsel for the defendant submit that the defendant number 15 passed away.
Lordship.
Your Lordship.
Full stop. Counsel for the plaintiff submit that he will take appropriate step for substitution and recording the death of the defendant number 15. Counsel for the plaintiff submit that the matter is mentioned before this court because the interim order passed by this court is going to be expired today. Consider the submission made by the counsel for the respective parties. Interim order granted earlier is extended till non-commerce till 15th of January 2025 or until further order, whichever is
Most grateful.
next.
Lordship, I am for the petitioner. Lordship, last order passed on 5th October 2020.
Your microphone. Yes.
Lordship, last order passed on 5th October 2024. Direction 3 weeks time to serve the copy. But unfortunately,
Carry out the amendment.
Lordship, kindly 2 weeks time.
For what?
Due to personal inconvenience, unable to serve the copy.
No, whether amendment is carried out or not. Regarding the service of copy will come later on. Whether what the order amendment was allowed.
Yes, Lord.
Correct. Amendment is carried out.
Lordship, my senior
It's engaged court number 13,
Ah,
Lordship. That's why that much of instruction.
Divine direct to carry out the amendment
Well,
within a period of 3 weeks on reopening of the court after ensuing puja vacation. To take instruction whether it has been carried out or not, unless and until the amendment is not carried out, what you will serve?
Lordship, kindly some time, Lordship.
For what?
I just inform her.
Yes. Not today.
Lordship, in this matter, appear on behalf of the plaintiff. I'm praying for substituted service on the defendants. If I may hand up the report of the sheriff. Lordship, 7 defendants have been served. However, even by speed post and by the bailiff, the rest of the defense could not be served.
How many defendants?
Lordship, there are 13 defendants. There was an investment agreement between the parties.
13.
Yes, Your Lordship.
One to 7 undelivered. 5 undelivered. 11 undelivered. 12 undelivered.
Lordship, 3 and 4 and 6, 3, 4, 6, 8, 9, 10, and 13 have been delivered. Defendant number 12 and 13 reside in the same address. They are husband and wife. However, defendant number 12 has come back as addressee absent, and rest of them are companies, Your Lordship. We have served them at the offices as mentioned in the MCA portal.
3, 4, 8, 9, 10.
3, 4, 8, 9, 10, and 13 have been served.
6 and 13.
Yes, 6 and 13.
It has been served the postal services, through postal service.
Yes, Your Lordship.
So 1 to 7. 1 to 7 not served.
Lordship, 1, 2, 5, 7, 11, and 12 have not been served.
2, 5, 7.
11 and 12.
11, 12 not served.
Yes, Your Lordship.
So what do you want?
Lordship, substituted service by way of paper publication.
In Calcutta or outside Calcutta?
All of them reside inside Calcutta, Lordship.
So and so bring for the plaintiff. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. The plaintiff has handed over the service report issued by the Deputy Sheriff of Kolkata of this court, dated 12/11/2024, wherein it reveals that writ of summon through postal services were served upon the defendant numbers 3, 4, 6, 8, 9, 10, and 13. But 3, 4, 6, 8, 9, 10, and 13. But no, but the writ of summon could not be served upon defendant number 1, 2, 7, 5, 11, and 12.
Yes, Lordship.
The counsel for the plaintiff submits that as the writ of summon could not be served either through the process server or through the postal services, and as such, she prays for substituted service by way of publication. Consider the submission made by the counsel for the plaintiff. Peruse the report. The plaintiff is granted liberty to cause service of the writ of summon by way of publication of the notice in the English daily newspaper, the Daily Telegraph,
Lordship, Statesman,
the Statesman, and
Sunmark,
and the Bangla newspaper Sunmark.
Lordship, Hindi newspaper Sunmark. All of them are not Bengali speaking.
Not Bengali.
Yeah.
They're not Bengali.
No, they are Hindi speaking, Lordship.
The plaintiff is directed to take appropriate steps for publication of the.
Lord, I'm praying for an extreme indulgence, Your Lordship. I'm praying for extension of time to use the affidavit in opposition till tomorrow.
Affidavit in opposition of?
For one, that is yes. My Lord,
And only till tomorrow, the advance copy I can serve today. It's ready.
Let me say what is it about.
Yes.
My lord, only till tomorrow, my lord.
Oh, till tomorrow.
Till tomorrow.
Then I
The advance
Tomorrow
copy
the
is
court is having objections. Tomorrow is
No,
not.
our Wednesday. Yes.
come to the end of the month. This is that
OJA matter.
withdrawal, my lord.
But and also just one sentence more before my learned senior friend starts, my lord. And we have also preferred an appeal. We have already got the number. It has already been served. That I should be
No,
indicating.
not on that, my lord. We are not on that, but there's some practical difficulties. Now, again, we are at the end of the month. The entire dues have again fallen due. One more difficulty is, my lord, there is no signing of the rent.
Have you got the stay order in the appeal?
No, it has been filed. No.
It's not appearing.
We have just filed.
Not even appearing.
I cannot file a stay because it's from a dismissal of the suit. There can't be a stay of dismissal.
That's the main order.
Stay of proceedings is been
Stay of the dismissal of the suit.
That is the
Dismissal
main
of
order. That is the main order.
Yes.
With regard to this,
No.
No. With regard to this,
The difficulty what I'm facing is that, but every time because of these kind of adjournments, my lord, the running is coming to a standstill. The staff salaries, the electricity expense, all necessary expenses.
but I'm not
cannot-
standing in the way.
And
On that, I'm not standing in the way.
another difficulty is, my lord, the special officer also does not know whether to work or not. Rent bills are not being signed. Revenue is not coming in. What I had asked for in this application is only consequential to that. If
Yes.
the learned friend succeeds in having your lordship's order set
let they
aside,
get the order set aside, remand the matter back, then we will.
The only thing was the dismissal of the suit because of non-compliance of an order. That's the only thing. So we are
but
not
my
just
learned friend
trying.
was
We are
not
trying.
there.
I was not there. I have been
I
briefed
also
recently.
wonder what circumstances your lordship passed that order. Your lordship
That's
does
right.
not pass that order
Yes.
ever in any other matter.
But the precarious situation in the suit is such, and the special officer has been continuing since
That's
time.
correct. That's what correct. But the situation like that, what
Yes.
can be done?
But we'll
Whenever
try and
like this only. Whenever the courts come, there are several advocates. One is affidavit, one is reply, this and that. The suit and the court has appointed the special officer to conduct the case. The parties are not adhering to that. Also, what?
No,
can
but I am not standing in the way. The special officer
Okay, no
discharged.
problem. Whatever it
I am not standing in the way.
But
Let my learned
What-
senior friends
What about the prayer of Mrs. Sen?
regarding disbursement. I am not standing in the way. If the others oppose,
No, Lord, I'm not opposing. I'm supporting Mr. Sen, Lord. I also appear for the workers. Lord, in that
Month of October and November.
we have it. Lord, in that list, my Lord, from serial number 3 to 10, my Lord, is what is urgently required to be disbursed.
Remuneration, clerk
Yeah.
remuneration,
Yes,
property tax.
Employee salary, that is important, my Lord. And Lord,
3 to 10.
CSC bill, electricity bill. 3 to 10.
yes, madam. Let
And
these
not
be
12.
disbursed. I am not. And only one humble submission. Apart from this,
And only thing, Malad, if my learned friend takes time, Malad, the special officer can, in the meantime, will continue with the activities of signing of the rent bills.
Yes.
yes,
They will not
yes.
pay the rent.
Yes.
So and so suffering for the
Yeah, police last.
plaintiff. You are not going to correct about so and suffering for the defendant number 2 and 4.
Nevin, I have a big heart.
The counsel for the plaintiff prays for a day's time to file affidavit in reply. Affidavit in opposition. Affidavit in opposition. Opposition. Counsel for the plaintiff prays for time to file affidavit in opposition in connection with GA 28 of 2024. Counsel for the defendant number 2 to 4 submits that the special officer is facing difficulties for release of remuneration of employees, paying property tax, and to issue the rent bills.
Rent bills,
And
my
to
Lord.
raise the rent bills to the tenants. And as such is praised that until the disposal of this case, disposal of the present application, the special officer may be allowed to continue to pay the remuneration of the employees, also to pay property tax and other taxes, and also to raise the rent bills from the tenants.
But one humble submission in this regard, my lord. The plaintiff was to also to get the salary per month. We have requested for that. That has also been stopped for a considerable period. If
Lord,
that can also be.
Lord, it has no fund, my lord. That is why, my lord, the urgent release are being
At
sought.
the landed council for the respective parties.
1 to 10 if they can release.
Parties, the plaintiff is directed to solicit the
Serial number 12.
plaintiff is directed to file affidavit in opposition within a week from the
11 ta baki hai.
reply, if any, there to file within a week thereafter. Police release the matter. We are on 28, na? Release the matter on 18th of December 2020.
We will file our reply to that.
That 1 week, 1 week.
My lord, your lordship has also indicated, my lord, 1 to 10, my lord, in serial numbers 1 to 10.
I am only granting 3 remuneration of the receiver.
Yes, my lord.
And clerk remuneration, property tax, employee salary, employees PF, CSC bill, telephone bill, and
office
maintenance charges.
Yes, my lord.
And where is that 2?
2 is, my lord, the plaintiff's remuneration, my lord.
Why only plaintiff? One.
No, I am not joining issues with 1 also.
Where is that rent raising rent bills?
Raising rate
No, at the bottom.
have to do.
At
This
the
is
bottom,
expense.
Kya bola?
At the bottom, your lordship will
I
find.
am not opposing 1 either.
Full stop.
At the bottom,
The-
my lord, rent
The
receipt not
receiver
subject.
and the special officer is directed
बोले दीजिए.
that in the meantime, you till the disposal of the present application shall release the receiver remuneration, comma receiver, receiver clerk remuneration, comma pay the property tax, comma employees salary, comma employees provident fund, comma CSC bills, comma telephone bills, comma office maintenance charges, and also to raise the rent bills and to give rent receipts on receipt of the rent from the tenants.
My lord, just one more indulgence, your lordship. May kindly see serial number 12, my lord. This auditor has been suffering, my lord, because of the fight between the parties. My lord, I'm requesting, my lord, for release of this payment as well, my lord. He is suffering, my lord, for the fight between the parties. He has done the accounts.
The auditor shall also at liberty to pay the auditor fees if he found that the fee raised by the auditor is genuine
Yes,
and is liable and is entitled to get the settlement.
Yes.
My lord, 1 humble submission if it commences to your lordship. If the funds are available, if serial numbers 1 and 2 can also be catered to pro rata. If the funds are available.
Let the suit rest. Extremely grateful.
And your lordship has extended the time till tomorrow, my lord, to file the reply.
To opposition.
Yeah, given 1 week,
Very good.
but you give it
I shall give it tomorrow.
opposition replying auditor fee if he found that the fee raised by the auditor is genuine and liable to be.
Extremely grateful.
And is liable. And liable to receive.
I'm for the plaintiff. My lord, the defendant's application, they wish to abandon two of their counterclaims.
Huh?
The defendant wishes to abandon 2 of their counterclaims. So that's why the
prayers were actually, my lord, already before the NCDRC, and they were also in the counterclaim. And since my application GA7 was rejected, I am going in an appeal to the Supreme Court. So I want to withdraw those 2 prayers, my lord, from the counterclaim.
have no difficulty, but then technically he should possibly get the WS amended. If he has to strike off prayers, it's a written statement already filed.
There is a counterclaim.
Yes, possibly
The counterclaim is, my lord, can I give you my copy?
No.
It is on page 108, my lord.
108?
Yes, my lord. Prayer F and prayer G, my lord.
Prayer F and
G.
Direct to stay fresh sale flats.
It is already mentioned, my lord, that this prayer is already pending before the NCDRC, and this honorable court may pass any order as it may deem fit for both the prayers.
His case is that it was before NCDRC. Be that as it may, he's not praying for any leave to file a fresh
So what about the other prayers?
The other prayers stay intact, my lord. I'm praying for all the other prayers, but only these two prayers, since they were already before NCDRC, and I had put them here, and now I want to withdraw these two prayers.
F and G.
F and G, my lord.
He can abandon part of his claim that, and he's not seeking any liberty because he has said that he has already made this prayer before NCDRC. I have no difficulty if it is done. Maybe an amendment to the written statement or counterclaim would have been an appropriate procedure, but then he's appearing in person, so I don't want to, my lord, take this technical point.
What's the order passed in GA7?
My lord, that application has been rejected.
His application.
My application in GA7, which was before my lord, because NCDRC had released the case and given it to
last.
Yes, my lord.
Okay. Yes.
Only thing, my lord, my additional written statement to his counterclaim, it was to be filed this Monday. My lord, there was 2 days delay. It is ready and affirmed. May I file it before this honorable court, my lord? I can. No, if he's, that's fine. If he's withdrawing two of his claims by my written statement to his counterclaim is prepared, taking into account
that is within 120 days.
My lord, this was directed, my lord, after his counterclaim was accepted, your lordship had directed it to be filed by Monday, this 26th. It has been the 2 days delay affirmed yesterday. My lord, may I file it in court? Because the department may not accept it because my lord's previous order.
Yes.
I will
have
serve
no
it.
objection, my lord.
I'll serve it, man. At a copy later.
Although I would have prayed for 10,000 rupees fine on them. Because I was also imposed a fine of 10,000 rupees.
That is for 1 year delay. That's a different 1 year, 2 days.
So 1 year delay, 10,000 rupees. And then 2 days delay.
2 days delay. So proportionate.
200 rupees. So
My lord had directed me to ask him to come for a cup of coffee, but he's not accepting it.
You might have been offered in the normal restaurant. You could have been offered in the.
My lord, I'm ready for whichever it was. The best in Calcutta. But the bigger ones are not really good, my lord.
So appearing for the plaintiff. Defendant number 1 is appearing in person. Defendant has filed the counterclaim along with the written statement. Now the defendant submits that the claim made by the defendant in prayer F and prayer G of the counterclaim is the subject matter of the NCDRC.
Yes, my lord.
Is the subject matter of
was the subject matter?
Was the subject matter? Now since I'm going to the Supreme Court, so
the subject matter of the NCDRC and challenging the order of the NCDRC, the defendant preferred or preferring?
Preferring.
Is preferring an SLP before the Honorable Supreme Court, and as
my lord, actually it will be an appeal instead of SLP.
Preferring an appeal. Preferring an appeal before the Honorable Supreme Court against the order passed
by the NCDRC against
by the NCDRC.
Whatever his petition case, he wants to abandon
Counsel for the plaintiff and the defendant appearing in person, defendant number 1 appearing in person. Submit that he will not press, he is not pressing prayer F and prayer G of the contract claim. Police counsel for the plaintiff raised no objection. Accordingly, prayer F and prayer G of the contract claim appearing in page 108 and 109 is deleted. Police stop. The plaintiff is the defendant is directed to take the department is directed to take appropriate steps to amend the written the contract the contract claim by deleting the prayer F and prayer G of the contract claim. Police stop. The plaintiff is the defendant is directed to file. Not necessary. Amendment is not necessary. It is only deletion. It will
has directed it to be deleted.
The plaintiff has filed the written statement to the additional written statement to the counterclaim after serving the copy to the defendant. Let the same be kept with the record. Police stop. So now pleading is completed.
Now pleadings are completed in the suit.
Complete, my lord, and my lord had said on the last occasion that today my lord will pass orders for verification of the.
That's why. That's why.
My lord will, yes. Whatever necessary directions to be given.
Though the pleadings have been completed, the parties are directed to complete their discovery and inspection of the document within 3 weeks.
My lord, 4 weeks makes it 4 weeks. 4 weeks will possibly take it to the vacations, maybe 1 week after reopening. 4 weeks.
Within on or before 2nd of January 2024. 2025. Full stop. Affidavit of admission, affidavit of document be filed within
Well,
2 weeks
within 2
thereafter.
weeks thereafter.
Full stop. In the meantime, the parties are also directed to exchange their suggested issues. Full stop. List the matter on 2 weeks bola na? Is the matter on 22nd of January 2025 for framing of issues.
My lord, can I make a prayer? If my lord could fix the time also.
Framing of issues, nothing.
Okay, my lord. Much
Grateful.
obliged, my lord.
Grateful. Grateful.
हाँ? ये क्या है? नहीं ये कुछ नहीं किया, तो सूट में ऑर्डर किया, ये पता नहीं क्या किया. Yes.
Confirmation of sale of a trust property. Now, my lord, on 14th of November, the Lordship has passed an order, my lord, where your Lordship will find that the only offer has been made by my learned friend's client. Now, my lord, 20% of the being the earnest money has been deposited, kept in the safe custody of this honorable court. My lord, a further direction was also passed, my lord, to communicate this order to the officers of the corporation. That has been done. They have received it, my lord. May I file the affidavit of service? So,
Nobody has come.
Nobody has come forward. So, my lord, I was humbly praying, my lord, if the sale be confirmed, my lord. Now, 2 orders are there. 27th September 2024 and 14th November 2024.
Yeah.
And the only offer which we have received is from AK's Treasury Management LLP. That's an offer of 3.5. 3.1. 3.51. Sorry.
3.51 ko.
Yes.
So what you will do the amount, how it can be?
My lord, the earnest money has been deposited before this honorable court.
That I
The
know
rest, my lord, it can be paid either, my lord, to the trustees. Sorry, to the trust, my lord. Bank account ache to? They have a separate bank account in the name of the trust. It can be paid directly to the bank account. And, my lord, the earnest money can, my lord, also, my lord, go to the can be handed over to the trustees, and then, my lord.
That is correct.
Yes.
But then how you will utilize for the benefit of the trust only?
For the benefit of the trust. Has to, my lord.
How many trustees are there?
My lord, only 4 trustees. Your lordship will find all the 4 trustees have made this application. Nirmal Kumar Sadhu Khan, Shoibal Kumar Sadhu Khan, Sholil Kumar Sadhu
Tenants are
Khan.
there.
My lord, tenants or merely, my lord, all trespassers. My lord, pending litigations are there against them. And, my lord, there's a condition is very dilapidated.
Do one thing.
Yes, my lord.
You do one thing. Nobody is there. I am passing an order. Come with a proposed agreement with the seller. That agreement will be accepted. On the basis of that, this order will be passed, and that agreement may be affirmed in the meeting of all occupiers, and that will be accepted. Then appropriate direction will be
Grateful.
given. That will be
Grateful.
better.
Grateful.
Then on the basis of that, the sale deed can be
Yes.
executed after obtaining.
Absolutely. Absolutely.
So and so appearing for the petitioner trustees. So and so appearing for the proposed purchaser.
Oh.
In spite of the several direction passed by this court, the municipal authority, the municipal corporation failed to submit the report before this court. It is found that the only one proposed purchaser has come forward to purchase the property of the trust for a total sum of rupees 3.51 crores, and accordingly the proposed purchaser has deposited 7 lakh 20,000.
70 lakh, my lord.
70
Sorry,
lakh.
70 lakh 20,000 being the 20% of the proposed purchased amount in the by way of demand draft. Demand draft, na?
My lord.
Yes,
By way
yes.
of demand draft, which is kept with the record of this court. Full stop. Till date, none of the purchaser has come forward for giving any excess amount to that of the proposed purchaser. Accordingly, the parties are according the petitioner and the proposed purchaser directed to come with the proposed agreement for sale of the property in question within a week.
Within a week.
Within a week from date, the proposed agreement, if any, executed between the trustee and the proposed purchaser shall be confirmed in the resolution of the trust. And the parties are the petitioner directed to file the draft copy of the agreement along with the resolution of the trust within a week from date.
My lord, instead of agreement for sale, let it be deed of conveyance, my lord.
Deed of conveyance kar dena. Instead of deed of conveyance. This is the matter on today we are on 28. On 5th December it will be
5th
ready
December.
because their passive amount is kept here.
Yes, because we have to, my lord,
Ah,
hurry up
that-
because the draft, my lord, is 3 months and it's
That's enough.
drawn on
Then you
30.
will get the interest
Yes,
also.
yes.
No? 5th of December under same ID.
Grateful.
I'm grateful, my lord.
Seven, my lord. Yes, very.
Considering the above, the parties are directed to maintain status quo with regard to nature, character, and possession of the suit property till the disposal of the suit.
I'm briefly. And my lord, the
As on 4th of
disposal-
July, when the interim order was filed interim, as on 4th of July.
And my lord clarified that, my lord.
Clarify.
And my lord, I have filed a GA2, my lord, that may be listed next week. My lord, the amendment.
You
No, that
mentioned-
was listed as the next item immediately last day.
Uh-huh.
My lord was of the view that my lord, GA1, my lord, will hear up first.
What is the GA2?
Amendment. My lord, recollect, my lord,
My lord, I have another application GA3 considering the probate application pending under section 211 of the Indian Succession Act, property vests with the estate executor. So in view of that, my lord, I have prayed certain prayer for my, because if I file no my lord, written statement, if I am
Why not let them probate be brought here?
Yes.
Both the suit can be tagged together. That will be better.
sorry, my lord,
Let him take
I'll be
steps.
deeply obliged.
Let him take steps. My lord, we have no-
I have filed an application to that.
We'll be happy to do this.
Yes,
Because my lord is also having the jurisdiction of that recent year.
Because otherwise conflict it will.
Yes,
It
yes.
will be conflict
GA3,
because
my
he's asking the partition. You are
Absolutely.
claiming the probate. So if you
It will not benefit anyone if the unless the matter is heard out my lord, as a whole, my lord. Absolutely, my lord. Mine one is GA3. My learned friends is GA2.
GA2.
sense suffering for the plaintiff, sense suffering for the defendants. Full stop. The counsel for the plaintiff submitted. The plaintiff has filed an application being GA2 of 2024, praying for amendment in the amendment of the plaint. Counsel for the defendant submitted. The defendant number 1 has filed an application for filed an application being GA3 for appropriate orders. In view of the submission made by the counsel for the parties, let both the GS be placed before this court along with CS number so and so.
I will give a fortnight gap because today morning I have heard that defendant number 2's husband expired.
Defendant number 1.
Placed before.
My lord, my amendment is necessary. My lord, keep that, my lord, on 4th.
I have
It's
recorded
my
the
duty to
amendment.
point it out, my lord. That is why.
Placed on 12th of December. 12th of December. Separate. Yeah.
Deeply
Yes.
Lordship, I appear for the plaintiff. This matter was originally filed as a commercial suit and later I had withdrawn and now I have filed it as a regular suit. But it's a transaction where the plaintiff had advanced an unsecured loan. The board resolution which records the unsecured loan is at page 13, my lord.
Well, let there be suit properties, my lord. So plural. Properties, my lord, I said property.
Well, the suit property, well, is a residential property, well, they are indicating, well, because otherwise the business property, there is nothing in there.
Let there be suit properties.
I have
Yes, yes.
clarified in my observation. I have clarified in my
Property, there are multiple.
No.
Sorry, my lord, for you.
Yes, yes, yes.
Lordship, the board resolution which records the grant of the loan, that is, my lord, at page 13. And there is the ledger has also been annexed, which
Page 13.
page 13 is the board resolution, my lord,
Board resolution for
for grant of the loan, where it is been recorded that the loan is being granted at the rate of 30%.
okay.
In page 14, my lord, that is the ledger which shows the disbursement. Lordship will see the first 4 entries.
Okay, why clause 12?
Lordship, clause 12, because part of the
Both are within jurisdiction.
no, my lord, I think
Where is the cause of action?
the registered office might be outside the jurisdiction. That is why the clause 12 leave was taken, which is pin code 38.
Where do you mention?
Lordship, in the cost title.
Registered office at Chitranjan Chatterjee Road.
Yes.
Police station, New Alipur. And its corporate office. But you are not describe that. Only come to the page 1, cost title, Chatterjee Road, Police station, New Alipur, and its corporate office, Lindsay Street, within jurisdiction. That you not mention.
Lordship.
What you will do? And where is the averment in the plaint?
Lordship, the averment is at paragraph 16 at page 7.
Even kindly come to the paragraph 1 also. Chatterjee Road, New Alipur, Kolkata.
And its corporate office.
And it's before that you have to mention outside the
outside.
jurisdiction of the court.
Outside. Lordship, kindly takes paragraph 16 at page 7. I have explained there.
Paragraph 16?
Yes, my lord.
Yes.
There I have written that in as much as part of the cause of action has arisen outside the jurisdiction of this honorable court, the plaintiff prays for leave.
How the part of cause of action arose outside?
Lordship, since one of the offices is outside the jurisdiction, otherwise everything is within the jurisdiction.
Even though, but you are not mentioned. You not mentioned. I am giving liberty. So suffering for the plaintiff. Counsel for the plaintiff submit that the registered office of the plaintiff company is outside of the jurisdiction of this court, but though the plaintiff has mentioned the address, but inadvertently it is not recorded in the cause title as well as in the paragraph that outside the jurisdiction of this court. Accordingly, the plaintiff is granted leave. According counsel for the plaintiff prays for leave to amend the cause title and the paragraph 1 of the plaint by adding the word outside the jurisdiction of this court. Consider the submission made by the counsel for the plaintiff. Leave is granted to the advocate on record of the plaintiff to amend the cause title of the plaintiff as well as in paragraph 1 by incorporating the word after the address of the plaintiff outside the jurisdiction of this honorable court. After the amendment is carried out, and police of the said amendment we carried out. How many days? How we? 1 week. Within a week from date after the amendment, let the matter be placed before this court. Next. नहीं है.
My lord, I am for the plaintiff.
Yes.
My lord, this
Yesterday, but kindly come to the concise statement.
yes, my lord.
Where is the prayer? You prayed the order to rule to pray for leave order to rule in the prayer portion paragraph from page 22.
Yes, my lord.
Correct.
Yes.
Kindly come to the concise statement. There is no prayer.
It should have been. Lord.
Sons of sons suffering for the plaintiff. The plaintiff in the prayer portion of the plaint has prayed for leave under order to rule 2 of the Code of Civil Procedure 1908. But in the concise statement, the plaintiff has not prayed for any leave under order to rule 2 of the Code of Civil Procedure. The advocate on record of the plaintiff is granted liberty, and the counsel for the plaintiff prays for leave to amend the concise statement by incorporating the prayer for leave under order to rule 2 of the Code of Civil Procedure. Consider the submission made by the counsel for the plaintiff. Leave is granted to the advocate on record of the plaintiff to amend the concise statement by incorporating the prayer for leave under order to rule 2 of the CPC within a.
My lord, if your lordship grants liberty to the advocate, then it can be done instantly. But the petitioner himself is 92 years old.
Advocate on record.
Advocate on record by hand.
In course of the day.
In course of the day.
In course of the day. After the amendment, let the matter be placed before this court.
My lord, when is your lordship fixing it again, my lord?
Wednesday.
Yeah, kindly let it, my lord, be mentioned in the order.
That already placed before this court.
I'm so grateful.
After the amendment, it may be.
I'm so grateful.
Next.
In this matter, Mr. Meghnath Datta, this is the argument matter, my lord.
Yes.
This is the argument is going on, my lord. Your lordship, my lord. Yesterday also in the adjournment motion heading, my lord. Today is a testamentary. Your lordship fixed another date, my lord. Mr. Meghnath Datta.
That matter.
That matter. All are complete.
The probate of the will. I am the propounder.
Yes, ma'am.
That Mr. Datta was arguing for the respondent assigned is parted before your lordship.
Yes, parted matter.
From the earlier determination. Now, he should do the matter, my lord.
Yes, my lord. Last occasion, he also he do the matter, my lord.
What's in a heading?
What's
in a specially fixed?
Yesterday also in item number, my lord, 74 not taken up, my lord.
Because yesterday it was not the testament.
Yes, you also fixed another date, my lord.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the plaintiff.
Yes, my lord.
No.
Counsel for the plaintiff.
Trace
for time. Accordingly, case adjourned. Let the matter appear on 11th December under the same heading.
11.
Yes.
Next.
Oblige.
Item number 13. Your lordship, this is my application. This is an application for interim reliefs in connection with an application for grant of letters of administration. If your lordship kindly takes the order dated 4th of October 2024, there is already a subsisting order of injunction against all the heirs, your lordship. Now we were to serve and come back. We have already effected the service on the other two heirs who are the parties. At pages 76 and 77, the tracking receipt is annexed. So the service has been effected. And we had already notified the other heirs by our previous notices at pages 35 to 38, even prior to institution of the application. Now, in these facts, your lordship, when the matter came up for the first time before the other bench, your lordship coordinate bench, we had made a request. We had prayed for interim injunction. Interim injunction has been granted as against all heirs from dealing with all the assets forming part of the affidavit of assets. Now, we had also made a consequential prayer for disclosure of the status of asset, which admittedly had been transmitted to one of the heirs. Your lordship, if your lordship kindly sees the last order, if the other side would have appeared, then a direction for affidavit could have been passed for them to disclose the status. Yes. If your lordship kindly comes to internal page number 2 of the last order.
Yes.
Mr. Kumarjit Banerjee so-and-so, appearing for the petitioner submits, this is left behind substantial assets, including movable assets in the nature of cash in bank shares held in stock of Fort Share Broking Private Limited. deposits of which held in demat account as well as mutual funds. Apprehending that said movables be withdrawn or liquidated, the petitioner through her representative and advocate wrote a letter to the Fort Share Broking dated 22nd of July 2024 intimating them about the death of Mr. Balkishan Jhawar
Yes.
as a reason not to take any steps in respect of the investment of the deceased. He also indicates that in response, Fort Share Broking Private Limited has informed petitioner Miss Preeti Jhawar, who is my sister and one of the heirs, the registered nominee made request for transmission of the shares and the request was duly executed. Now, insofar as a nominee in respect of shares are concerned, security is concerned, it is settled law that they need to account to the estate. They don't have beneficial ownership. So, in view of that, in the last page of the order, Your Lordship, the Honorable a single judge was pleased to pass an order. On perusal of the affidavit of asset at page 18, it is found that deceased had shares in the stock of Fort Share Broking Private Limited, the face value of which is so and so, and deposits held in demat account of Fort Share Broking Private Limited amounting to so and so. The letter dated so and so addressed to Fort Share Broking Private Limited by the petitioner shows that a request was made before the said concern not to take any step in respect of the investment of the deceased. In response thereto, vide letter dated so and so, it has been informed to the petitioner or its advocate that shares were transmitted in favor of registered nominee as well as to her learned advocate. In view of the above, the petitioner as well as Ms. Pramila Jhawar and Ms. Preeti Jhawar are directed to maintain status quo in respect of the assets and effects as mentioned in the affidavit of assets being annexure B until further order.
Now what you want?
So insofar as prayer B is concerned, because there has already been a transmission, the correct course would have been a direction upon them to file an affidavit disclosing the status of that. So in that event, Your Lordship, and they have not yet lodged caveat either.
Correct.
That is also recorded in the order. So today it is not in contest. So if it is Your Lordship's pleasure, Lordship can also pass a direction upon the other heirs to disclose by way of an affidavit as to status
How
of
many
assets.
years are there?
3 heirs. I'm the applicant.
So these are the two. You issue
other-
the notice.
I have already issued a notice.
They are not appearing.
They are not appearing.
So what can be done?
Let a direction be issued from them to disclose the
Citations
status of
issued.
assets. One direction citation has not been issued. Item number 41 of today's list is the application for grant of letters of administration. Let the general citation.
So what is this?
Application for this is the interim relief. This is the application for interim relief. GA.
This is 13, na?
Yes.
13.
Item number 13.
13, this is GA1.
GA1. Item 41 is the PLA.
41, 369. No. The same thing. Here also PLA is there.
140. I'm sorry. 141.
141.
141.
Hey, क्या अलग अलग क्यों हुआ?
देखाओ लिस्ट है देखाओ cause list.
Why two places? Why in two places? Okay, then the same, it has been doubled. Number double. So you're not citations not issued.
Citation has not been issued.
Where is the PLA?
Your Lordship kindly sees page 10 and 11 of the application for interim reliefs. Prayer A has already been granted.
Correct.
Prayer B is a direction upon Miss Preeti Jhawar to disclose the details and particulars and status of shares of the deceased transmitted to her. Because this is an admitted position, she has to account. And nobody will be prejudiced by that order.
That's a prayer B is concerned, it shall be considered after service of notice.
Yes, and we have already made service of
You have made service, it is not. Now what? Instead of that, status quo is already there. Let the citation be issued.
Very well.
If the citation is issued, they come. They will not come automatically a non-contentious cause. Then you can prove.
Very well. Very well. And in the meantime, a general direction for affidavits, if any. Actually, if citation is issued,
Citation
that is
that's I'm telling.
Very
That
well.
will serve the total purpose.
That will serve the total purpose. I appreciate your Lordship.
So appearing for the petitioner. Full stop. The petitioner has drawn the attention of this court to the order dated 4th October 2024, wherein this court directed the petitioner, Mrs. Pramila Jhawar, JHW, and Miss Preeti Jhawar to maintain status quo in respect of the assets and effects as mentioned in the affidavit of assets being Annexure B until further order. This court also of the view that only after issuance of the notice upon Pramila Jhawar and Preeti Jhawar, prayer B made in GA1 of 2024 can be considered. Full stop. Counsel for the plaintiff submitted as per the order dated 4th October 2024, the petitioner has sent the notice to the Pramila Jhawar and Preeti Jhawar, but in spite of receipt of the notice, none appears on behalf of the said two persons. Full stop. This court find that in the probate application, the petition
Application for grant of letters.
counsel for the petitioner submitted no caveat has been lodged.
That is also recorded in the order, Your Lordship.
Caveat has been lodged. Full stop. It is fine from the probate application, application for grant of letters of administration, the petitioner has prayed for issuance of general citation as well as special citation. Accordingly, this court is of the view the purpose should be served if the petitioner is directed for taking appropriate steps for issuance of general citation as well as special citation. Full stop. The petition is directed to take appropriate steps for issuance of general citation and special citation within a week. Within a week from date, full stop. The department is directed. The petition has taken appropriate steps. The department shall issue the special citation within a week thereafter. Full stop.
And let the interim order continue, Your Lord.
Already there is no time limit.
No, still further orders.
Until further order. The interim order granted earlier, dated 4th October 2024, be continued until further order.
I appreciate it. I'm deeply obliged.
Next.
Now the carriage is on them.
Your Lordship, I appear for the applicant. Your Lordship would recall this is the matter wherein the address, this is for amendment of the cost title, wherein the address in the death certificate was different, the address in the will was different. Your Lordship was kind enough to handhold me through the niceties of the consequence of what would happen if the amendment was allowed. Your Lordship, I've obtained instructions with respect to this. What had happened is actually once the PLA was filed, certain discrepancies cropped up with respect to the objections from the department. The department says that since the address in the death certificate, last residing address.
Why you are getting so sweet?
No, Your Lordship, I'm so sorry.
Yes.
Since the permanent address of the deceased as at the time of death was the subsequent address that Your Lordship will find, which is 2-1 by C Aggressant so and so. So that would be essentially the address that should be enumerated in the cost title. Your Lordship had indicated what would be the consequences of the incongruity with respect to the. Yes, Your Lordship. I am told that, however, that this will would never be contested, but however, that is not my purview. Your Lordship would kindly just direct the department to cure the defects and call for a report in that case, Your Lordship.
You have to cure the defect.
Lordship, the department says that it will be the last address as recorded in the death certificate, which is the subsequent address. The address which I have adduced in the cost title, that is my address. That was the address where I was residing at the time of executing the will. My Aadhaar card and other ancillary documents also espouse that address. Your Lordship, this is what the difficulty is, Your Lordship.
But death certificate is other address.
Death certificate is other address.
So you made amendment in the cost title.
Your Lordship, that is what this application is for.
Where is the proposed amendment?
I beg you. Your Lordship, it is page number 10 of Your Lordship.
See,
yes,
you kindly come to the page 10.
Yes, Your Lordship.
You stated that 65 Chintamani Day Road, so and so, so and so.
Yes,
correct. This is the address which is appearing in the will. As well as your all documents.
Other ancillary identification documents.
But now what you want, the 21C Argesen Street? you wanted to include because this address is mentioning in the death certificate. So the department telling that this is the death certificate is the last resident.
Last resident.
Correct. Now you wanted to this. Then on the last occasion, I also explained to you.
Yes, Your Lordship.
And again, it will be difficult for you.
Yes, Your
At the time of probate.
Probate.
Correct. You do one thing.
Yes, sir.
So this court is not an advisory jurisdiction. You let it be continued. The old orders may continue. You withdraw this. Let it be continue. You record lastly resided this address.
Yes, Your Lordship. Just that leave may be granted to me for the purposes of the department because upon
Not
scrutiny,
department. You withdraw this.
I will withdraw this and make a fresh application.
Fresh
Your Lordship.
application.
Of course. But with respect to the probate application, Your Lordship, the defects with respect to the department are that is what my instructions are.
What?
From my
What probate? Probate same thing. Nah?
Same issue. Yes,
So that's why you.
that's
if-
what we will do. Yes.
That's why if you come with an application,
Yes, sir.
then amendment will be carried out.
That's what we will do, Your Lordship.
So what do you want? What
Just
you will
we'll withdraw this application
take appropriate step.
and make appropriate applications for the
Concerns appearing for the petitioner. Petitioner has filed the present application being GA number 1 of 2024 for amendment in the probate application with regard to address of the testator, testatrix, testator,
testator.
testator,
I'm the sole
testator. Full stop. Counsel for the petitioner submitted there is some defects in the application and intend to withdraw the said application with the liberty to file afresh on the same self cause of action. Consider the submission made by the counsel for the petitioner. The petitioner given liberty to withdraw GA1 of 2024 to file afresh on the same cause of action. Accordingly, GA1 of 2024 is dismissed as withdrawn, liberty to file afresh.
Grateful to you.
Next, fixed matter, na?
Section 1130, item number 10, non-commercial.
Monitor.
Yes.
My lord, your lordship, on my application had passed an order of 1st October 2024.
Yes.
My lord, it appears that the respondent number one has also filed an application which was served on us yesterday, which is GA2 for vacating that interim order, my lord. My lord, if your lordship takes the interim order which has been passed.
Yes.
Well, there are no, from what I have seen, my lord, in this application for vacating which they have filed, it is only averments. There are no documents annexed. The only document which is annexed is my GA only. My lord, if your lordship takes the order. Mr. Mitro, learned senior counsel, is appearing for the plaintiff. The counsel for the plaintiff has filed the present application praying for an ad interim injunction. Plaintiff and defendant number 1 have entered into a lease deed on 29th November 1989 with respect to the entire ground floor of premises number 1, excluding the lawn, motor garage, the flat in occupation of One Security Service of India. The deed of lease entered into between the plaintiff and the defendant number 1 is for 51 years, which is valid till the month of November 2040. Counsel for the plaintiff submits that the deed of lease under clause 22, it is mentioned that during the continuation of the lease agreement, the lessor shall not transfer the said property or any portion thereof. Counsel for the plaintiff submits that on 9th April 2001, the defendant number 1 had issued a letter. This is very important, kindly note this. Counsel for the plaintiff submits that on 9th April 2001, the defendant number 1 has issued a letter informing the plaintiff that the defendant number was intending to sell the said property and has given the option to the plaintiff whether the plaintiff is interested to purchase the said property and to inform the defendant number 1 within 72 hours from the date of receipt of the letter, and if no representation is received from the plaintiff, it will be treated that the plaintiff is not interested to purchase the said property and the plaintiff has no objection to sell the property by the defendant number 1 to the third party. On receipt of the letter, On 9th letter dated 9th April 2001, the defendant number 1 has sent a reply to the to the plaintiff, informing that the plaintiff is eager to purchase the said property and has asked for certain clarifications from the defendant number 1. After receipt of the said letter of 9th April 2001, the defendant number 1 has not sent any clarification as required by the plaintiff. Subsequently, in the year 2007, the plaintiff had also published a notice for information of general public that if anybody will negotiate with the said property, it will be their own risk and cost. All of a sudden, in the month of September 2024, the plaintiff came to know that the defendant number 1 had executed a deed of conveyance in favor of the third party, that is the defendant number 2 and 3, and accordingly, the plaintiff has applied for certified copy of the deed of conveyance. On receipt of the certified copy of the deed of conveyance, the plaintiff came to know that the defendant number 1 sold the entire property to the defendant number 2 and 3 by way of a registered deed of conveyance. The counsel for the plaintiff submits that the deed of lease entered between the plaintiff and the defendant number 1, dated 29 November 1989, is still in existence, and as per the terms and conditions of the deed of lease, the defendant number 1 is not entitled to sell the said property. And on the earlier occasion when the defendant number 1 was intending to sell the said property, the defendant number 1 has informed the plaintiff, and accordingly, the plaintiff has requested the defendant number 1 to furnish the details so that the plaintiff can proceed to purchase the property, but the defendant number 1 has not given any reply to the said notice. Now, all of a sudden, without any notice to the plaintiff, the defendant number 1 has transferred said property by way of a deed of conveyance in favor of the defendant number 2 and 3. Counsel for the plaintiff submits that as the defendant number 2 and 3 had purchased the said property by way of a deed of conveyance dated 28 June 2024, the plaintiff apprehends that the defendant number 2 and 3 will further transfer said property to third party, and they will also disturb the possession of the plaintiff over the suit premises. Heard the counsel for the plaintiff peruse the materials on record, this court finds that the plaintiff and the defendant number 1 have entered into the deed of lease of 29th November 1989, and in the said deed, the details of the property have been described as the said property, and as per clause 22, it has been categorically mentioned that during the continuation of the lease agreement, the defendant number 1 shall not transfer the said property or any portion thereof. The lease deed entered into between the plaintiff and the defendant number 1 is valid till 2040, and the plaintiff is still in possession of the entire ground floor except the lawn measuring 7 kata, 6 chitaks, a garage, and a flat under the occupation of Security Service of India. It is also evident from the record that the defendant number 1 has entered into a deed of conveyance on 28 June 2024 in favor of defendant number 2 and 3 in respect of the entire property without the knowledge of the plaintiff. Considering the above, this court finds that the plaintiff has made out a prima facie case, balance of convenience and inconvenience in favor of the plaintiff. This court also finds that at this state, ad interim order is not granted, the plaintiff will suffer irreparable loss and injury. Accordingly, defendants, their men, agents, and assigns are restrained from taking steps or further steps or in any manner dealing with or disposing of the said property or any portion thereof till 27th November 2024. Plaintiff is directed to serve. So, my lord, your lordship will find it is duly recorded. My lord, I showed 9th April 2001, they had issued a letter that they want to sell. We replied back immediately saying we wanted certain clarifications. This is our plain case and details what we want. Now, my lord, their application for vacating, they say that because it was 72 hours within which you had to inform the price, a quote, because we did not do that, so that offer has lapsed, and they have complied with the obligation under clause 22. It is on that basis they are asking for vacating of the interim order. Yes. Lord, if leave may be given to my senior, my lord.
There are two issues, my lord, which are important. First is, my lord, kindly, my lord, your lordship has seen the clause, but I'll just bring it to your lordship's notice because this is the principal issue raised in the vacating application. Page 31.
I make it clear, I will not go by vacating application. I am a demand 2 and 3. I am not made in application. I shall go on the petition. No ground is made out. And court was, if I say respect, court has rather misled.
Well, page 31. Clause 20.
Who has filed GA2? I have filed GA2, my lord. Kindly permit me to appear online, my lord. I am the defendant number 1, the owner of the premises, prior to transferring the same by way of sale to my learned senior, Mr. Mitra's client, my lord, who's defendant number 2. So GA1 is my application, my lord. I am praying for vacating of it.
Yes.
Once Mr. Chaudhary completes, my lord, kindly comment.
They have made the application on ground separation.
My lord, he is the principal defendant. Now, my lord, please see, my lord, clause 22 at page 31.
Of J1.
Yes, my lord. Which is, my lord, the lease deed.
Page 22.
Yeah, 31, my lord, clause 22. And this is what your lordship, my lord,
Yes, that is.
noticed, my lord. The important part is that during the continuation of this lease agreement, the lessor here too of the one part shall not transfer. Now, my lord, is the important part. The said property or any portion thereof by way of super lease, lease out, letting out any person, etc., institution, company, etc., and obtain written consent from the lessee hereof to that respect. Now, important is shall not transfer and said property. Said property is also defined in the lease deed. It's not the demised portion, it's the entirety of the property, which your lordship, my lord, was pleased to appreciate at page 22. And this was, my lord, placed before your lordship. That whereas the lessor here too of the one part is the absolute and exclusive owner of a partly two-storied and partly three-storied built house, message land, tenement, drains, path, waterways, such and such, in the city of Calcutta, which for the sake of brevity shall be referred to hereinafter or as the said property.
Yes.
And the lessor here too of the one part is in exclusive possession, occupation of the entire first floor of the said property.
Yes.
So, my lord, said property is the whole.
Yes.
Next, my lord, in this principal ground taken in vacating application, that this is only demised portion.
Yes.
Now, my lord, please see how the parties understood, my lord, this clause. There are three other clauses which are really ancillary. This is the main important clause. Now, my lord, please come to page 41. 9th April 2001 is to place on record an information.
Page
41, my lord.
Yes. Yes.
This is to place on record an information that after obtaining probate of the will of Shamshul Haq, his daughter, Dr. Mrs. Husna Bano, became the absolute owner of the land and building bearing such and such, wherein you are in occupation of some portion and under your possession. It has been decided that Dr. Mrs. Husna Banu, your present landlady, decided to dispose of the property at a present market value, and the interested person who will give highest offer. In the aforesaid reason, I, on behalf of my wife, as her constituted attorney, offering you to purchase the property and offer me the price.
Yes.
If the price given by you is the highest price, in that event, I shall register the property in your favor. Be it noted herein that the transaction should be on as is where is basis. Further, if I do not hear from you within 72 hours from the date of receipt, I shall take it into consideration that you are not interested to purchase the property, and also you have no objection in the matter if I sell the property to any third party. 3 points, my lord, of very crucial importance. First, my lord, the date of the letter, 9th April 2001.
Yes.
We are in 2024. This is 23 years ago. After which, my lord, they did not sell, they continued. And matters can't be the same today.
Yes.
So it's not, my lord, correct to now contend after 23 years that, look, I had given you an offer 23 years earlier and the price wasn't matched or something. That's, my lord, not proper. Today, if you want to sell, you have to give me an offer. Second, the clause says that you have to give me a right to purchase at market value, etc. Because he has to tell me what is the price and I have to agree or not agree. That's, my lord, very preliminary.
Yes.
There can't be an offer without a price. Otherwise, it's really no intimation.
Yes.
This letter does not contain a price.
Yes.
Does not contain the terms. Does not contain what is the market value. Now, my lord, please see what my response is at page 42. we are in receipt of your letter dated 9th April 2001 on 16th April 2001. We are eager to exercise our right to acquire premises number 1, Victoria Terrace, which according to you will be sold on as is where is basis. So, my lord, we express our, my lord, interest. In order to enable us to make a concrete offer, please furnish the following details, and we ask for, my lord, the details. What is litigation, etc., requisition? This is it. As so on hearing from you, we shall revert back to you. So, my lord, two things can happen. A is you can tell me this is my price, etc. These are the details, or you can tell me I'm not going to give you the details. This is the price.
Yes.
Either of the two can happen. Nothing happens. You know, they back off completely.
So they have not given any reply.
Nothing, no response.
Yes.
No response. After 23 years, we, my lord, are to be on a clean and fresh slate. They are not, my lord, accordingly entitled to sell. This is my short case. This is what we had placed before your lordship. Now, the intention of the parties that I would have primacy as regards the right in respect of the property is also clear from 3 further clauses, 8, 10 and 18. May I just quickly bring those to your lordship's, my lord, notice. My lord, the intention, my lord, would be very clear. My lord, kindly see, my lord, page 27. 8 is at page 27.
Yes.
This is about the lawn.
Yes.
It says that if you raise construction on the lawn, you will have to sell me the constructed area in case you give me first right of offer. Miller, I'll just read it for your lordship. That the adjacent lawn, which is about 7 katas, 6 titaks, being the same, more or less, shall absolutely belong to the lessor, and the lessee shall have no right and or claim to raise any objection and or cause to create any obstruction in respect of any future construction on the said lawn. But in the event of any such construction on the said adjacent lawn, the lessee should be informed or offered if the lessor wants to transfer the same by way of letting it out or leasing or by way of sale. So you can't even lease out without offering me first. So that shows the intention. This is lawn. Next, my lord, is clause 10 on the next page. Lessor undertakes not to transfer the demise property. That's, my lord, my portion.
Yes.
Or any portion without offering the same to the lessee by way of gift or inheritance or otherwise by way of gift or inheritance. So no transfer of demise portion. Then, my lord, 18. I won't object to development of a multi-storied building only if it's, my lord, mutual consent, etc. So, my lord, concreting my rights in every way in respect of the property. And then, my lord, clause 22, which I placed earlier.
Yeah.
My lord, so, my lord, I'll quickly, my lord, summarize. Quickly, my lord, summarize. Number 1, intention of the parties in the year 1989 was to give me lease for, my lord, the entire ground floor except, my lord, lawn, etc., etc. Intention of the parties was that if the lessor, Mr. Thakkar's client, wants to, my lord, sell, he has to give me right of first offer. Number 2, if he wants to construct on the lawn, he can do so, but he can't let it out or sell without giving me. Number 3, there's another blanket clause restraining him. My lord, 4 clauses, my lord, all clearly establish, my lord, my rights. And this was their understanding, which is why 2001 he gave me notice. I expressed interest. He, my lord, didn't name a price. I asked him for details to name the price. He didn't give me the details. Parties continued. My lord, that fell through. Parties continued. Then, my lord, 23 years later, now, my lord, you can't act in breach of the terms of the document. My lord, these are my submissions.
May I?
Yes.
That, for 2 and 3. Well, my submission is, this petition or plaint discloses no ground for any
defend
cause
number
of
2 and
action.
3.
2 and 3. Who have the purchaser
Yes.
of the property. There is no basis in the plaint or petition. Now, my lord, learned friend has argued that there is no response to the letter at page 42. And from what? So, what follows from that, he has not said clearly. But my lord, see, kindly letter at page 42, does it call for a response? Please see page 41, our letter.
Correct.
That as by sale will be as is, where is basis. Last time, if you don't hear from me within 70 hours, 72 hours, then we shall not. When the response came within 72 hours, no. Response came on date is 19th April. So letter is useless letter. This part has not been pointed out to your lordship.
Yes.
So what response I gave? It's not a response at all. Second part.
Yes.
Second part. Kindly come to page 42. Later we shall show it is only time killing. There is no intention to buy the property.
Yes.
I shall show you why it is so. Because it is noted, see the past paragraph, the property will be sold on as is where is basis. When it's sold as is where is basis, now are these things, any of these questions arise?
Okay.
Please, my lord, area of land. They know there's lessee, DW said. Construction built up area, they are lessee, they are living there, they're occupying.
Yes.
Extent of on it, as this what is basis I've said, for that they want 12 inquiries just to kill time. Name of tenants, etc. That you find out as is what is basis. Present and will, in case of proposed sale of a property on as is what is basis. Now, which is more important, my lord. This is a suit supposed for preemption. According to them, right is created by the deed of lease. Preemption right is created normally by statute, except in Mohammedan law for Mohammedan. That is similar to what is the case. Their case is a contractual preemption right. Similar petition paragraph 4. Your own petition paragraph 4. What is their case? Paragraph 4. Right of preemption, right to purchase what? What is the right of purchase? Paragraph 4. This is in the plain same thing. Plain is same thing. Same paragraph, plain also. The parties with a lease covenanted as the plaintiff or the petitioner has the first right to purchase what? The demised premises, not the said property. Not the said property.
Yes.
That is the case in the petition and plaint also. There is a right of preemption. Right of preemption.
Yes.
If it is not a right of preemption, then it doesn't run with the covenant, run with the land, doesn't matter. Preemption also doesn't matter. The relevant clauses similar to this. First, they purchase the demised premises. Demised premises mean the area covered by lease. Now, property is 16 cutters of land, 7 cutters long, and there is a building, 3-storied building. He is a lessee of the ground floor only. And now he is claiming a right to buy the entire property. He admitted position, similar to annexure A to the petition.
Yes.
That will show what is the leasehold area. Page 20. 27, no? Page 17, sorry, page 17. Page 17. 3. This is what the schedule of demised property. Demised property. Not any all that piece and parcel hereditament premises lying on the ground floor of the premises. 7 except the lawn, that is not part. Be the same little more or less. Garage under occupation, that's also excluded. Garage is excluded. Flat under tenancy, security service, that's excluded. Territorial limits, and ward number 3, etc. This is not only the leasehold ground floor premises, not entire ground floor. Ground floor is excluding a flat and etc. A portion of the ground floor. Now he is coming a right of preemption of the entire property.
Yes.
This is Miller trick. Now, Miller, please come back to the paragraph 4. And after that, how can this right? The case is I am right to purchase demise premises, and they ask for injunction against entire sale of the entire property. It's contradictory.
What is the suit for?
Hello?
What is the suit for?
Page 4. Can you see?
Suit. What is the prayer in
Suit
the
for
suit?
preemption. Suit for prayers. Can you see prayers are set out in the petition also? Suit for preemption. Right of preemption.
Page 9, man.
Page 9. Prayers are set out. Thank you. Page 9. Declaration the sale deed is null and void. I am saying that there is no cause of action for this. It is settled law that after the sale takes place wrongfully, even assuming he has the right of preemption, holder of right of preemption has no right to get the sale already effected in violation of preemption, I'm assuming, to right to say declare it void. They have no right. Their only right is substitution. They cannot can you say clear? Prayer C sale and null and void. That is by this document we have purchased the property. Now I'm going to contrast this with the prayer B.
Mandatory injunction.
And injunct defendant number 1 to execute a conveyance, it's entire said property, plenty, but same consideration. Very good. C, Miller C. Mandatory injunction directing defendant number 2 and 3 to execute deed of conveyance. Right? If sale deed is void, then how can I be asked to convey the said property to them? Contradictory prayer. Sale deed is void, main prayer. And then here is a prayer asking me to execute a deed of conveyance.
Yes.
Who personally has no title. And the prayer D, execute a conveyance. Where you will execute a conveyance? That is event number 1. We shall see which one will prevail. If event number 1.
Yes.
Sir, show annexure C, which is the entire.
Now, see, my lord, all mandate injunct directly in event number 2 and 3 execute deed of conveyance. This guy in schedule C, annexure C, my lord, entire property. This prayer B also entire property, annexure C. Although their case is, the right to purchase is confined to leasehold area only.
No, but kindly come to this lease deed.
Lease deed, kindly come to lease deed. And in this paragraph, all the clauses have been set out.
Page 22.
Yes, clauses have been set out. Well, I'm reading for the
Lesser
clause.
here
Yes.
to one
Why
part.
is the right to buy the entire property? 3 minutes. I am obliged to lordship 22. Here refer to said property.
Said property.
That means entire property. 16 cutters of land with a lawn, three-story building. Now, what is their right? They rely on 3 clauses which are for convenience set out in paragraph 4. Please come back to paragraph 4 at page 3 of the petition. The clauses set out. Read the clauses. And similar how court was not taken into confidence. Firstly, that the adjacent loan, if we construct on the loan, but in the event, these 4 lines, they have no right to inspect of loan. But in the event, any construction on the said loan, lessee should be informed and or offered if the lessor want to transfer the same by letting out the lease or leasing. Similar, if somebody buys the loan, make a residential house there, no right.
Yes.
Only is this conveyance is not for construction on the adjacent lawn.
Correct.
Clause 8 has no application. Now, clause 10 now similar. That the lessor hereby undertakes not to transfer the said demise property, not the said property. Clause 10 confined to demise property. Page 4, Miller, of the petition of the find. Clause 10. All that the lessor hereby undertake not to transfer the said demise property. What is Miller? Page 4, or running page I don't have.
Page 4.
Page of the petition.
Yes, page 4.
Clause you got him, Miller. Clause 10 is said, or next clause rely upon. That the lessor hereby undertakes not to transfer what? Demise property. Now they are asking injunction against Schedule C property, Annex C property, said property. Said property, the entire property.
Yes.
So no that transfer without first offering the same to the lessee.
Yes.
Yes. Now, clause 22, my lord, was late to rely upon. See, my lord, how lordship means that during the continuation of this lease agreement, here to one part, the party shall not transfer. This has been emphasized very emphatically. But transfer what? Transfer by way of super lease. Similar, not every transfer or any portion thereof, by way of super lease, lease out, and the letting out. Sale is not covered by this.
Shall not transfer the said property
By way of that portion they're omitting.
said property or any portion
Transfer said
thereof.
property or any portion thereof. Correct. By what transfer a particular mode by your lease, super lease, lease. That part, Milord, has not been highlighted to your lordship. And it is not pointed out to your lordship that this is not a transfer by your super lease or lease or letting out.
Yes.
Now, Milord, it is transfer. This clause 22. See, Milord. Yes. No restriction on outright sale. Sale and super lease are different. Is section 54 sale, section 105 of transfer property act lease. These, yeah.
Yes.
Secondly, Milord.
Yes.
They have clause 22. Do not say that if it's sold without written consent, then this lessee will have a right to buy the entire property. Why is that clause? Why is the right to buy the entire property? Why is that clause? Lease do not say that they have a right to purchase the property, said property. See? See? Very carefully read it, Milord.
Yes.
Now, Lordship, at the time of moving the application, passing the order, my lord, attention was not drawn to the fact that clause 22 gives them no right to buy the property.
Yes. Yes.
Now, what is the consequence of selling? Selling is not covered. But suppose I give a super lease. Suppose I give a super lease
then it
without consent, then what is the effect of that? Super lease void. That is not said. Will be voidable. That is often nothing said. Do so.
Yes.
It's a breach on the part of the lessor, your lessor. You have claimed for damages. Why is the right to go down after the property?
Yes.
Similar, this case does not disclose any cause of action or ground. The next point, Lordship, can you see, my lord? What they're asking for? Specific enforcement of 3 clauses in the lease, leaving out other clauses. Very good. And the pleading is I've got negative covenant. It is a negative clause.
Negative.
Now, when negative clauses can be implemented? Section 42 can be similar or specifically fact.
Give the specific
Section 42. There is judgment on this, very clear judgment, I think, undisputable, which has been thoroughly established by judgment aided and assisted by Mr. Jishu Rai Chaudhuri, very ably assisted that court. Section 42, my lord. Kindly see the injunction. We get Section 42. Kindly see 42. The proviso is to be very important. Notwithstanding anything contained in clause A, E2, section 42(1), where the contract comprises an affirmative agreement to do a certain act, contract of lease affirmative to do something, pay the rent, etc. With a negative agreement, express or implied, not to do a certain thing, certain act, the circumstances that the court is unable to compel basic performance of the affirmative agreement shall not preclude it from granting an injunction to perform the negative agreement, but provided that the plaintiff has not failed to perform the contract so it's binding on him. So one cannot say I have not performed clauses for all other clauses, but I want negative agreement clause to MC. Why is the affirmment in the petition that they have not failed to perform their obligations and the other clauses of the lease?
Yes.
Similar. I'll show you the paragraph where they pleaded that. Paragraph 13 of the petition, kindly see. In the tongue-in-cheek affirmment, paragraph 13, they have pleaded.
Yes. Ready and willing.
What the? 13.
Page 7.
Yes, yes. Huh? It does. At material times, petitioner has been and still is ready and willing to perform the terms of the lease deed. And more particularly exercise the right of preemption. Has performed all the obligations, how do I find it? But has performed, so but now let's see their own petition. What they have not performed. They have not paid rent since 1994. See the petition. Was it drawn to my lord's attention? Please, my lord, come to paragraph 6 of the petition. I'm going by the petition, same as plain. Paragraph 6. Plaintiff at material times has paid rent month by month in terms of deed of lease to the defendant respondent. But defendant respondent, since around 1994, has failed and neglected and refused to accept the same. What evidence? What evidence? Prima facie evidence, now petition. Since 1994, rent is not paid. Now the case is refused to accept. Very good. Then did they deposit? No. The payment has been made similar by your money orders to the defendant at the permanent residence, being the said premises. Misstatement. Permanent residence is not the said premises, Victoria Terrace. Can you look at the cost title? Can you look at the cost title? Number 1 defendant. Hasna Bano, alias Sancha, residing at number 38 Avenue, Kenton, London. How they are misleading the court? Can you see below? Very good. Permanent address, being the said premises, is incorrect statement. Money orders have been returned month by month by the postal authority upon defendant. Not a piece of evidence on this. Not a piece of documentary evidence. Money orders come back. And not accepting same. The last of such rent payment was made for the month of August, which has also been returned. A copy of the money order received 17 August annex. This is the only evidence given again in August. That is at page 38. Kindly come to page 38 the petition. Where they send the money orders? At the residence where the defendant resides, or at the place where the defendant never has not been visiting or seeing for the last 20 years. Page 38. This is the document they have given.
Yes.
This is the track consignment. Now, my lord, see, my lord, item number 4, item returned. This item was returned. Addressee left without instruction. They're all in Bhavanipur post office. Addressee left without instruction.
Yes, sir.
This is their own case. Now, my lord, where is the address? What address it was sent? That my lord, page 39, difficult to read. Sent at the address of number 1, Victoria. Go to at page 37. Can we come to page 37, Milton? Yes, by page 37.
Circus Avenue.
Victor.
Victor.
So, see, Milton. This is, if they send money order at a place, who is the defendant left long time back, will have tender of rent. 1994. Since 1994, rent has not paid. So a party who has not performed his fundamental obligation of payment of rent under lease cannot rely on any negative clause in the lease, if at all.
Yes.
The second point.
How much time will take, Mr. Mithuna? Because I have
That's
other...
why, let us, the other matter fixed.
Yes, fixed matter is there.
At 2 p.m. No, fixed.
2 p.m. today already fixed. Tomorrow, right? 3:40 आज तो है ना?
তারপরেও এটা লাগিয়েছে নিজেরাই প্লেনটা বলেছে গোর্কি টেরেস
Yes.
Lord, I was requesting my lord before on the next day before Mr. Mitra starts, give me 2. Give me 2 minutes back. I couldn't. I was stuck somewhere. She gave me 2 minutes before Mr. Mitra resumes his argument. Allow me 2 minutes. That's all.
That you can have right now. That 2 minutes you can have right now.
Yes, I can do it just now, my lord. Give me 2 minutes.
उस लोग आएगा तो अगर विटनेस चलेगा तो
There's so many things to say, but there's no cause of action. Manify this.
I can do the 2 minutes now also, Lordship. As Mr. Mitra. Oh, Lordship, whichever day, Lordship. Tomorrow, Lordship takes up commercial matters.
Tomorrow commercial matter.
So Monday, Lordship, keep it Monday.
Wednesday. Wednesday देखो 12 बजे है.
And this expert injunction, again, entire property
12
injunction.
बजे.
Now, Lord, see me, Lord.
क्या? 12 बजे क्या?
One thing.
12 बजे.
This party was offered to buy the property. He did not offer any money. Now, Lord, after getting...
They will say you are also not offered the money in the...
They will say, they wrongly say, because no question, I invited offer. Market. Anyway, I'll come into that question. But they have got injunction. After getting knowledge of this conveyance, have they offered to buy at this conveyance price? No. There's not single letter of abandonment. There's no right of preemption.
So offering for the plaintiff. So offering for the defendant number 1 and so offering for the defendant number 2 and 3. Counsel for the plaintiff has argued at length and concluded his argument in connection with GA1 of 2024. Counsel for the defendant number 1 has argued at length, but due to paucity of time, hearing could not be completed. Fixed the matter on 4th of December 2024 at 12 noon as part heard.
And the interim order to
interim order.
Well, we might continue interim order after hearing this.
I will dispose of, let it be till
They're skipping him on Wednesday, Monday.
4th at 12 noon.
It
Is convenient to you?
I'll make myself available.
4th.
It will be urgent matter for my client.
I will 4th at 12.
My lord, it's defendant number 2, my lord. The lordship said defendant number 1, Mr. Mitra Senior
At any
appeared
fixed hour, my lord. At any fixed hour.
Bordership.
Defendant number
Very good.
You are for the defendant number 1, na? Mr.
I am for 1. Yes, I am for 1, my lord. Mr. Mitra appeared for defendant number 2.
Defendant number 1. Yes. His application gone to suppression, vacating.
The vacating application is separate.
My lord, kindly grant us leave to short serve. We have a demurrer application in this for Mr.
Mitra. Completed you, sir. What is the necessity of...
My lord, I need a leave. Otherwise, I can't, my lord, get it listed with
you. Granted.
Grateful to your lordship.
Yes, call the fixed matter. Yes, sir.
Wait, please, Your Lordship, my lord.
Yes.
Lords, before I really go into a direct rejoinder,
Yes.
there is an aspect which I would like to highlight and then build on that. Lord, according to us, the pivotal point of this case, the fundamental point of this case, is the arbitrator's failure to decide the primary and mainly the only question referred to him, which was who had committed breach of the original contract of 22nd February 2022. All other matters are absolutely subsidiary. Now, my lords, I find there that the reply is reasonably perfunctory on that point and goes into far greater detail on the other subsidiary aspects. So, my lords, I would request your lordships, give me about 15 minutes to just recap the position, and not more than that, because, my lord, my thrust is going to be that that point alone is totally adequate to vitiate the award.
Yes, you are on that point only.
Yes, yes. But, my lord, the background, 15 minutes, if your lordship,
No problem,
because of the amount of time. That's why. My lord, just let us go back to how this dispute started. Very, very quickly, and not reading anything except one document. My lord, there is the contract is 22nd February 2022 for the sale of 10,000 metric tons of coke by Orissa Metallics to Neo Metallics. A deposit of 4.49 crores is made at that time. Then, my lord, in the month of April, there is a lot of correspondence regarding the form of the LC, and which term ends on 14th April by Orissa Metallics returning our deposit of 4.49 crores. And they later on saying that they took our failure to establish an LC as a repudiatory breach, which they had accepted, and they terminated the contract and refunded the money. On the 25th of April, Neo, my lord, files a suit. And in the suit, the relief claimed is for specific delivery of the goods. So, my lord, at that point, the issue was that was Orissa Metallics justified in saying that the contract had come to an end on 14th April? Or was Neo entitled to enforce that contract by seeking delivery on 21st April, on the date when the ship came in over here? Now, on the 25th of April, Neo also got a status quo interim order. On the 27th of April, that matter was carried in appeal by Orissa Metallics. And in that, my lord, comes this order of 28th. I'll come to that, but I just want to summarize because I feel that is the fulcrum issue.
Correct.
My lord, the first thing is that parties were referred to arbitration. Now, it must follow that what was referred to arbitration was the dispute in the suit. There was no other dispute in the suit, which really was who was entitled to enforce, who was not entitled. Where the pitch got slightly queried is the court, while doing so, also worked out by the consent of parties a pro tem modality, not for deciding the rights of parties, but for going ahead with the payment and delivery of the goods. So it was provided that by a certain time, a new LC would be opened, the money would be paid back, and within a certain time thereafter, they would encash the LC and thereafter deliver the goods. Now, my lords, Orissa, in fact, told the court that, hang on, I am being asked by this working order to deliver the goods at the contract price. Whereas according to us, we are not liable to deliver at all. And the contract price on 21st April or 25th April was substantially less than the market price. And therefore, I would suffer a loss. Neo said that, no, but if I succeed in the suit, you're bound to deliver to me. And therefore, there's no question of any loss. So the rival contentions at that stage were on this part. Consequently, the court said that, all right, you give a bank guarantee of 5 crores. In case you lose and you're liable to compensate Orissa for having to deliver the goods to you at contract price. And you provide, both parties provide, that whoever succeeds in the award will pay interest at 18% per annum. Now, signally, the obligations to give a bank guarantee and undertaking were expressly made without prejudice to the rights and contentions of parties. Now, my lord, why is this very important? Because I pause. This is the one area. I'm not reading it because your lordship has read it. My lord, the latter part, the primary reference could at that stage have only been about who had committed breach of the contract of 22nd February, who was bound to deliver or not, and who was bound to pay what damages or not. So everything focused only on that. The second part was a pro tem arrangement, and that was really without prejudice to the rights of parties which would be determined in the arbitration. Therefore, my lord, I want to stress this point. No substantive rights of the parties under the contract were affected in any way by that working arrangement. And that is crucial to understand. It is not as if the matter was settled by that working arrangement. I'll tell you, lordship.
By the court.
By the court, but by a consent order.
Consent order.
So, my lord, I'll tell you, lordship, why. Because if that was so, then there was nothing to refer. If the parties had resolved matters as per that order, that you open the LC, you pay the money back, I'll pay the goods to you, then the matter, if that was an end, there was now no dispute left to resolve. Therefore, this was not in any way affecting the substantive rights.
Which is in the contract.
Which is in the contract. It was only a modality for dealing with the delivery and payment subject to the rights which would be decided in the arbitration. That is crucial because, well, there.
So as per your submission, whatever the order passed, though parties have accepted that, so that is only a modality.
Of course, so without prejudice modality.
And that cannot be clubbed into as a condition precedent of the contract.
Or any variation of the contract. The contract was to be determined.
So this cannot be read as in terms of the contract.
Right. In any way affecting the contract or the substantive rights of the parties. It was a pro tem arrangement by which the delivery and payment was to be resolved subject to the adjudication finally in the arbitration as to the rights of the parties. That's the way it went.
Okay.
Now, my lords, once that was done, that order, the working part order, could not be implemented. I'm right now not going into who is responsible or not, but the LC could not be agreed upon, the payment could not be made. The matter went back to the court and an order of 20th of May is made. That order of 20th May extended the date, provided further payments, how LC was
further modality.
Yeah, I'm not at the moment, it altered the modality further.
Correct.
Even that could not be finally implemented. So the modality part was rendered infructuous. The matter went to arbitration. In the arbitration, my lord, the claim by both the parties was essentially on who was responsible for fulfillment of obligations under 22nd February 2022, who had committed breach, the original contract, etc. For example, my lord, your lordship will see yes. In the statement of claim, my lord, the basic point urged by Neo was that you are liable to give delivery to us on 21st April, on the date the ship came in.
Reached.
And on that date, the price was substantially higher. Your failure to deliver the goods made you liable to pay me about 10.5 crores as damages for that. I must tell your lordship that even Neo added a subsidiary quantum of claim, not relating to breach of any order, but relating to what it claimed was the monetary loss it had suffered by implementing the working order. In other words, the LC charges, the bank guarantee charges, the interest on the deposit which never came back, and that added up to about 14 crores. So the fundamental claim was the breach of the 22nd February 2022 order.
Correct.
Now, in the statement of defense, Orissa, my lord, went on two aspects. First, they said that Neo had committed breach, that they had terminated the contract, and therefore they were not liable to deliver at all. And since that was so, any attempt by Neo to keep the goods blocked, in that sense by the injunction, was resulting in a loss to them.
The business.
And therefore they said that they took it on the 25th of April, where the injunction had come. And they said on that date, the price was
So
X.
much.
I was forced to deliver to you at contract. Therefore, the difference between the two is a loss that I should suffer. They also said further that by virtue of the injunction of the court, they were not able to deal with the property till 14th of June 2022. And they therefore said that the date for quantification of loss would actually go to the 14th of June, when we were freed and what we sold at and what was the contract price or the market price. So that was the broad heads of claim. Now, my lords, what is interesting is, and if I may request your lordship now to look at the award for a moment, because this is where now the matter becomes it's in volume, it's at page 743, volume 4, I believe.
Volume 4 to?
Right? Volume 5.
Petition से उससे दे
743. It's part of the award, in the middle of the award.
7.
No, sorry, just a minute.
5, volume 5.
Volume, yeah, but I want volume, no, volume 6.
6. Yes.
And in that, at page, they set out what were the arguments advanced by parties before that. So if your lordship looks at para 19, page 743, sorry, my lord, it will be in 5, my apologies. Para 19. Just 5-10 minutes more to focus the matter, that's all, my lord. So para 19, claimant changed the stance, filed written notes of arguments. The first, my lord, is that contract is dated 22nd February, and then it goes on to 2, 3, that they repudiated obligations under the contract.
Yes.
And that is up to 4. Now, in 4, it says parties agreed on a modality, and the appeal was disposed of on the basis thereof by an order of 20th April, did not comply, etc. The next point was breach of the agreement in capital C dated 20th February and non-compliance of orders dated 20th April. In the course of hearing, it appears to be an important issue for the claimant to establish that the respondent was in breach of the agreement and did not comply or acted contrary to the orders. Then, my lord, the agreement is set out in paragraph C7, fully set out. And then, my lord, your lordship will go on to 753. That's in the next. Well, unfortunately, these volumes.
No problem, no problem. Yes, 753.
So, my lord, in F.
Waivers.
Yes, waivers. Only the last order is 20 and the above. Now, mark capital G on the next page. Without prejudice to the above, only breach under agreement of 22nd February is relevant. The subsequent orders only record an understanding qua modality of working out an arrangement while sending parties to arbitration for adjudication. This is crucial. That was the case which we argued. And then, if your lordship goes to the respondent's arguments, which are noted at 761. The first issue, first they go through the facts of the case, and then paragraph 766, paragraph 3A.
Yes.
This is what the defendant said.
Yes.
The first issue which is required to be adjudicated in the present proceeding is to determine and ascertain page 765, paragraph 3A of the defendant's notes as quoted in the award. The first issue which is required to be adjudicated in the present proceeding is to determine and or ascertain who had committed breach of the agreement of 22nd February 2022. And mark this, and whether the agreement stood amended by the aforesaid consent orders of April and May.
Yes.
So that's the first issue.
Yes.
Regarding the contract. And then the second issue, which is at page 769, subclause B, page 769, the second issue which is required to be adjudicated in the present case is to determine which party has committed breach of the two consent orders of 20th April and 20th May and the consequence of such breach. So the first was the contract,
yes,
and they added a point about who was liable for breach of the orders and what is the consequence.
Correct.
Now, to this, my lord, a supplementary note was tendered, which is at page 773 by the claimant, by Neo. 772. Paragraph 21.
Yes.
It is submitted that the orders dated 20th April and 20th May are not relevant for the purpose of the present arbitration proceedings. By the order of 20th April, all disputes have been referred to arbitration. At that stage, all disputes meant claims on account of damages of either party and specific performance of contract dated February 22nd, 2022. Then, my lord, paragraph C, the orders dated 20th April and 20th May do not have the effect of modifying the agreement of the parties. It is also not the case of the respondent that by the orders of 20th April and 20th May, the agreement between the parties of 22nd February has been modified or altered or novated. The direction in the order of appointment of the Honorable Tribunal Court on 20th April specifically says all disputes of the parties are referred to arbitration. So the contract of February 22nd and the rights and obligations thereunder and its breach were all referred to arbitration. Submission of counsel for the respondent that breach under the agreement was waived is especially incorrect. The orders dated 20th April and 20th May are merely for the purpose of working out an agreed modality breach of the orders was first complained of. No, sorry, there's a page. No, was
first complained
of in a contempt petition. Then a rule was issued. So and so contempt is still pending. Respondent is so and so orders are to be done. What is relevant for the purpose of this decision in this case is breach of the contract. Was the claimant in breach on 14th April or was the respondent's repudiation correct? So that was the way it went.
Correct.
Now that was the pleadings, that was the arguments. Now the arbitrator fixed 3 issues at I think 7:32. Yes, 7:33. So the first issue he framed, whether there was breach of the terms of the contract dated 22nd February, admittedly executed, and who has committed the breach. The second he framed was on the terms of the consent order being breached and by whom. And the third, whether the terms of the consent order of 20th May has been breached and by whom. Now, my lord, just one. Then, if your lordship goes to 777, volume 6, the last volume.
Yes.
Starting from paragraph 22. Now see how the award turns matters on its head. The first question that arises for determination in these proceedings, it is what is the effect of the 2 consent orders passed in the appeal before Honorable High Court. Now, your lordship will note that both the statement of claim and the statement of defense had said that the first question is the breach of the agreement of 22nd. Both parties went.
Correct.
It is true that in addition, they had also argued as a second point, breach of the orders. But the and the reference, my lord, your lordship will bear in mind, could only be of the breach of the contract because on 27th April, there was no other dispute. It was the only dispute. The arbitrator now turns the matter on its head, doesn't talk of issue number 1 first, and says, what is the effect of this order on the contract? And after going through a whole lot of judgments on section 62 and 63 of the Contract Act, which go on right till page 782, at para 26 says, by applying the principles laid down in the above decision, the tribunal holds that the effect of the 2 consent orders before the High Court is that the seller, by accepting the advance price over again, and the purchaser, by again tendering the advance price which was earlier returned by it, both agreed to extend the period of performance with the further condition that in the process, that if the value of the goods falls in the market and the seller succeed in the long run, the purchaser will be bound to compensate the seller for the loss suffered by the seller due to fall of price because of the fact that by the injunction order, the seller was restrained from selling the goods to a third party at a higher market rate. Now, first of all, my lord, on 28th April, there was no continuing injunction. It was supposed to be all in 6 days. 3 days to pay back the money, open the LC, 3 days later get payment and put it. It is because that did not work out that the further extension of 20th May took place. So, thus the fact that the added amount and the security clause were added would not amount to superseding the original contract, as these relate to payment under the original contract and put the promisee in the same position as if the contract had been originally performed. So what the arbitrator seems to say is that yes, there was a modification in the contract as to its performance and the time was extended, but the bank guarantee and the undertaking would provide that if you succeeded in your dispute on the main contract, you would by virtue of these be put in the same position you were as if the contract had been dealt with without that.
Correct.
Therefore, now mark 27. Therefore, the date of performance of the contract had been...
Paragraph 26.
Yes, my lord.
That the tribunal further finds that the original agreement was not
so. But this is a contradiction in terms, because let's just test it, because my lord, we get used to legalese. There is a contract. The contract says that the delivery was to be made on 21st April 2022.
Correct.
By virtue of the working arrangement, it was possible to have the delivery even on, say, 3rd of May.
Correct.
And later on extended. But neither of those extensions affected the substantive obligation to deliver on that date.
Contract, yes.
The working arrangement was only to provide how to work out modalities while that point was being decided there. The arbitrator says that this modified the contract. Now, how can it modify the contract if it's without prejudice to the rights of parties and if it's all pro tem and a working modality? So this is a contradiction in terms. And look at what the consequence of this finding is, the next two paras, because this is where the germ keeps in. Therefore, the date of performance of the original contract has been extended by consent of parties through the consent orders. So it's as if 21st April now no longer mattered. It now goes to the date of performance is June. That's not anyone's case. The contract remains the contract. This modality resulted in them being required to delay the delivery till for a period of time.
Yes.
That can only make a difference on quantification. So suppose, my lord, he holds tomorrow in the arbitrator that I have no case and they were not obliged to give it to me. Then by virtue of these modalities, he has been held back for this period. He will claim a difference of what he has suffered in terms of loss. But that is not to mean that the contract now provides a delivery on 14th. The contract remains the contract of 21st April. Now he takes the view, look at para 27.
If suppose,
yes,
okay,
yes,
if suppose, in terms of the order passed by the division bench,
yes,
if what the modality has been given by the court and parties have
fulfilled everything,
what would be the effect of
the effect would only be this, that I would get the goods at contract price, and whether I was entitled to so get will be decided in the arbitration. Let me just, this is a very important question. I think that's the heart of the matter.
That is
assuming, let's take it on
because the has taken a proper view that
I will say that it's not a possible view, not a proper view. Because, my lord, of course,
yes.
So, my lord, that's why I said that before I go to a rejoinder, I need to set the context right. And your lordship has put your lordship's thumb on this issue directly. What is let me just ask myself a question. Forget 20th May for a moment.
Correct.
Let's go to 28th April. Two things happen, a reference to arbitration and a working modality.
Correct.
Now, assuming, as your lordship had said, that the working modality had completed. In other words, I had opened the LC,
paid, and all this,
and he had given me the goods at contract price. What would have happened? The claim was not over. The issue of whether I was entitled to get it at contract price was a matter which the arbitrator would decide. In other words, let me test it. Suppose the arbitrator had held that I was at fault and I was not entitled to claim delivery of the goods, then clearly I was not entitled to get those goods at contract price, and I would end up paying the difference between what was the price at which was in the market and the price at which I got it.
Correct.
So the fulfillment of the working modality does not affect the substantive rights of parties. it only provides for a pro tem arrangement. The substantive rights would be decided in the arbitration, and they would not be affected except in quantum. The quantum would change.
Yes, got it.
This is the crucial difference, my lord, because if you treat what the arbitrator said, the time for performance was extended, it would mean that on that date, if you performed, everything was over. But that is not the way it went. The fundamental error in this comes from that. And look at the consequence of the error on the next page. In the self-same way, the extended date was further extended by the second contract. Now look at the consequence of this finding. Therefore, the first two issues have lost significance. So he now takes
Contract gone.
The contract's gone. I don't need to go into that. But then what was the reference for? The reference was to determine the rights and parties under the contract. This modality only affected when you got it at what price practically, and then an adjustment on a determination of the damages. The arbitrator now says, I'm not deciding the first point.
So if it is go, then the first point is whether there was a breach of contract.
Of course. And both parties went to court on that. The SOC and the SOD both said the first point is who committed breach of 22nd February and what is the consequence in damages. The notes of argument also say that. The arbitrator now says that the only point which was really referred, which is the dispute between the parties, has now become irrelevant to decide because the contract has changed. Now, how could this is absurd? If what he's saying is right, then why was a reference made on 27th April? Because the rights had been extended. Parties would have performed that, might have not performed it. The reference on 27th April was to determine the rights and obligations of parties under the contract of 22nd February. Those rights were not affected by the working arrangement or the modality. That only resulted in a pro tem getting the goods and paying an amount subject to the rights being decided there. Otherwise, why was the bank guarantee there? Why was the undertaking there? If the contract was performed and everything was over. So, and this one point, now, my lord, just need a little further.
Yes.
Yes. Therefore, the first two issues framed by this tribunal have lost their significance after the passing of the second consent order and need not be decided in these proceedings. In place of those, issue number 3 framed who committed breach of 20th May is the only issue to be gone into. Now, we argued, and that is noted in para 29, that the consent orders recorded before the first court, before the High Court, do not amount to a variation of the agreement between the parties. And for the purpose of this arbitration, these two orders are to be ignored. Well, this is factually a little incorrect. They would become relevant on quantum. So once you decided the rights, how much would be payable if you were wrong would depend on what you had given the goods for at that price. So it is relevant on adjudication of quantum after adjudication of the rights of parties under the contract. Contends that the tribunal should decide this proceeding on the basis of the original contract as if the original contract is still subsisting, etc., etc. And then, my lord, at page para 29, page 17, para 32, page 787.
So your contention was in the original contract needs to be decided.
Yes, but my lord, it was the only dispute.
Well, that's why.
And that was the only thing he was to decide. The orders could affect the quantum of damages. My lord, let me ask myself a question. Suppose the modality orders were not there and I was to claim delivery and I had got a stay, simpliciter. Then if the tribunal came to a conclusion I was wrong, he would say you are not entitled to delivery, and since you have blocked his goods, you will pay damages for that cost in that sense. Since under the orders I was to get it at contract value, the consequence of deciding against me would be I would have to pay the difference between the date value on 21st April and the value of the contract. That's all. But nothing altered the contract in any way. To say, my lord, that it did would make a mockery of the fact that this was the bank guarantee and the interest was expressly without prejudice to the rights and contentions of parties in the arbitration.
Yes. Good. Next.
Now, therefore, my lord, let's see paragraph 32, page 787. Therefore, the effect of the first two consent orders passed by the court is that both the parties have decided to change a part of the contract by which the very sum due under the contract continued to be due and payable under the second order having been merged. The fact that the imposition of security by way of bank guarantee and legal costs were added would not amount in itself to superseding the contract, as those relate to payments under the original contract and put the promisee in the same position if the contract had been originally performed. This is the second part. The arbitrator seems to say, okay, it doesn't change your rights under the original contract. The bank guarantee is to provide for a quantum. And then how can he say that it's been changed? And therefore, I don't need to go into the first question. So this is the fundamental point. I'll tell your lordship why it becomes so important. Just 2 minutes just to follow it.
Yes.
If he doesn't decide who is at breach, the reference is not answered. The reference was only on that point.
Correct.
And there is even a Supreme Court decision in Dolphin Drilling which says when it means all disputes, it means all disputes existing on that date.
Contract only.
On that date, the only dispute was the contract. These orders had not even been worked out, not worked out, nothing. So to say that by virtue of those orders, the only dispute referred to you doesn't need to be decided. Now, why does it become so important? He then proceeds to decide who committed breach of 20th May. I'm just putting it in perspective. I'm not for the moment going why or not. And he holds that we were in breach of 20th May. Then he says that the damages will not be computed on the basis of the original contract, but on the basis of your non-compliance with these orders. So the question of damages would have had to be on 21st April 2022, who was in breach, and if so, who is to pay how much? That question he didn't answer because he said the contract is changed. And that I didn't decide. So without deciding the question of who was in breach, he then proceeds to award damages for breach of the order of 20th May. It's an absurdity. It's an incomprehensible award, my lord, frankly. The learned arbitrator, for various reasons, have completely lost the chart here.
Yes.
And my lord, now look what happens. He, from this page, that's 788, right up till, sorry, it goes on for a number of pages. Till
791.
Till 815. All this is about who committed breach of 20th May, and if so, what happens because of that. And then at 816, 54, capital A and B, 816, paragraph 54. I'm just giving your lordship the thread, because he should have said that award should rightly have been who committed breach of 22nd February, and on 21st April, what liability or damages goes to either of the parties. Instead of which, he now says at 54A, he notes this is a finding of fact. The market price on 25th April was so much. The contract price was so much. And therefore, damages are so much. Now, 25th April is nothing to do. It's the date of the injunction. It's nothing to do with who committed breach. And then overleaf at page, at page 817, E, as would appear from the documents marked, the market price of the goods on 14 June was 457 so and so. The respondent is therefore entitled to a difference between market price and contract price. By this time, the market price had dropped below contract price. So he says 21,98,000. Neither of these matters relate to the contract. The pity is that because of his finding that I don't need to decide about the breach of the contract, he relates the consequential damages not to the breach of the contract, but to what he claims the breach of the order. And that is the complete vitiating factor. So, my lord, the primary vitiating factor of this award is the arbitrator's view that he was not required to decide the dispute referred to him, which was the question of who committed breach of 22nd February and what happened. And everything else flows from that. Now, this is the whole award is a mix-up on that one point. Because once you say, I don't need to look at the contract and the contract has been altered, I don't award damages for breach of the contract. I award it for various other considerations, each of which are also wrong. But I'll show, but this is the vitiating factor. Now, my lords, this was the first argument we had made. My friend in his reply essentially said that it is not necessary for the arbitrator to decide all issues. And he cited two judgments. The Supreme Court in 2005. Now has the judgment. What is that? 54C. And the Calcutta. And Calcutta. Now, my lords, there is a view. I had in fact cited Sangyong. And my friend said what I've said was not the correct para. Look at the other para.
They were also right other para.
But now, my lord, there is fortunately a direct judgment of your lordship's court, which I would like to place. I know it's in rejoinder, but because it's helpful on this point. Sorry. Well, this was a case where the court found that the fundamental question referred had not been decided. The court said in such a case, the award was vitiated under 37A24, which says that you have to not go outside the reference. Now, my lord, just look at it. 2 minutes, my lord. I'll also go to my friend's judgments. Because, my lord, let me explain what I'm going to say. Those judgments only say that it is not necessary to answer every issue so long as the main points are decided.
It is covered.
Yeah, it is covered then.
Sometimes it's happened.
So it's not a formality. So long as the issues are covered in that sense. Now here we have a different case altogether of the fundamental issue not being decided.
Here you have made out a case, and as per the once the first issue is regarding the contract
and which is not
the
decided.
Arbitrator has of the view that that has been
not to be decided.
Not to be decided.
Then how can the award work?
The arbitrator has gone into in respect of the orders passed by the court.
So those are the second point, whether he could have gone into those. But the first point, which is most important, that he has failed to decide the matter referred to him. The reference, my lord, on that date has to be of the matters referred. Can we have dolphin drilling? Yes, let's show that first. Lord, I'll just show one first before I go further. Well, dolphin drilling is a case which arises, it's been followed repeatedly, but I'll tell you also how it arose.
Yeah.
Suppose you have a running contract and you have made one reference, and then of all disputes, and thereafter 3 months later you want to make another reference. Can you make it or not? And the court said yes, because the reference of the first level is of disputes which were prevailing then. It doesn't cover future disputes. Therefore, you can make, so it is possible that if he wanted to say that the breach of the orders resulted in further disputes, he could have made a reference. But he could not say that it fell into the reference here.
First one.
Yes. And kindly see that. It's quite important, my lord. I'll read the actual part instead of the head note. So this was an 11-6 matter, my lord. They made a grievance that their invoices were not paid. They addressed a notice on 29 January 2008, invoking arbitration, nominating Justice Barucha, Chief Justice, as an arbitrator. Then, my lord, appearing for the respondent, accepted the provision for arbitration, Pide Clause 28. He also acknowledged that the disputes raised by the applicant in the arbitration notice of 208 arose under the agreement of 2003 and were fully arbitrable. Nevertheless, he resisted the prayer to defer the disputes raised in the arbitration notice on the plea that the applicant had already invoked the arbitration clause, albeit in connection with a different dispute earlier arising under the agreement. Then submitted the remedy of arbitration. I'm not reading that. And then we can go straight to paragraph 8 on the last page. The plea of the respondent is based on the words all disputes occurring in para 28(3) for the agreement. Mr. Agarwal submitted that those two words must be understood to mean all disputes under the agreement that might arise between the parties throughout the period of subsistence. However, he had no answer as to what would happen to such disputes that might arise in the earlier period and get barred by limitation till the time comes to defer all disputes. The words all disputes in 28.3 can only mean all disputes that might be in existence when the clause is invoked, when the parties agree to give arbitration notice to the other. In its present form, clause 28 cannot be said to be a one-time measure, and it cannot be held that once the arbitration clause is invoked in the future, the remedy of arbitration is no longer available in regard to other disputes that might arise in future. So the point is this one line, the words all disputes in an agreement can only mean all disputes that might be in existence when the clause is invoked. And now look at tested, my lord. The clause was invoked by the order of 27th April 2022. The only disputes at that time were my suit, in which I had said deliver, and he said, no, I've terminated, I won't deliver. Now, what if that was not the dispute referred? How can the learned judge say, the learned tribunal say, that by virtue of the working modality, they need to decide that dispute goes? That's like turning the matter on its head. The working modality is used as a means for not determining the issue referred.
Yes.
Then why would you make the reference if that was so? So this really illustrates. And my lord, the Calcutta judgment, which I was showing your lordships, is rather interesting. You got a copy? I gave you a copy. 2017 Calcutta. I'll tell you, your lordship, what the point was. Railways were asking for brake blocks for the trains. He was the supplier of brake blocks. He submitted some supplies. Somewhere along the line, Railways issued a modification or clarification as to the specifications of the brake blocks. He took the view that that was not acceptable because they were adding new conditions. The Railways took the view that this was only an elucidation or elaboration of the original specs. Matter went to arbitration. In arbitration, the arbitrator did not consider the case of the Railways that this was only an elaboration or elucidation. He took the view that this was a modification and therefore he decreed it. Now look what the court says on that. Paragraph 10. In my opinion, the correct questions were not addressed by the learned arbitrator. The contention of the Railways was that there was no difference in the technical specifications between the original purchase order and the modification advice. The original purchase order specification stated that goods had to be manufactured according to the RDSO specification. The modification advice only made a clarification or amplification of this specification. If the brake blocks were manufactured according to this specification, it would also conform to the standard mentioned in the modification advice. Otherwise, according to the Railways, how could so many items be okay? If the railways by their modification had introduced an entirely different set of standards, then all the goods ought to have been rejected. Counsel went to the extent of saying that the award shocked the conscience of the court. In my opinion, when the learned arbitrator does not address the real dispute or issues before him, he's trying to decide something which is not referred to him. Or in other words, he's not exercising the jurisdiction vested in him. The award is liable to be set aside under 34(2)(a)(4) of the Arbitration and Conciliation Act, which is as follows. So they set aside and remanded. Now, this is exactly what has happened here. He has to quote the judgment, my lord, not address the real dispute or issues between the parties which were referred to him, and he's decided something which is not referred to him. Now, it might be that on the second part, they could rely on acquiescence or participation to say we also allowed him to decide that. But that doesn't change the first part. The question which I am urging is not so much that he went into the question of breach of the order, but that he didn't decide the question of breach of the agreement of 22nd February by saying it's not necessary to decide it. How could that be? That was the only thing.
It's only the arbitrator's duty.
Then that really has vitiated this whole award.
Okay.
And on that, my friend who has only cited these two judgments, which say that all issues need not be decided. But my lord, just see in the Supreme Court on this point, one last judgment, if your lordship permits. Sorry. In fact, this is a judgment referred to in one of the judgments my friend has cited. And what it says is that if you do not decide a fundamental question, then it's an error apparent which vitiates the matter. I'll give your lordship that in 2 minutes, my lord. If your lordship sees top page 45.
Yes.
Where they refer to what was decided in the pleadings of the case. The last 4 lines of paragraph 44, the cases to which reference has been made indicate that the misconception of the court must be regarded as sufficient reason analogous to an error on the face of the record. And then if your lordship goes to the page 49, and the bottom of that page. Assuming it is so, it is clear that the learned judges found themselves on the 3 points mentioned, which do not appear to fall within any of the issues in the case except 11A, which was given up, to decide against a party on matters which do not come in the issues on which the parties went to trial clearly amounts to an error apparent on the face of the record. It is futile to speculate as the effect the matters had in the matter. In fact, the point is, my lord, this one error, from this, everything comes. Because of that, he has not decided the next question of what damages for that contract. And he has decided a question of damages arising out of the 20th May order. Correct. Now, the judgments I'll show, much my friend cited, they are unexceptional. They only mean that you can't make a rigorous formality, so long as the points are covered. But here the point is not covered. It is expressly given up. It is said, I won't decide this point. I don't need to decide the point. How can that be done? Then what is left in this award?
No.
I'll complete.
Yes.
I'll complete tomorrow. I can go on now, whatever your lordship says.
How much time you will take?
About another half an hour.
Then come tomorrow.
Whatever your lordship says. Not more than half an hour. This was, my lord, I had to take your lordship's time to put the setting right, that what has gone wrong here in the matter. That's why.
Thank you.
Greatly obliged.
So appearing for the petitioner. So appearing for the respondent. Counsel for the petitioner in reply had argued at length, but due to paucity of time, argument could not be completed. The matter is already fixed tomorrow at 12 noon. Let the matter be placed tomorrow at 12 noon. Be placed on 29 at 12 noon. 29 no, 29 है ना? At 12.
Lord,
ले. Yes. दे दिया लगा. 15 सब भाग्य होएगा अभी कौन आएगा सब भाग्य होंगे
Item
number
15.
Yes.
That is written, my application praying for setting down that probate proceeding as a contentious cause.
Contentious cause?
Yes, sir.
Why?
One of
How
the
many legal layers?
There are 4 legal layers. One of the
legal layers?
4. One of them had filed a caveat affidavit in support of the caveat sometime in November 2023. Pursuant to the one of the legal layers have filed a affidavit in support of the caveat pursuant to the order dated 23rd November 2023, where the leave was granted to file the affidavit in support of the caveat. So I'm just praying for setting down the probate proceeding as a contentious cause and a further direction for discovery and inspection.
Where is the affidavit in support of caveat? Caveat is there.
My lord, my affidavit of service be kept.
What is the GA1?
GA1 has been disposed.
Disposed of?
Yes, your lordship. All
when
the
it was
other
disposed of? What is the GA1?
sorry, I'm not safe. By an order dated 16th March 2023, it has been disposed of
for amendment?
For amendment of affidavit assets.
Affidavit assets?
Yes, your lordship.
It was amended?
Yes, your lordship.
16 March?
Yes, your lordship.
So it is disposed of?
All the other applications are disposed.
What is the GA4 now?
GA4 is my application, which is lying for praying for setting down the probate proceeding as a contentious cause.
GA4 कहाँ है? You are having the copy of the GA4?
Yes, your lordship.
Who has filed caveat? Asit Kumar Roy.
Asit Kumar Ray.
Have you got the affidavit in support of caveat?
Yes, your lordship.
But that is not on record. So and so appearing for the petitioner. Petitioner has filed the present application being PLA 80 of 2020 2021?
Yes, your lordship.
Or 19?
2021, PLA 80 of 2021.
Hey, key number.
That would be reserving.
तो जब वो 19 में फाइल हो 21 कैसा आएगा? डिपार्टमेंट तो कुछ भी 2080 of 2021 दे अच्छा ये है नया फाइल किया J2 है उसको दे एक है वो यहाँ तो फाइल एन एप्लीकेशन फॉर ग्रांट ऑफ बीइंग GA वो 2 है ना GA4 of 2020 GA4
Yes, your
of
lordship.
2020 अरे सब गलत हो गया. The petitioner has filed an application being PLA number 80 of 2021 praying for grant of probate. Probate of the last will and testament dated. एप्लीकेशन भी नहीं प्रोबेट एप्लीकेशन कहाँ है कुछ भी नहीं है यहाँ पे
It is dated 27 July 2007.
dated 27th of July
2007.
2007. Counsel for the plaintiff submit that one Ashit Kumar Roy, he has filed the caveat.
Yes, your lordship.
One Ashit Kumar Roy has filed the caveat as well as affidavit in support of caveat. Accordingly, the petitioner has filed the present application for treating the PLA number 80 of 2021 as contentious cause and by converting the same into a testamentary suit. Considering the submission made by the counsel for the petitioner, peruse the application, caveat filed by Ashit Kumar Roy. The PLA number 80 of 2021 is converted into contentious cause. Department is directed to assign the testamentary suit number and to place before this court on 12th of December 2024.
And your lordship, with regard to prayer B for direction of discovery inspection, prayer B.
Direction of
discovery and inspection.
Let it come first. That's why I'm telling. Let it is completed, then let the other party come.
I had filed by your lordship, I have filed the affidavit of service as well.
Affidavit of service filed by the petitioner to be kept with the record. Take back.
Grateful.
सर रिकॉर्ड ठीक करो इस तरह होने से मत लो लेते क्यों हो देख के लो कल को आप लोग को दे देंगे भरपेट यस नेक्स्ट
Your Lordship, I appear for the respondent in this application.
Milord, I am appearing, Milord, virtually, Milord. I cannot, Milord, start my video. There seems to be the host has stopped it, Milord. I am.
Your Lordship,
Milord, now,
may I just say something?
Milord,
Vashish Sengupta is leading me in this matter for the respondent. He's lost his mother.
You are appearing for?
I'm appearing for the respondent in this application.
Respondent?
Yes, Your Lordship.
In the application?
Yes, Your
What application?
Your Lordship, this was an application taken out by them for extension of time and condoning the delay with
for
respect
condonation of delay, Milord, in filing the affidavit in support of caveat, Milord. I understand my learned friend is in some difficulty, Milord. I am also in some difficulty. I am being led by Mr.
Who is for the
Pradyumna
petitioner?
Sinha.
Original petitioner? Who is the original petitioner?
Your Lordship, I am for the original petitioner in the Yes, Your Lordship. Just if I may just indicate, Mr. Subhashish Sengupta is leading me in this matter. He's requested me to just pray before Your Lordship. He's lost his mother yesterday. So if it could be adjourned for a period of 2 weeks.
As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 19th of December. Next.
Extremely grateful to you.
Item number 17. I mentioned this matter before your lordship. Only for the leave, my lord. Amendment order was passed, my lord, on my lord. on my lord, 13th September 2024. There is a typographical mistake, my lord, in the annexure, my lord. Kindly see the petition, my lord.
Where is the order?
Order. This is the order, my lord. Order was passed to proposed amendment application was annexure, my lord, and annexure D of the said application, my lord. But there is in petition, original petition, it was there, my lord, but proposed amendment, the one line was not there, my lord. So much, my lord, regarding my lord, this I showed my lord before your lordship, my lord. My lord.
GA1.
GA1.
What was your prayer? Prayer A?
All prayer was granted, my lord.
Yes, A to D was granted.
Yes, my lord. All are granted, my lord. After passing the order, my lord, department find out, my lord, there are some typography.
Where?
In annexure D, my lord. Annexure D.
Which number? Which paragraph number? Which line number?
Page 12, my lord. Page 12, my lord. Kindly see, my lord. Nirmala Sen. Nirmala Sen, son of late was not, my lord, type, my lord. The Sumir Kumar Sen, aged about 60 by faith.
What you want now? Only late is
only
to be
leave to file the amend, the proposed amendment application.
What amendment? Now what correction you want?
This line, my lord. This line, my lord. Only this line.
What this line?
Kindly see this annexure, my lord, and compare with the page 12, my lord. Compare with the page 12, my lord. Page 12.
Instead of Nirmala Sen, it should be Nandini Sen.
Nandini Sen.
Wife of Nirmala Sen.
Yes.
Good.
Yes.
You change the total person from the affidavit.
That was allowed, my lord. That was allowed. Only, my lord, the
What
sole...
allowed? Your application was allowed with regard to the Nirmala Sen. Now you wanted to correct
no,
the
Nandini. No, my lord. Nandini Sen. It is a letter of administration. Convert to the letter of administration. There is no sole.
You are
yes, my lord. Proposed amendment. Kindly see the proposed amendment. Nandini Sen.
So what you want to correct now?
Correct, my lord, sole executor permanently. That this word in second line, my lord. These words were not omitted, my lord, from the
second line.
Yes, my lord. The second line, page 12, my lord.
You read it.
Read it, my lord.
Nandini Sen,
wife
of Nirmala
Sen.
Instead
of my lord, Nirmala Sen, son of Samir Kumar Sen. Thereafter, my lord, in after service, occupation service.
Sir, you read, continue.
Yes, my lord. Aged about.
Sen.
Yes, my lord.
Wife of Nirmala Sen.
Yes, my lord.
Age about 60 years.
Instead of 61 year by faith Hindu, by occupation service, residing at. Here, my lord, one word omitted, sole executor permanently. That was what omitted.
Sole executor?
Sole executor permanently.
Permanently?
Permanently residing at. Only residing at type. It was permanently residing at type.
It is there, permanently residing it, and that is there.
In the proposed amendment, it was not there, Malad. In my correction copy, Malad, it was there. Malad, proposed amendment, page 12, Malad, it was.
Occupation service.
Yes, Malad.
Sole executor, you are not mentioned in the
proposed amendment.
Proposal. So, want to sole executor also. Sole executor permanently.
Permanently. This one. So, Malad, the department is not able to carry out the amendment, Malad, because they showed.
So appearing for the petitioner. Petitioner has filed an application being GA1 of 2024, praying for amendment in the PLA application.
Letter of
amendment in the probate application.
Not probate, letter of administration.
Amendment in the
yes, probate application. Probate application. It will be converted to the letter of administration. Sorry, my lord. I beg your apology, my lord. I beg your apology, my lord.
Great Cable filed an application being GA1 of 2024, praying for amendment in the application for grant of letters of administration. Full stop. This court, by an order dated 13th September 2024, has allowed prayer A, B, C, A to D, A to E, A to D of the master summon of GA1 of 2024. Full stop. At the time of amendment by the department in terms of the proposed amendment allowed by this court of the letters of the application for grant of letters of administration, comma, the department pointed out that in page number 12 of the proposed amendment, second paragraph, after the second line, first paragraph, second line, after the word by occupation service, after the word reside by occupation service, comma, service, comma, so invert comma, yeah, sole executor permanently has not typed in the proposed amendment, due to which though the same was appearing in the main application for grant of administration, grant of letters of administration. Accordingly, counsel for the petitioner prays for leave to add 3 words: sole executor permanently after the word service and before the word residing in page 12, paragraph 1, line number 2 of the proposed amendment application. Consider the submission made by the counsel for the petitioner. This court find that in the original application for grant of letters of administration, the sole executor, comma, permanently is mentioned, but at the time of filing the proposed amendment application, the petitioner the words sole executor permanently is misplaced. Accordingly, leave is granted to the petitioner to add the words sole executor, comma, permanently after the word service and before the word residing in the proposed amended application appearing at page number 12, paragraph 1, line number 2, within a week from date.
And department will accept
the department is directed to allow the petitioner to amend the application appropriately by adding the words sole executor permanently
And
as mentioned above.
also extend that time for carry out the amendment, my lord.
Within a week.
Yes, my lord. Yes.
Counsel for the petitioner submit that the time granted by this court for amendment is
2 weeks earlier
completed. Accordingly, further 3 weeks time is granted to the petition to the department to carry out the amendment in terms of the order dated 13 September 2024 and this order.
Deeply applied.
My lord, may I have a kind
Should I appear for the defendant number 2 and 3? Yes, may I leave to submit the authorization of this witness which I have brought today?
Not you, sir. Again, you are doing this. It is your duty. You are bringing the authorization before this court. What you have to produce through the witness.
Yes.
May I get a copy of it? ये तो कॉन्ट्रैक्ट ना
बोलिए। हम धर्म से कह रहे हैं
हम धर्म से कह रहे हैं
इस मुकदमे में
गवाही के तौर पर
हम जो कुछ भी बोलेंगे सच बोलेंगे सच के सिवा झूठ नहीं बोलेंगे और कुछ नहीं छुपाएंगे। आपका नाम?
मेरा नाम त्योफिल एक्का।
धर्म से
स्पेलिंग बताइए।
थोड़ी है, मैं कसम खाता
टी
हूँ, झूठ नहीं बोलूंगा, सच बोलूंगा, सच बोलूंगा, झूठ नहीं बोलूंगा। ईश्वर मेरी सहायता करे।
कंस्ट्रक्शन टेबल चिकन कंस्ट्रक्शन
नहीं, where from you got this oath?
तो 1992 था देखिए।
धर्म से नहीं,
92 डॉक्यूमेंट
मैं कसम खाता हूँ जो कुछ बयान दूंगा वो सही होगा, मेरे बयान में कुछ झूठ नहीं होगा। ठीक है, ईश्वर मेरी सहायता करे। इमाम से वो जो भी।
आपका नाम सर?
त्योफिल एक्का।
स्पेलिंग बताइए।
TEOPHIL। त्योफिल एक्का।
EKKA।
हाँ, EKK।
पिताजी का नाम?
लेट अमृत एक्का।
लेट अमृत एक्का। राइट। आपकी उम्र?
57।
57। आप क्या करते हैं?
मैं दक्षिणपुर रेलवे में वरिष्ठ खंड अभियंता के पद पर।
डेजिग्नेशन की जरूरत नहीं है। आपके घर का पता बताइए धीरे धीरे से।
ओरिजिन से रूल्स लो।
मेरा गांव है, विलेज है, नगरी पोखर टोली।
नगरी पोखर टोली। नगरी पोखर टोली।
पोस्ट इसका नगरी।
इसका नगरी। इसका नगरी।
हाँ,
PISKA। इसका नगरी NAGRI। बोलिए। डिस्ट्रिक्ट रांची।
स्टेट झारखंड।
पिन कोड
83535303।
यस सर।
Yes, sir.
I'm showing you one document. Kindly tell my lord what is this document.
आपको एक डॉक्यूमेंट दिखाया जा रहा है।
हाँ।
माय लॉर्ड को बोलिए कि ये डॉक्यूमेंट क्या है।
महाशय, ये लेटर ऑथराइजेशन का है। ये
दिस इज अ लेटर ऑफ ऑथराइजेशन।
ये डिप्टी चीफ इंजीनियर कंस्ट्रक्शन में मेरे को एड्रेस किए।
दिस वाज गिवन टू मी बाय द डेप्यूटी चीफ इंजीनियर कहाँ का?
रायगढ़।
इंजीनियर कंस्ट्रक्शन रायपुर।
बिलासपुर।
यस सर।
Rika,
Yes.
showing you document being DD 15 marked X for X4 for identification. X4 for identification. DD14.
DD15, sir, you said. 26.
Yes. DD15 mark for this mark for identification 4. Right.
X4. Yes.
Kindly tell what is the date of this letter?
ये लेटर देखिए और बोलिए जिसका तारीख क्या है लेटर का.
ये 16/6/2011 का है.
This is a letter of 16 June 2011.
Who has signed this letter?
किसने ये लेटर को साइन किया है?
ये इसको साइन किया डिप्टी चीफ इंजीनियर कंस्ट्रक्शन 2 रायगढ़.
The letter was signed by Deputy Chief Engineer Construction 2 Raigad.
May I come back? Do you know his signature?
क्या आप उनकी दस्तखत को पहचानते हैं?
यस सर.
Yes, I know his signature.
How do you know his signature?
आप कैसे उनके सिग्नेचर को जानते हैं?
इसका सिग्नेचर मैंने देखा है ऑफिस में और इसके अंडर में काम कर किया था.
I worked under him and I saw him signing documents in front of me.
Rekha, I am showing you another letter dated 24/8. Mr. Drolia, earlier your authorization, it is marked or not? It is not marked. Then, let's see. I am learning many things from this court. I am. Okay. Identified, है ना? What is the answer? What is the question?
Export for identification. What is the date of letter? Well, I think that the letter of time for do you know how I got under it and I saw time profit.
Exhibit. Mr. Rekha, I am showing you exhibit.
14. 14. 1 second, sir. The letter dated 16th June 2011. Marked as
Yes, next. Mr. Rekha, I am showing you another letter dated 24th August 2011, being document DD document 14, and marked as X5 for identification. Kindly tell my lord what is the date of
What is the date of the document?
What is the date of the document?
इस डॉक्यूमेंट का तारीख क्या है बताइए?
ये 24/8/2011 का.
The date of the document is 24th August 2011.
And who has signed this letter?
ये लेटर किसने साइन किसने दस्तखत किया है इस लेटर पे?
ये डिप्टी चीफ इंजीनियर कंस्ट्रक्शन 2 रायगढ़.
The letter was signed by the Deputy Chief Engineer Construction Raigad.
What is the name of the Deputy Chief Engineer?
Deputy Chief Engineer Raigad का नाम क्या था?
MV सत्यनारायण. श्री MV सत्यनारायण.
The name of the Deputy Chief Umuk is MV Satyanarayana. Sri MV Satyanarayana.
Do you know his signature?
Yes.
क्या आपको पता है उनका सिग्नेचर?
जी हाँ.
Yes.
How do you know his signature?
आप उनकी दस्तखत को कैसे जानते थे?
ऑफिस में देखा सर और उसके अंदर में काम भी किया है.
I worked under him and I saw him signing document in office in front of me.
let it be marked.
Exhibit.
Yes, sir.
Yes, next.
I'm showing you a letter DD 14 marked for X5 for identification. Okay. Yes. No. That letter, what is the date? The earlier letter?
24th August 2011.
Yes, DD 16 marked X for marks X for identification. X6 for identification.
X6. Yes, sir. What is the question, sir?
So, Eka, kindly tell the date of this letter.
Just a minute, Mr. Dhrolia. This the earlier letter, Exhibit 15. It was a Xerox copy.
The Xerox copy means that I submitted before Lordship that the original have been misplaced by the rail.
You are denying this? It is admitted document. X5. Because the signature was not identified, it was not exhibited on that day. See, your senior is not here.
Can we have it?
মিট করছো কিনা সেই কারণ অ্যাডমিশন ডিনাল তো আছে অরিজিনালটা নেই জেরক্সটা হচ্ছে ফেস করছেন মিট করছে অ্যাডমিশন ডিনালে নেই দশটা নিয়ে নিন জিজ্ঞেস করছি I am not finding the admission denial. May I take copy? Hey, copy. It's a lot of papers. It has now 3 bags.
No, because on the last occasion, the witness he could not identify the signature. That's why it was not exhibited. And
24 এটা কি দেখ তো তুই বুঝবি বুঝতে পারছি না এখন we are not admitting it's this letter
with objection with objection exhibit 15 with objection as the plaintiff denied the document and this is the Xerox copy.
I'm showing you the letter being in DD 16 marked X6 for identification. Can you tell my lord what is the date of this?
इस डॉक्यूमेंट का तारीख क्या है बताइए?
यह 30/8/2011 का है.
The document is dated 30th August 2011.
Who has signed this letter?
किसने ये लेटर साइन किया है?
देख तो
2011 Chief Engineer Construction 1 Bilaspur.
The letter was signed by Chief Engineer Construction 1 Bilashpur.
What is the name of the Chief Engineer Construction 1 Bilaspur?
Chief Engineer Construction 1 Bilaspur का नाम क्या था?
AK Singh.
Mr. AK Singh.
Do you know his signature?
क्या
Yes.
आप? Yes.
How do you know his signature?
आप कैसे उनके सिग्नेचर को पहचानते हैं या जानते हैं?
बिलासपुर से सर रायगढ़ में उसका लेटर आया, आता जाता रहता था, तो
His letter used to come from Bilaspur to Raigad.
जी
Raigad, and that is how I know his signature.
Let it be marked.
Original?
Original. No, original. No, no.
You denied?
I'm searching.
Take this. Keep with you.
Sorry, Milad.
अगर डिनाई है तो
Denied.
denied
Serial number 16.
with objection as the defendant plaintiff denied the document and the document is a Xerox copy with objection.
Milad, I'm keeping this Milad for the timing. Milad.
Nah, keep it.
Obliging. Mr. Eka, I am showing you.
Yes, sir.
Mr. Eka, I am showing you a letter being the document annexed in documents of DD 17 and being the marked as X7 for identification. I'll tell my lord, what is the date of this letter?
ये डॉक्यूमेंट देखिए और बताइए इस डॉक्यूमेंट का तारीख क्या है?
ये 11/10/2011 का है.
This is the document is dated 11th October 2011.
And who has signed this letter?
किसने दस्तखत किया है इस लेटर पर?
डिप्टी चीफ इंजीनियर कंस्ट्रक्शन 2 रायगढ़.
The letter was signed by Deputy Chief Construction 2 Raigad.
What is the name of the Deputy Chief Construction Raigad?
Deputy Chief Construction Raigad का नाम क्या था?
MV सत्यनारायण.
Mr. MV Satyanarayana.
Do you know his signature?
क्या आप उनकी दस्तखत को जानते हैं?
यस सर.
Yes.
How do you know his signature?
कैसे जानते हैं?
ऑफिस में उसका अंडर में था और देखा हूँ उसका.
I worked under him and I saw him signing documents at the office on many times.
Xerox copy, Milad. Milad, it's serial number 17, Milad, existence and content denied.
With objection as the plaintiff denied the existence and contents of the document and the document is Xerox.
I'm sorry, Milad, it is the original.
Okay, Xerox got it.
Original. With objection. It is can be marked exhibit.
Exhibit 17. With objection.
With objection. With objection.
Yes, sir.
Yes, next.
Mr. Eka, kindly, I'm showing you the DD 18 being that document marked as X8 for identification.
Yes, sir.
What is the date of this letter?
इस चिट्ठी का तारीख क्या है?
21/10/2011.
The letter is dated 21st of October 2011.
With objection, Milad, same. Who is the signatory of this letter?
ये लेटर किसने साइन किया है?
डिप्टी चीफ इंजीनियर कंस्ट्रक्शन रायगढ़ 2.
The letter was signed by Deputy Chief Engineer Construction 2 Raigad.
What is the name of the Deputy Chief Construction Raigad?
Deputy Chief Engineer Construction 2 Raigad का नाम क्या था?
श्री MV सत्यनारायण.
Mr. और श्री MV Satyanarayana.
Do you know his signature?
क्या आप उनके दस्तखत को पहचानते हैं?
यस सर.
Yes.
How do you know his signature?
कैसे पहचानते हैं?
उसके अंडर में काम किया और ऑफिस में भी था.
I worked under him and saw him signing documents at the office on many occasions.
With objection.
Same.
Exhibit 18 with objection.
Is it original?
Yes, sir.
It is original.
Original, but they are denying in the.
Object.
It will be considered an argument.
18 with objection.
Or if you want to prove the content, then you have to take steps.
Mr. Reka, I am showing you a document being DD19 marked as X9 for identification. Kindly tell the date of this letter.
इस चिट्ठी का तारीख क्या है?
30/11/2011.
The letter is dated 30th November 2011.
अभी जो एग्जीक्यूट हो रहा है ना, उनको डॉक्यूमेंट देना है, अभी हमको देना बाद में होने.
Who has signed this letter?
इस लेटर में किसका दस्तखत है?
डिप्टी चीफ इंजीनियर टू रायगढ़.
The letter is signed by Deputy Chief Engineer Construction to Raigad.
What is the name of the signatory of this letter?
जिसने साइन किया है उनका नाम क्या है?
श्री M.V. सत्यनारायण.
श्री M.V. सत्यनारायण.
You know his signature?
क्या आप उनके दस्तखत को पहचानते हैं?
Yes.
Yes.
How do you know his signature?
कैसे पहचानते हैं?
उसके अंडर में काम किया और
I worked under him.
देखा.
जोर से बोलिए सर.
उसके अंडर में काम किया और मैंने देखा है साइन.
I worked under him and I saw him signing documents on many occasions at the office.
Just
No sir. Original.
Let it be marked. It's original.
Same with objection.
Mr. Reka, I am showing you a letter being DD23 and marked as X11 for identification.
Yes sir.
What is the date of this letter?
इस लेटर का तारीख क्या है?
5/5/2012.
The letter is dated 5th May 2012.
Who has signed this letter?
किसने साइन किया है?
डिप्टी चीफ इंजीनियर कंस्ट्रक्शन टू रायगढ़.
The letter was signed by the Deputy Chief Engineer Construction to Raigad.
What is the name of the Deputy Chief Engineer to Raigad?
क्या नाम था उनका?
श्री M.V. सत्यनारायण.
श्री M.V. सत्यनारायण.
Do you know his signature?
क्या आप उनके दस्तखत को पहचानते हैं या जानते हैं?
Yes.
Yes.
How do you know his signature?
कैसे पहचानते हैं?
उसके अंडर में था सर. उसके अंडर में काम किया हूँ और ऑफिस में भी था.
I worked under him and I saw him signing on signing documents at the office on many occasions.
It's okay. It's original. It's original. Original, no? Yes. Let it be marked.
It's
Admitted.
documents existence is admitted, contents disputed. So let me go with objection.
With objection with regard to the contents.
Exhibit 20, huh? With objection.
Mr. Reka, I am showing you a document being DD27 marked as X12 for identification. 12.
Yes.
What is the date of this letter?
इस चिट्ठी का तारीख क्या है?
19/9/2013.
The letter is dated 19th September 2013.
Who is the signatory of this letter?
किसने साइन किया है?
डिप्टी चीफ इंजीनियर कान रायगढ़.
The letter was signed by the Deputy Chief Engineer Construction Raigad.
What is the name of the signatory?
जिसने साइन किया है ये लेटर को, उनका नाम क्या था और है?
अशोक कुमार सूर्यवंशी.
अशोक कुमार सूर्यवंशी.
जी.
Do you know his signature?
क्या आप उनकी दस्तखत को पहचानते हैं?
यस.
Yes.
How do you know his signature?
कैसे पहचानते हैं?
उसके अंडर में था.
I worked under him.
Xerox copy?
Yes.
Separate Xerox copy, maybe with us.
Admitted? No, my lord, both are denied. Both are denied.
With objection, contents and existence are denied, and the document is Xerox one. Yes, next.
Mr. Eka, I am showing you a document being DD29 marked as X13 for identification.
ठीक है.
Yes, sir.
What is the date of this letter?
इस चिट्ठी का तारीख क्या है?
25/11/2013.
The letter is dated 25th November 2013. 13.
Who has signed this letter?
किसने साइन किया है?
ये डिप्टी चीफ इंजीनियर कंस्ट्रक्शन रायगढ़.
The letter was signed by the Deputy Chief Engineer Construction Raigad.
What is the name of the signatory of this letter?
जिन्होंने इस लेटर को साइन किया है उनका नाम क्या है?
श्री अशोक कुमार सूर्यवंशी.
श्री अशोक कुमार सूर्यवंशी.
Do you know his signature?
क्या आप उनकी सिग्नेचर को पहचानते हैं या जानते हैं?
यस.
यस.
How do you know his signature?
कैसे जानते हैं या पहचानते हैं?
उसके अंडर में.
I worked under him.
This is all for me.
That's all. With objection.
With objection.
Same, huh?
Both are denied. Yes.
22.
Counsel for the plaintiff denied the existence and contents of the document, and the document is Xerox. Xerox is the photocopy.
Maybe marked exhibit with objection.
Identify with objects. That's all.
That's all.
I'll just start Milad and then Milad.
Small one.
Yes.
2 question it will be finished.
I will Milad.
2 questions. Yes, continue. No problem.
কত আছে? কত আছে? Witness. How were you authorized? একটু অথরাইজেশনটা দেখিয়ে দিন একবার. এটা জমা দিন.
Authorization. Exhibit 13.
How were you authorized to depose before this honorable court?
आपको कैसे ऑथराइज किया गया था इस कोर्ट के सामने गवाही देने के लिए?
ये डिप्टी चीफ इंजीनियर कंस्ट्रक्शन के द्वारा.
जोर से बोलिए सर.
डिप्टी चीफ इंजीनियर कंस्ट्रक्शन बिलासपुर के द्वारा.
Deputy Chief Engineer Construction Bilaspur gave me an authorization letter to depose before this court.
Under which power did the deputy chief engineer had the authority to authorize you to depose before this honorable court?
किसके बिना पर, किस पावर के बिना पर डेप्यूटी चीफ इंजीनियर कंस्ट्रक्शन बिलासपुर ने आपको ऑथराइज किया था इस कोर्ट के सामने गवाही देने के लिए, आपको पता है?
चीफ इंजीनियर कंस्ट्रक्शन
how our question repeated.
किस पावर के बिना पर उन्होंने आपको ये ऑथराइजेशन लेटर दिया जिसके चलते आप यहाँ पर गवाही देने के लिए आए हैं?
ये रेलवे बोर्ड का कुछ ऑर्डर होगा।
There might be some railway board order.
ওনাকে একটু দেখান তো 12 এপ্রিল 2024 অর্পিত খুন্ডেটার এক্সামিনেশন। Kindly come to question number 4 of the deposition of Mr. Arpit Khunteta, dated April 12, 2024.
Yes.
I put it to you. Have you ওনাকে দেখিয়ে দিন ওই কোশ্চেনটা
आप इंग्लिश
পড়তে পারছেন?
समझ सकते हैं?
একবার হিন্দিতে বলে দিন।
या मैं बोल दूं आपको?
হ্যাঁ হিন্দিতে বলে দিন।
यहाँ पर लिखा है हैव यू बीन ऑथराइज्ड अंडर दिस ऑर्डर टू डिपोज? क्या इस ऑर्डर के बिना पर आपको ऑथराइजेशन दिया गया है इस कोर्ट के सामने गवाही देने के लिए? अंकित जी ने कहा था यस एट सीरियल नंबर 32 डिविजनल एग्जीक्यूटिव इंजीनियर हैज बीन ऑथराइज्ड सब्जेक्ट टू ऑब्जेक्शन। उन्होंने कहा था हाँ सीरियल नंबर 32 में डिविजनल चीफ एग्जीक्यूटिव इंजीनियर ने ऑथराइज किया था। यहाँ पर जो लेटर है उसका आइडेंटिफिकेशन के लिए वो रिकॉर्ड में रखा गया था, लेटर और उसको डेट के सहित।
So according to you, is this the railway board letter which has authorized the deputy chief engineer to authorize you?
क्या यही वो लेटर है आपके चलते? क्या यही वो लेटर है जिसके बिना पर डेप्यूटी चीफ इंजीनियर ने आपको यहाँ पर गवाही देने के लिए ऑथराइज किया है? इस लेटर के बिना पर
अभी आपने जो बोला ना कि रेलवे बोर्ड के एक ऑर्डर है, ये जो दिखाया है जो आपसे पहले विटनेस बोल के यही ऑर्डर को आप बता रहे हैं?
यस सर।
यस।
I put it to you that this letter has not been proved, though it was marked for identification.
How you can say that is your argument?
Very well. Then I'll stop here on this. Very well. ছেড়ে দিন। Next. When have you joined? ছেড়ে দিন, সরিয়ে দিন ওটা। When have you joined with the concerned defendant?
आपने जो डिफेंडेंट है उनको कब ज्वाइन किया था? रेलवे में आप कब ज्वाइन किए थे?
मैं रेलवे 1994
इन द ईयर 1994।
When have you joined the Southeastern Railway?
साउथ ईस्टर्न रेलवे में कब ज्वाइन किया था आपने?
1994 में किया था।
इन द ईयर 1994 I joined the South Indian.
Were you associated with the Jharsuguda division?
झारसुगदा डिवीजन में क्या आपका कोई?
Were you employed at the Jharsuguda division?
वहाँ पर थे?
मैं था वहाँ पर।
Yes, I was employed at that division.
Since till which period? Means what is the period for which you were employed at the Jharsuguda division?
आप वहाँ पर कितने देर थे? कब से कब तक? टाइम पीरियड बताइए।
2009 से 2014 तक।
From the year 2009 to 2014, I was posted there.
Have you disclosed any document before this honorable court to show that you were employed at the Jharsuguda division with the railways from 2009 to 2014 in the present suit?
आपने अभी भी कहा ना 2009 से 2014 तक आप झारसुगदा डिवीजन में थे
जी।
तो क्या आपने इस कोर्ट के सामने कोई डॉक्यूमेंट वगैरह पेश किया है जिससे ये पता चले कि आप सच में वहां पर थे 9 से 14 तक? क्या आपने कोई डॉक्यूमेंट सबमिट किया है कोर्ट में?
नहीं।
नो, आई हैव नॉट।
Where are you employed now after 2014?
2014 के बाद से अब तक आप कहाँ पर है? और अब
रायगढ़ के ही अंडर में डिप्टी चीफ जनरल के ही
आई एम अंडर द रायपुर डिवीजन।
रायगढ़
रायगढ़ डिवीजन।
As you have deposed today that you have
ফার্স্ট লেটারটা কি নাম ছিল?
প্রথম দিকের সত্যনারায়ণের আগেরটা
रघुवंशी
এর আগে একটা শুনেছি রাজবংশী
अशोक राजवंशी।
अशोक राजवंशी and Satyanarayan.
I put it to you that you, as you have not shown any document before this honorable court with regard to your employment for the concerned time period, all your evidence is hearsay in nature.
वो आपको सजेशन दे रहे हैं, आप मान भी सकते हैं या नहीं मान सकते। वो कह रहे हैं कि ये जो 2009 से 14 तक आपने जो वहां पर काम करते थे, रायगढ़ डिवीजन में काम करते थे, आपने बताया झारसुगुड़ा में काम करते थे, आपने बताया, इसका चलते आपने कोई डॉक्यूमेंट कोर्ट के सामने प्रस्तुत नहीं किया है। तो वो कह रहे हैं कि आपने जो गवाही दे रहे हैं वो सब गलत है। क्या आप मानते हैं या नहीं मानते हैं? वो कह रहे हैं कि आपने कोई डॉक्यूमेंट कोर्ट के सामने नहीं दिया है जिससे पता चले कि 2009 से 14 तक आप उस डिवीजन में काम करते थे। क्योंकि आपने नहीं दिया कोई डॉक्यूमेंट, आपका जो गवाही है वो गलत है। आप क्या ये बात मानते हैं?
नहीं, मैं तो था वहां पर।
आई डू नॉट एग्री। आई वाज देयर, द विटनेस वॉलंटियर्स, आई वाज पोस्टेड देयर फॉर।
Do you have any idea about the subject matter of the present dispute in which you have come to depose before this honorable court?
जिस मुकदमे में आपने आप गवाही देने के लिए यहाँ पर आए हैं, उसमें क्या डिस्प्यूट है, क्या विवाद है, आपको इसके बारे में कोई नॉलेज है, कोई आइडिया है आपको? क्या मैटर है?
नहीं, वो तो टाइम पीरियड थोड़ा खत्म हो रहा था इसलिए।
आपको पता है या नहीं किस मामले में आप गवाही देने के लिए आए हैं? आपको पता है? हाँ या ना?
टर्मिनेशन के उसके
आपको पता है?
डोंट आस्क उनको क्वेश्चन मत पुट कीजिए, आप बोलिए है पता है कि पता नहीं है।
यस।
व्हाट डू यू नो अबाउट द डिस्प्यूट?
क्या पता है आपको, बोलिए।
टेल द कोर्ट इन ब्रीफ व्हाट डू यू नो अबाउट द डिस्प्यूट।
छोटा करके बोलिए ना।
कॉन्ट्रैक्टर को टर्मिनेट कर दिया उसका।
किसको?
कॉन्ट्रैक्टर को।
The contractor was terminated. और कुछ?
Do you know anything about the claim of the plaintiff in the present case?
प्लेंटिफ ने इस मामले में जो कुछ भी क्लेम किया है, इसके बारे में आपको कुछ पता है? क्या क्लेम किया है प्लेंटिफ ने?
देखा नहीं।
I have not seen that.
Do you know as to whether the railways have claimed anything in the present suit or not?
क्या आपको ये पता है कि रेलवे ने कुछ क्लेम किया है या नहीं इस मामले में? रेलवे ने क्या कुछ क्लेम किया है या नहीं किया है, आपको पता है?
क्लेम किया है।
Yes, the railways have claimed.
What is the nature of claim of the railways?
रेलवेज का जो क्लेम है उनका नेचर क्या है, प्रकृति क्या है, क्या क्लेम किया है रेलवेज ने?
अगेंस्ट में डिफेंड किया है।
जोर से बोलिए सर।
कोर्ट में डिफेंड किया है।
कोर्ट में डिफेंड किया
कोर्ट में
बस।
डिफेंड किया।
That's all.
Defended the matter in the court.
I put it to you that you have no knowledge about the present proceeding. About the present proceeding.
आपको ये जो प्रेजेंट प्रोसीडिंग हो रहा है इसके बारे में कुछ नहीं पता, वो कह रहे हैं, आप मानते हैं या नहीं मानते हैं?
एक ही बार में तो मैं नहीं समझ पाऊंगा ना।
ये जो केस यहाँ चल रहा है ना,
जी।
वकील साहब को बोलना है कि केस जो चल रहा है इसके बारे में आपको कुछ नहीं मालूम है।
मैं थ्रू देखा नहीं है सर। ठीक
बस 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 ठीक है ठीक है, कुछ देखा नहीं। ठीक है, दैट्स ऑल।
दैट्स ऑल। थ्रू कोर्ट। ये जो आप बोले ना, दो डिप्टी चीफ इंजीनियर, क्या नाम था उनका? सत्यनारायण और
सूर्यवंशी, एके सूर्यवंशी।
हाँ,
एके सूर्यवंशी।
एके सूर्यवंशी।
एके सूर्यवंशी, ये दोनों अभी सर्विस में है?
है सर दोनों।
Any further evidence?
No, I have no other witness.
Close.
Put it for arguments any day. Maybe. He has to start.
Not before vacation day.
December, Mr. Drolia will prepare the argument.
I leave it to a lot.
What is the claim?
Claim, Millard, is on more than Millard 60, nothing much.
Why the contract matter? There is no arbitration.
No, it was referred to arbitration. The claim was much higher than their threshold limit. So the arbitration they had sent, but it was not accepted by the arbitrators. Then they filed a section 8. Justice Somensen was that point of this interlocutory judge. Millard, they had the section 8 was rejected because of the Millard threshold limit. It was more than the percentage of total claim. Yes.
ठीक है, उतर जाइए।
65 lakhs and all, no? 65 lakhs and all.
Here, Milord, the railway has a counterclaim.
Nothing.
Milord, breach of contract, work was not completed. And Milord, the plaintiff withdrew from the railway about 6 crores rupees by submitting the bills, Milord. But project was not complete. The railway has alternatively
through the other
contractors. And therefore, a counterclaim of the railways.
So and so appearing for the plaintiff. So and so appearing for the defendant. Defendant witness number 2 present. Examination and cross-examination completed. During his examination, how many documents were exhibited? And document will been exhibit 13 to exhibit 22 with objects. With object. Full stop. Counsel for the proceeding completed. The counsel for the defense submitted he will not adduce any further evidence. Evidence of the defendant is closed. Let the matter appear for argument. Please the matter on. Give the date for argument. शुरू दिन तुम पकवा देगा। हाँ? 9 जनवरी 8। हाँ, दे दो, क्या डेट? 15 जनवरी at 2 p.m. Good. Come ready on that day. For you have to start.
Yes.
Because you have used the evidence.
Yes. I am relieved on that day.
I have to start the plaintiff's case.
No.
That's why I am specifying. In the civil suit, who adduce last witness? He will start the argument. Who adduce the last witness? He will start the argument.
Many things I am learning. I did company matter, other matters, but suit matters, full trial I never did.
Come ready on that.
Obliged.
17 over? Not today. एक मिनट
Lordship, in this matter, I am appearing on behalf of the co-founder. Caveat.
Yes.
I am appearing on behalf of the co-founder. In this matter, Lordship, probate was granted in favor of me in 23. In the year 23, thereafter
My lord,
revocation application.
I am the revocation application, my lord. The talk of settlement is going on, my lord. That is my instruction. I'm just humbly seeking that the 2 weeks time be given. The matter can be amicably settled between the parties.
Yes. What is your instruction?
Lordship.
Going on.
It's going on.
Next time.
Settlement is going on.
Yes, Lordship.
So and so appearing for the executor. Executor or executrix?
Executrix.
Executrix. So and so appearing for the cavator or cavatrix?
My lord, we are not the caveatrix. We had filed the application. We are the applicant, my
For
lord.
the applicant who has filed an application for revocation of the probate granted by this court. Counsel for the respective parties submit that a talk of settlement is still going on and there is a chance of settlement and prays for fixing the matter after the period of 2 weeks. In view of the submission made by the counsel for the parties, let the matter appear on 8th of January 2025.
My application for revocation of grant of probate, my lord. I was the sole surviving heir, and my lord, I was not cited. There was a general paper publication. But Mr. Hussain was appearing at one point of time. I had given notice of mentioning to the client also, as well as to the learned advocate on record who was appearing, my lord. After my lord was pleased to allow my mentioning, I even intimated them that the matter has come in the list.
So you are the you have filed an application for revocation.
For revocation of grant.
Here.
I am the sole legal heir who is surviving as on date. My lord, no notice to me, my lord. This happened in January. I came to know in February. I came to know in May, and immediately thereafter I filed the revocation. This is of January 5, 2023. My lord, not only that, in the probate application, they say that there are legal heirs. We do not know the details. And then when the probate is granted, it is represented before the honorable judge that there are no legal heirs. My lord, two cousin brothers had filed their objections, my lord, rather affidavits, my lord. Ultimately, the caveats, my lord, they did not file their affidavits in support of caveat because they are not legal heirs. My lord, here, my lord, I am the sister-in-law. My lord, the deceased had died childless, my lord, had no other legal heir. I am the sister of her predeceased husband. I am the sole surviving legal heir, my lord.
Okay.
On repeated occasions, my lord, matter was heard, and repeated occasions, accommodations have been prayed for. In fact, on the last few occasions, accommodations have been repeatedly prayed for.
Yes. 5th August, 19th August, May.
Repeated occasions, my lord. Everything is complete. Matter is ready for hearing.
They filed affidavit.
Affidavits, my lord, in opposition, in reply, supplementary affidavit, everything has been filed, my lord.
I am fixing a date. You inform
My lord,
the
I'll
otherwise-
intimate. I'll intimate.
So appearing for the applicant in GA2 of 2023. None appears on behalf of the respondent or the propounder. Full stop. The applicant has filed the present application for revocation of the probate granted by this court on the ground that no notice was issued. Full stop. As none appears on behalf, it is fine from the record. Pleadings have been completed and matter is ready for hearing. But none appears on behalf of the propounder, for the interest of justice, the case adjourned. Let the matter appear on
2nd January 2025.
My lord, instead of second, because the second I'm
And 9th of January
my lord, grateful,
2025
my lord.
for hearing of GA2 of 2023. It is made clear that on the date fixed, if none appears on behalf of the applicant, on behalf of the propounder, the application filed by the applicant will be taken up for hearing.
My lord,
Full stop. The counsel for the applicant is directed to inform the next date of hearing to the learned advocate on record of the propounder and to file affidavit of service on the
be
next.
my lord's pleasure to fix a time, my lord. Very short matter would not take
Time,
more.
then it will go further.
My lord, no, then let it remain on 9th January.
That's
Money.
It's my application in a testamentary proceeding.
Appearing on behalf of the defendant.
Now, this GA6 is the application by the plaintiff number 2 against or seeking order against the plaintiff number 1. Now, the plaintiff number 1 is not here. They have taken a time to file opposition on 5th of September.
What order?
What order? The property in question in the will is a Salt Lake property, which is our father's property, grandfather's property. Now, the plaintiff number 1 is my sister, my cousin sister. He's holding over to all the original title deeds, sanction plan, all original documents. And she doesn't stay in Calcutta. So I make this application. I make a letter.
Plaintiff number 2.
I'm the plaintiff, the co-executor, the co-executors. So the first
Who is the objector?
The application was filed by Anushka Kajaria, the plaintiff number 1, without informing me. He went ahead and filed independently. So I made an application. I am the other executor, the other brother. The gentleman, the Bhagirath Kajaria, left behind 2 sons. I am the son of one son, and the lady, Anushka, is the daughter of another son. So the lady went ahead and filed the probate application without informing me. So I made an application for simultaneous grant added. That has been allowed. So that procedure has been taken care of. I am now added. Thereafter, I make an letter to them that please give me inspection of the only property covered under the will, the Salt Lake property. I need the sanction plan, title deed, the corporation, the municipality is under urban development. So those documents, let us see those documents. It's under your custody. She is not replying to that letter. So my today's application only restricted to let an inspection be given to us and a joint bank locker be opened for safe custody. Mutual, both signatures will be there. It will be nobody's custody. We can return a photocopy. Original should be kept separately because under the will, both brothers, both of us fathers will get some portion or the other on the property. So because these are lease properties in Salt Lake.
Who is the defendant?
Defendant is
The son of the deceased.
Defendant is my father, I must say. Simply. Defendant is my father. It's a simple way of putting it.
Father is objecting for that.
I just saw, because once he's not here, Temple of Justice. We have heard this. Now, in the last matter, I really saw that. The gentleman in the box was barefooted. Then I asked my clerk, where is this? Was outside. So it's really a temple of justice with a god over here. and he's barefooted. And the bahar rakh ke aaya hai, mandir ka bahar hai juta. See, some people
in the village side,
Yes,
people
yes.
come to the dock.
Yes.
Even entering into the court, they will not come with a slip.
Yes.
Oh, yeah, in lower judiciaries.
They will not come.
The first time I saw only socks.
In one
I
case, I
got
remember
astonished.
in the murder trial. That is the 302 husband or something. I could not. The lady was the eyewitness of the case. She came in the dock, folded his hand, started rounding, and total case she has narrated.
With folded hands.
She folded hand. About half an hour, the total case
For the
of
incident that took place.
roaming there in the dock itself.
Oh, in the dock itself.
Totally started to.
Pious ladies.
So how you will cross-examine?
The lawyer, you are gone. You are gone. God is seeing. God is there. I'm not cross-examining. Curse.
And he was giving the evidence I find is
totally, mind is totally.
Those
from Bilaspur and.
yes, yeah, the surname,
Good
the
post. He was holding the good post, but still.
but nah, those areas are from the village. Yes, that. What? But the first time I saw unno mamla alochona
For the plaintiff.
general discussion. We are waiting for you. General discussion.
I'm sorry, Mullah,
Yes.
to keep you waiting.
You are appearing for
the plaintiff.
what the?
The
For
plaintiff
the
number
plaintiff,
one.
number one.
What is your application?
It's not my application.
So why you are not allowing?
It's not a question about allowing, my lord. I have to file my opposition. The only difficulty is opposition is ready, but the dealing advocate is suffering from cancer.
And nah, not from cancer. Yes, he's in hospital.
He
I
has been
know.
detected for cancer.
Whatever.
Very well, very well.
Bolo.
Let that be on record. What I'm saying is, I'll be needing a week's time.
That can.
I'll give the opposition. If they want to file a reply.
So appearing for the plaintiff number 1. So appearing for the plaintiff number 2. And so appearing for the defendant. Plaintiff number 1 filed an application being GS6. You are for the plaintiff number 1 GS6.
Plaintiff number 2.
Plaintiff number 2 has filed.
Yes, co-plaintiff.
Plaintiff number 2 has filed an application being GS6 of 2024. Counsel for the defendant, plaintiff number 1 prays for time to file affidavit in opposition. Prayed for extension of time to file affidavit in opposition. Let affidavit in opposition be filed
within a week, Lord.
Yes, because
within a week.
Direction was initially given in September.
Within a week. Reply, if any, there to be filed within a week thereafter. List the matter on 19th of December 2020.
We'll do it.
Extremely grateful, Lord. On that day, I shall answer all the points raised by my learned senior friend.
No, he has not.
No, I have not. I was giving some bias or something
I'm
else.
watching
We are discussing something else. No, today I saw for my own eyes. My God.
Extremely grateful.
Obligement.
Next.
I am for the plaintiff, my lord. My lord, GA2 is my application for appointment of commissioner, my lord. My lord,
Appointment of?
Commissioner. For examination of the witnesses. My lord.
Non-contentious? Non-contentious?
No, my lord. It is a
Which for the other side? Have you served?
Chandramala Mukherjee, learned advocate, is appearing for the other side, my lord.
Have you served?
Yes, I have informed them. Inform her. But
that you have served the copy?
Yes. I have served the copy. Yes, I have served the copy.
Why commissioner is to be appointed?
My lord, the witness is the wife of the testator, my lord, and she is very old aged.
She is the executrix.
Yes,
She's the executrix.
Yes, my lord. That's why I am.
What about the attesting witnesses?
Who are the attesting witnesses, my lord?
They are not examined. They filed affidavit.
Yes, my lord.
You will examine.
At the time of commission.
No, that's why I'm asking. Commission only with regard to the executrix?
No,
or with regard to the other witnesses also?
Other witnesses also, my lord.
Where they are residing?
They are residing at Calcutta, my lord.
But other side is not here. Other side is not here. I am fixing a date.
My lord.
Next week I am fixing. Inform the next date if they will not come.
My lord. But I am filing my suggested issues, affidavit of documents, and affidavit of admission and denial.
Issue not framed. So how the commissioner will be appointed, madam?
My lord,
without the issue, how you will examine the witness? On what point you will examine the witness? Give the issue.
Yes.
Yes, sir. On document नहीं रहने से यही प्रॉब्लम होगा. एक ही ऑर्डर है. They have not filed the issues. So first the issue is to be framed.
My lord.
As soon as appearing for the plaintiff, none appears on behalf of the defendant. Plaintiff has filed the suggested issues and affidavit of documents. Affidavit of document and affidavit of admission and denial
Yes, my lord.
by the plaintiff. Admission and denial of the document by the plaintiff. Let the same be kept to the record. The plaintiff has also filed an application being GA2 of 2023, praying for appointment of commissioner for examination of the witnesses on commission. Full stop. As none appears on behalf of the defendant, for the interest of justice, the case is adjourned. Let the matter appear on 11th of December 2024 for framing of issues and hearing of GA2 of 2023. The plaintiff is directed to inform the next date of hearing to the defendant and to file affidavit of service on the next date. It is made clear that on the next date fix, if the defendant will not appear, the suit will be proceeded accordingly.
I will intimate.
Next.
Grateful, my lord.
Item number 11 of the non-commercial text.
Please, Your Lordship, my lord. This
yes
review application. My lord, I will be the scope of review is very, very limited, and I will not try to stretch it at all, my lord.
Which order?
My lord, Your Lordship's order granting leave in an application under 13A, suit for eviction. Your Lordship will kindly have the memorandum of review, please, my lord. Others? 19 December 2023 order, my lord.
No summary judgment can be passed. Yes.
May I kindly come to, my lord? I'll just show Your Lordship's 2 paragraphs of
the other side.
My lord, Mr. Mitro, my lord, learned senior counsel, Mr. Mitro.
They are arguing within court number 33, steps senior advocate and Mitra is just.
Yes, well, Mr. Mitra's clerk was here, but Miss Agarwal and Miss... Yes, Mr. Mitra.
Yes.
Lord, may I take an advantage of him not being there? My lord, kindly see.
Yes.
There is
take note. Okay, take note.
Yes.
Yes.
My lord, the case of both the parties, the issue was this, my lord, whether the rent is a composite amount, 10,080 per month, which takes it into the provisions of the Transfer of Property Act, and therefore the protection under the Premises Tenancy Act is not available, or whether it is composed of 3 variable components. I'm sorry, one fixed component, which is the rent, which is about 6,000 odd, that is below the Tenancy Act bar, and 2 variable components, my lord, that is the municipal rates, occupiers' share of municipal rates and taxes, and monthly rent. This was the issue. Now, it was contended on behalf of the, although the rent bill is for 10,080, it was contended on behalf of the tenant that it is split into 3 components. One is the rent, which is 6,000, and the other are 2 components. And therefore, Your Lordship was pleased to hold that this is a triable issue which has to be remanded to trial. Now, if Your Lordship kindly sees, I want to show Your Lordship, my lord, why this cannot be an issue at all. My lord, may kindly have, my lord, paragraph, the arguments which were advanced, and Your Lordship will see the error apparent on the face of the record, my lord, if I may permit it to put it that way. Kindly come to paragraph 12.
Of the judgment?
Of the, yes, my lord, of the judgment. Your Lordship's judgment, my lord, internal page 5.
Yes.
Paragraph 12.
Yes.
Mr. Mitra submits that the last rent was enhanced to rupees 7,200 with effect from the month of September 2015. He submits that the plaintiff issued last rent for the month of February 2017 for a sum of rupees 6,900 as rent and rupees 1,380 as occupier's share of municipal tax, aggregating to a sum of rupees 8,280. He further submits that the plaintiff also issued a separate tax bill for the month of February 2017 for a sum of rupees 1,380, and it stops here. Your Lordship will see the pleaded cases rent bill issued for February 2017 comprising of these three components: rent, occupier's share of municipal tax, and cess, commercial surcharge. Now, my lord, kindly see the other arguments. I'm not troubling your lordship with, then this cannot be. He submits that there are several documents, etc. Now, kindly come to paragraph 15, please, my lord. This is where your lordship's judgment starts, my lord. Earlier portions were the arguments. Now, these are the analysis, findings with reasons, my lord. The documents appearing at pages 10, 11, and 12 of the application reveal that the plaintiff has raised rent or arrears bill of the suit premises from the defendant from the month of, kindly note this, my lord, February 2017 to November 2017 at rupees 10,080 per month. And at page number 13 of the application, the defendant has paid an amount of rupees 40,320. That is for the 4 months, my lord, by way of check to the defendant. Should be to the plaintiff, my lord. Relying upon the said document, the plaintiff raised the contention that the monthly rent was fixed at 10,080. The same was duly accepted by the defendant without any objection, and the same has been paid. So, my lord, your lordship has noted that it is from February 2017 to November 2017. That is the case. Last paid rent was of November 2017, 10,080 per month. Now, my lord, kindly come to, your lordship has quoted from paragraph 5 of the plaint. Now, kindly come to in contrary towards the bottom of the page. Yeah. In contrary, the defendant has enclosed a document at pages 43 to 46 dated 30th September 2015 and 28th February 2017. My lord, kindly see he pauses at 28th February 2017, does not travel up to November 2017, wherein it appears that the plaintiff has accepted the monthly rent for the month of September 15 and for the month of February 15 at 6,900, and the breakup is given as per the statement made in paragraph 11, specific case that the plaintiff is. So I'm not troubling your lordship with this. Now, my lord, kindly, I'm not troubling your lordship with the judgments. Kindly come to paragraph 19, please, my lord. In the present case, the plaintiff is claiming that the total monthly rent is rupees 10,080 and has relied upon the bills raised by the plaintiff for recovery of arrears, and the defendant has paid the total amount as rent, and thus the amount of rupees 10,080 to be treated as monthly rent. But now your lordship kindly sees, on the other hand, the defendant has relied upon the documents as mentioned supra, wherein it reveals that even in 2015 and 2017, plaintiff has paid the monthly, this should be defendant, my lord. There's a typographical error. Defendant has paid the monthly rent, occupier's share of municipal tax, commercial charges separately. This is where, my lord, I pause, and that is all I have to say, my lord. Your lordship has held here that the defendant has disclosed documents of 2017. The only document of 2017, my lord, which the defendant disclosed was of February 17. Only. The subsequent March, April, May, June, July, August, September, October, November, which the defendant has admittedly paid, which your lordship had occasion to consider and come to a finding that these are at 10,080 per month at paragraph 15.
Yes.
This is, my lord, where I beseech your lordship to kindly review your lordship's decision, because your lordship has proceeded on the premise in paragraph 19 that for entire 2017, the rent was split into in these components. Whereas your lordship has held in paragraph 15 that from November 17 onwards, the rent as 10,080 per month at page 13 of the application. And your lordship,
as per your submission, the defendants the document relied by the defendant is only up till the February 17th.
That is all.
February 17th.
That is all.
And this court has also considered till the number 17 which you have filed.
Yes, your lordship.
As per that document,
it is
February 17 to number 17, that is 1080.
1080. That is all. So after February 17, that is March 17 onwards, till November 17, the bill is composite 10,080. Till February 17, there was a split bill. Now, if your lordship kindly sees page 13, which your lordship has referred to at paragraph 15 of your lordship's order, that your lordship will find at page 31, please, my lord. These are the bills for the subsequent months, which have been duly paid. Kindly see page 31, please. Rent for the month of April 17, 10,080, May 17, June, July. Then your lordship turns over kindly, August, September, October, November. This your lordship had occasion to consider in paragraph 15 of your lordship's judgment. And then your lordship sees page 13 is at page 33, where there is one check of 40,320 for 5 months rent paid together, not split into components.
Page 31 to
I'm sorry, my lord, page 31 to 33.
33.
Yes. So this is 13. What your lordship has seen, these were the bills which 10, 11, 12, your lordship sees documents appearing at pages 10, 11, 12 of the application are, my lord, my pages 29, 30, 31. I'm sorry, 20, 30, 31, 32. 10, 11, 12 equal to 30, 31, 32. Where your lordships find composite amount. There is no breakup. There is one single amount mentioned as rent. And then at paragraph 15,
what was the
now the defendant's document, my lord, which your lordship had occasion to consider.
what was the this if we go to that also, then
Yes.
so what is the split of the tax and others?
Well, there is no split. It is one composite rent. That was the whole issue. Whether it is split, because that is what your lordship has been pleased to hold. Now, if your lordship sees your at page 10, please, my lord.
Page 10 of order?
Of the order, please, my lord.
Yeah.
Thus, this court finds that the defendant has raised the triable issue whether the rent paid by the defendant amounting to rupees 1080 is the total monthly rent.
Correct.
Or it includes the occupier's share of municipal tax and commercial charge. So this is the issue which your lordship was pleased to hold on assuming that after February 2017 also there is a breakup. There is no breakup. After February 2017, as your lordship has held at
That's why this court maybe 2017 after March to November 2017, this court has not considered your document, whatever it is.
Your lordship has considered, which at paragraph 15.
Paragraph 15, but at the time of
yes, that is why, my lord,
in the findings, this court has not taken into consideration. But last finding, this court is of the view. If we go by the 1030 and 1080,
yes, ma'am.
So whether it is the only rent or whether it is including the tax and all
that is why your lordship has, because your lordship was of the view that this is a split amount. It is not the rent component is something, the tax is something. That is why your lordship has chosen not to follow division bench judgment of our court, which is at page 16, please, ma'am, paragraph 16. That is why, because your lordship was of the view that the rent bill which I am raising is in 3 parts. May I just trouble your lordship with what the defendant showed your lordship, my lord? Pages 43 to 46. At paragraph 15, your lordship has referred to of the judgment. In contrary, the defendant has enclosed a document at pages 43 to 46, dated 30th September 2015 and 28th February 2017.
Page?
Yes. Now, this is at pages 95 onwards, my lord. Kindly see, my lord. Page 94, please, my lord. I'm sorry, 93. Where your lordship will find the breakup which was there in 2015, but then this was given a go away.
That's why 1380.
Yes, 1380. And that your lordship sees the period September 2015. Then your lordship sees September 2015 surcharge. And then the rent. Now this is where, my lord, my learned senior friend, stopped at February 2017. Your lordship sees this. Now here the rent was divided into 3 parts. At page 95, my lord.
95 is?
February 2017.
February 2017.
Yes. 6,900 on account of rent. And 1380 on account of occupier share of municipal taxes, which is 8280. And the next page your lordship will find charges for surcharge, 1380. So the rent component, by dint of this document, it was submitted that the rent component is only 6900, and it is below the slab of 10,000. Now, so that is why your lordship has noticed that this is so in February 2017, and in the previous part of paragraph 15, your lordship has noted that in November 2017 it is actually 1080. There is no bifurcation. The rent is one block.
So that's why in the February, November 2017 or since then,
yes,
whether it is the combined or it is to be decided in trial.
So, that your lordship has noticed the documents. Kindly come back to.
That's why I have noticed the document. But where is the document? It is only the rent, not the tax and commercial charges.
Yes, that is the bill itself, my lord, which your lordship has found at page 10, 11, 12. Kindly see page 31. Page 31, rent for the month of.
Correct. So
there is no.
That's why I think put the question also to show me the tax has been paid separately.
He is not required to pay any tax separately, my lord. It is not his case.
Not he. Whether you have paid the tax, whether they have paid the tax on this.
I beg your pardon, my lord.
This is you are telling that this is the only rent. So what is about the municipal tax and all these things?
He does not say, my lord, that he is liable to pay anything else. The defendant doesn't say that I have to pay anything over and above this. And he has paid only this. He does not say, my lord, that is why your lordship will see, my lord, my learned senior friend submissions. That is why I showed your lordship those two paragraphs. Paragraphs 12.
12.
Plaintiff issued a separate tax bill for February 2017 for a sum of 1380.
Correct.
After February 2017, I do not charge him separately for tax. Now all that is charged is rent. That is why, my lord, with the greatest of respect, my lord, there is some inconsistency between your lordship's findings at paragraph 15.
It is not liable to pay the tax.
No, not anymore, my lord. Because it is all combined in my rent. He doesn't say he's liable to pay tax separately. I would have understood, my lord, if my learned friend would have said, for the tenant would have said that I am liable to pay tax separately. That is also not his case. And he has not paid. Because up till November 2017, your lordship has come to a finding that this rent bill was honored when he paid that 43,000 check of 43,000. That also is your lordship's finding. That these bills up to November 2017 have been duly paid.
Yes.
At page 33, your lordship will find his check, and your lordship, this is paragraph 30, page 13, which your lordship has made a finding on at paragraph 15 of your lordship's order.
Yes.
The bills at page, my lord, for the bills for 40,320 at pages 32 have been paid in full at page 33.
Yes.
So that is why, my lord, I say, with the greatest respect, that at page 15 and the findings at 15 and 19, where your lordship has in 15, your lordship has come to a clear finding.
That's correct.
Yes.
I know. Only when this court has lastly, at the time of finding, it is found that whether this is the total rent or it is including the tax. How the court can in the chapter 13 application can decide.
Yes. May I just
earlier you have paid, now you have raised the combined bill and you are telling that here now I am not claiming the tax.
Yes.
So that is a matter of trial.
Yes, that is what your lordship has seen at paragraph. Kindly come to paragraph 16, please, my lord. That is what our court has held, but your lordship was of the view that this judgment will not apply because the last paid rent is split into 3. That is why your lordship held.
This document was not before the in this case.
No, same documents.
No, in this case that was not considered.
Kindly, may I place just paragraph 16 once, please, my lord? The plaintiff had relied upon the judgment reported in so-and-so and submitted that the Honorable Division Bench of this court in the similar matter held that the tenant had paid the rent of rupees 10,080 by check and asked the landlord to issue rent receipts. The landlord responded to the said payment by issuing the rent receipts for the said month, and there was no ambiguity that the rent for the month of April 2015 was accepted and agreed at 10,080 per month. This is my last rent bill also, and that is the payment. Therefore, exceeds the limit set out in Section 3F of the Tenancy Act, and thus the premise is not governed by the Premises Tenancy Act. In the present case also, the total amount is 10,080 per month. The plaintiff is claiming the said amount as rent, but in contrary, now Malad kindly see, but in contrary, the defendant has disclosed documents to show that they used to raise bills for rent, occupiers' share of municipal tax, and such charges for such charges on the Calcutta municipal tax. In the case relied by the plaintiff, the said fact was not before the Honorable Court, and thus the fact of the present case and the case relied by the plaintiff is distinguishable. So your Lordship has gone on the rent bill of February, which is not the last rent bill. The last rent bill is the other bills for the subsequent months where there was a composite rent bill without any bifurcation.
Okay.
That is my response. May I just? And Malad, this, kindly see 125 once, please, Malad, also. This is their document. Yes. Page 125, your Lordship will kindly have. This is the balance sheet of the kindly see the under the heading other expenses, note 15, under the expenses, other expenses rent is a composite amount. This would also show that they also treated the rent as a composite.
Where?
Last but one entry under block 15, please, my lord.
Page 125.
Other expenses your Lordship has, my lord. Rent your Lordship finds.
Legal fees.
Yes, after legal fees, my lord, about last but one. Last is telephone and then there is rent.
Telephone rent.
Yes. So one amount.
1,23,000.
Yes. It's a composite amount, my lord. Single block. It is, even they don't treat it as payment on different heads, and which is also at page 134. 134 is for 2018 because your Lordship has seen last paid rent was in November 17. So in 31st March 2018, rent is again one block, my lord, 92,160.
So whether this document is in the application was there?
Yes, my lord. This was it was disclosed by a separate letter 3 years before the application was filed. My lord. 9 December letter is there, my lord. They have received it 9 December 2020. This document was disclosed. And it is their document. They cannot.
No, in the at the time of hearing, it's not placed. It was not placed.
Yeah, in the written notes of argument was also there.
It was not placed.
In the notes of argument.
My lord, Mr. Gupta says it was placed, and it's
No,
a reference is there also in the notes of arguments. But my lord, this is their document. I am not troubling your lordship, my lord, because new documents, even in the review stage, even if a new document is brought, your lordships entertain a review. So even if it was not there, I take it, my lord, at the highest that it was not there. Now, my lord, they cannot, my lord, turn away from their own document at 134, where it shows a rent as a composite block.
Okay.
My lord. The first point, my lord, which I take is this, my lord, that this review is not maintainable.
Why?
First of all, my lord, the review has to be within the parameter of Order 47, Rule 1. My lord, my learned friend in the grounds have not made out any of the grounds, my lord, which would permit them to invoke the jurisdiction of review.
What are the grounds, madam?
The review, my lord, kindly see the grounds which they have made out. The order dated 19 December 2023 suffers from an error apparent on the face of the record and is contrary to the settled principle of law. It is not elaborated as to what error my lord has committed, which is apparent on the face of the record.
Round
Then
2,
second,
your
my
lordship
lord,
will kindly. Round 2.
I'll come to that. I know that. There an error apparent on the face of the order dated 19 December 2023. As the Honorable Court has considered rent bills prior to February 2017 for arriving at a conclusion instead of considering the rent bills on and from February 2017 till November 2017. when the last paid rent was rupees 10,080, which were duly acknowledged and accepted with acquiescence by the respondent by putting their seal and signature on the same and by making the payment of the same by one singular check of rupees 10,080 per month. There was no bifurcation of the said amount of rupees 10,080. The entire amount was paid by the defendant as rent. Lord, this contention, my lord, your lordship has elaborately dealt with in your lordship's judgment, starting from paragraph 11 to paragraph 15, my lord. And your lordship, kindly see one document which your lordship has quoted in your lordship's order is page 30 of their document, my lord. 30.
Yes.
Kindly see page 30. Rent oblique area bills.
That's why.
That's why your lordship said it will be decided at the time of trial.
No, that's why what they are in the review application, what they are claiming.
I love it.
I'm sorry, my lord.
Yes, continue.
What is falling from production? Let me hear it when I sit down.
No, your lordship.
Get my
No,
pen
please,
back.
no problem. Anybody, no problem.
My senior friend has come, my lord.
Yes.
My lord, I could not find any reason as to why the review application should be made. Review application cannot be made just by way of an appeal. If you have agreed, go up for the appeal court. How can the review application be maintainable? Order 47, your lordship kindly sees, there is no ground whatsoever. It's a matter of re-argument. My learned friend re-argued the matter. My lord, your lordship has been pleased to consider the actual bills which have been, my lord, subsequent one, which my learned friend is relying upon. They are, my lord, they have been made for the purpose of filing the suit. Together, your lordship looks at those. Kindly compare this with the bills which you have been issued.
Page 95.
And my lord have been paid.
No, they are not denying only their contention. Mr. Thakkar has raised the contention. What he has submitted, what the document is available, and this court has recorded till February 2017, 6,990 rupees, and prior other two are the segregated.
Absolutely.
Correct. Yes. So they are telling that after February, they have paid the rent till the month of November 2017.
Very good.
And that they have raised the bill, including 10,080, and you have paid the total amount as a rent. They have raised the bill as a rent, and you have paid the bill as a rent. But this court kindly come to they are only harping upon paragraph 19.
Paragraph
19. Page 9, inner page 9 of my judgment.
Yes.
9 of the judgment. The present case, the plaintiff is claiming that the total monthly rent of previous 10,080 and has relied upon the bills raised by the plaintiff for recovery of areas, and the defendant has paid the total amount as rent, and thus the amount of 10,008 to be treated as a monthly rent. But on the other hand, the defendant relied upon the document as mentioned supra, wherein it reveals that even in 2015-2017, the defendant has paid the monthly rent, occupiers shares and municipal tax commercial separately. The defendant has made a specific defense so and so. So they are telling that I have taken till 2017. So 2017, this court has taken into consider because what the document you have relied upon, that is only up to the February 2017.
My lord, it is, if, my lord, I could have understood if the amounts had been different. If your lordship looks into the documents, this 10,000 and odd,
correct.
This is adding, my lord, these three things which had been, my lord, previously. So these two bills which have been presented to your lordship, saying that 10,080 consists of rent only. This is only for the purpose of when is the suit filed? Give me the date of the suit filed.
December
2017.
This is, well, what happened is the evidence was created for the purpose of filing the suit.
No, that's why they're telling now kindly come to the page 31 and 32. 31, 32, 33.
31, 32, 30, yes.
Of the application, GA.
Yes, yes.
31, they are telling that they have raised the bill of the total of 10,000, and page 33, 40,320 was paid by you. That's why this is a total rent, not the segregation amount.
Right. This is the question issue which has to be gone into at the time of hearing of the suit. It's a judgment upon admission. It is one has to be, your lordship has been, the judgments have been, I rely upon the judgment placed by my learned friend. These judgments, 6 or 7 judgments have been placed by him. These are, I rely upon those judgments only.
That's why Mr. Thakare is smiling.
Yes, that's why he's hesitant in putting forward his case. You are not hesitant. No. But my learned friend junior is not hesitant. But this learned senior is. Well, I submit to your lordship this, that these bills which have been prepared for the purpose of filing the suit. Throughout, my lord, your lordship has been pleased to see this evidence is on record. One has to go into the box for the purpose of proving it. Otherwise, it has to be, my lord, clear, specific case of admission. Well, admission of liability cannot be like this. Therefore, I submit to your lordship, there is nothing which will entitle my learned friend to come and pray before your lordship for review of your lordship judgment. The judgment has been delivered by your lordship after considering all this. These documents were there before your lordship. You considered this. After considering this, you have delivered judgment.
The contention is that is the error appearing on the face of record. That document has been considered.
No. These documents, there has been no error on the face of the record. My learned friend is asking for eviction. Eviction from a particular property in which I had been living for a long time. Now he has come up with a case with the 3 or 4 documents. They are all just before the suit file documents, prepared for the purpose of preparing the base, the basis for my lord filing the suit. I am showing, my lord, throughout the conduct of the parties. This is what I am going to lead my evidence on. And when my learned friend's client goes on into the box, I shall be personally cross-examining it to find out as to what is the true state of affairs. And this opportunity, your lordship would be pleased not to deny me on the basis of the cases cited by my learned friend.
Yes.
My client will not step into the box if learned senior counsel is going to cross-examine. But I don't think that need will arise at all. First of all, Malad, this was not a case of judgment on admission. It was a case of summary judgment. Number 2, Malad, what my learned senior friend says about the past bills, they are irrelevant because your lordships have held, and in the judgments which your lordship has distinguished, it was the last rent bill, and your lordship has been pleased not to accept that judgment because your lordship's view was that last rent bill is itself in 3 parts, which is a clear finding in paragraph 19, which is, my lord, contradicted by paragraph. This is, my lord, the clear error which is apparent on the face of the record. Kindly come back to page 16, please, my lord, where your lordship has distinguished the division bench judgment in Rajshri, my lord. Kindly come back to page 16, please, my lord.
Page 16.
Paragraph 16, page 7.
Yes.
Landlord responded to the said payment by issuing rent receipts for the said month, and there was no ambiguity that the rent for April 2015, which is the last paid rent, was agreed at 10,080 per month. It's the same premises, same landlord. Only the defendant is different. The lordship will see T. Thompson was the same landlord and same premises and same rent. Therefore, exceeds the limit. In the present case also, this is where your lordship's distinction starts, my lord. The plaintiff is claiming the said amount in rent because on the basis of the last rent paid bill. But in contrary, the defendant has disclosed documents to show that they used to raise bills for rent, occupier share, municipal tax, and surcharges on Calcutta municipal tax. In the case relied by the plaintiff, the said fact was not before the honorable court. That is why, my lord, paragraph 17, your lordship holds that whole of the last bill up to whole of 2017 is split. That is where, my lord, the greatest of respect, my lord, your lordship's finding in paragraph 15, where your lordship has noticed correctly, with the greatest of respect, that November 2017 and prior thereto, 6 months, the last rent was at this amount only.
Yeah.
The second, my lord, where my learned senior friend says,
They are going in the case. Well, I respectfully submit to your lordship the review application. My lord.
I am not saying yes.
Yes.
my lord, I will rely on the judgment which has been cited. My lord, kindly take their affidavit in opposition months, please, my lord. Where their affidavit in opposition, where after analyzing the entire gamut of decisions placed by the Honorable Supreme Court, they've summed up what is the gist.
Page number?
Page 6.
Yes. Yes.
Your lordship has the affidavit on opposition once, please. I'm so sorry. My lord, just to, since my affidavit in opposition, my lord. It's a very short affidavit, my lord.
In this?
Yes. The affidavit in opposition to the stay of, it's an affidavit of Manohar Kumar Kankaria of June 2024. It's here. In এইটা পুরো লটা সেট আউট আছে, তাই বলে কোনো জাজমেন্ট আনিনি। Yes. Lordship kindly comes to page 16, please, my lord. Page 6.
Yes.
The gist of the aforestated decisions is that, where they've summed up after analyzing all the decisions of the Supreme Court, a judgment is open to review inter alia if there's a mistake or an error apparent on the face of the record. My lord, this is where I say, my lord, there's an error apparent on the face of the record. In the finding, in the conclusion, your lordship has proceeded as rent. The last paid rent was not a composite amount, but was split into 3. Then, my lord, kindly come to judgment pronounced by the court is final, and departure from that principle is justified only when circumstances of substantial and compelling character make it necessary to do so. Here also, my lord, I say there is a compelling reason to differ, to review this judgment, because your lordship has distinguished a binding decision of our court on the ground of a factual difference when no such factual difference exists. That is why the compelling reason. And then, my lord, error which is not self-evident has to be detected by process of reasoning. There's no process of reasoning required here, my lord. I'm not re-arguing the matter. I'm showing your lordship only from the paragraphs of the decision under review. Kindly take once, my lord, what Raj Production, which is there in paragraph 16, which your lordship has been pleased to distinguish. Kindly take Raj Productions once, please, my lord. Kindly have paragraph 11.
Yes.
On the conspectus of the aforesaid proposition of law, let us see whether the defense of the appellant justifies that the portion of the municipal tax or the surcharge is not a component of the rent, nor can be regarded as an integral part of the rent for the purpose of determining the quantum of rent, so that it can fall outside the purview of the exempted clause. As already discussed, kindly see, as already discussed, 3 components, even if my learned senior friend's case is correct, as already discussed, 3 components constitute the payment per month at the instance of the appellant. Our attention is drawn to the rent receipts issued by the respondent for the months of January and February 2017, which indicate that the sum of 6,900 was basic rent, identical, and a sum of rupees 1380 was the occupier's share of municipal taxes, totaling to 8280, which is admittedly below the cap of 10,000 as indicated in clause F of section 3. It is apparent from the record that the tenancy was created many years before, and the occupation of the appellant in respect thereof is more than decades. What my learned senior friend said, I will show evidence dating back to decades. The rent which was initially fixed might have been enhanced from the time to time, either by virtue of the terms and conditions incorporated in the agreement or by mutual agreement between the parties. The rent which was fixed at the time of creation of the tenancy may not be the same by passage of time. After the month of January and February, we could not ignore the correspondence exchange within the parties and the appellant in the month of June and subsequent thereto. By virtue of a letter dated so-and-so issued by there's a clear stipulation that they're including the rent and the areas. Now kindly see, identical here. There's a clear stipulation they're including the rent and the areas which became due from September 15 to be accepted by the landlord. It is clearly indicated in the said letter that the rent at the rate of 10,080 for the months of April 2015 and May 2017 are also enclosed by virtue of checks being issued in this regard. Subsequent letters would reveal that since the rent February 2017, which was paid by the check, was not in cash and the period of validity has expired, a fresh check was issued. Subsequent letter, the appellant that the rent for the month was 10,080 paid by a check. Landlord responded to the issued rent receipts. There is no ambiguity that the rent for the months of April to June 2017 was accepted and agreed at the rate of 10,080. And then kindly see paragraph 12, it is from the aforesaid facts, it may be that at one point of time the rent was below 10,000. But at the time of determining the tenancy, appellant unequivocally, clearly and explicitly admitted rent is at the rate of 1080 per month. This is the check which your lordship has seen. So it is the last paid rent. The bill is there for the last paid rent at 1080. Identical facts here. Same breakup was there earlier. But when the rent component is now a fixed amount, then it is the last paid rent which has to be seen. This is all that is there, and that is why your lordship, I am just showing why your lordship has not followed this judgment. Is your lordship has said this is distinguishable because there are separate rent bills which were shown up to February 2017.
That is not the reason.
Kindly see the reasoning at paragraph 16, please, my lord. Kindly come back to paragraph 16.
Kindly come to
the plaintiff is in the present case also the total amount of rent is rupees 1080 per month. The plaintiff is claiming the said amount as rent, but in contrary, the defendant has disclosed documents to show that they used to raise bills for rent, occupiers' share of municipal tax, and charges for surcharges on CMC. This is the distinction which your lordship has noticed, that is up to February 2017, no dispute. In the case relied by the plaintiff, the said fact was not before the Honorable Court. It was very much there. The earlier bills were for the breakup. Your lordship has seen same amount, same breakup. And thus the fact of the present case is distinguishable. Your lordship has distinguished division bench decision on the factual matrix.
30 and 95.
On the factual matrix, the decision has been distinguished, which is correct up to February 2017. But once a composite rent bill is raised and the composite rent bill is paid, that is the end of the matter, in my respectful submission. Then the previous conduct, which was here also in Rajshri, previous bills were there for breakups.
There is a difference. My lord, what your lordship noted, kindly, my lord, come to the Rajshri's judgment once, my lord. Kindly read it with me. These have been, exactly this has been argued. My learned friend was not there. Kindly can see the difference between us and what difference, my lord, your lordship was pleased to take note of. Page 11 of Rajshri.
Paragraph 11.
Page 11. Page 11, the middle of that page.
Page 11.
Page 11. Paragraph 11 তো নেই?
রিপোর্টেড আছে কি আপনার?
Unreported code copy
আমি
আছে।
আপনাকে রিপোর্টেডটা
তাহলে
এটা আপনি নিতে পারেন, রিপোর্টেডটা।
এটা কি রিপোর্টেড দিয়েছে?
আমি জজ সাহেবকে
আচ্ছা, আমি
we cannot ignore it. এই আপনি এটা দিচ্ছেন। এক মিনিট।
after the month.
On the conspectus, it is where your paragraphs.
Yes. My lord, kindly come to the paragraph 11. My learned friend very kindly points out. This is the paragraph which starts. I'm not troubling your lordship with the first part of the paragraph. Kindly come to paragraph 11. Yes.
On the conspectus.
Yes. You kindly come to 5 lines from the bottom of that page.
Yes.
After the month of January and February 2017, we cannot ignore the correspondence. Kindly note this. We cannot ignore the correspondence exchange between the appellant and the respondent in the month of June and subsequent thereto. That means June 2017. By virtue of a letter, kindly note this. By virtue of a letter dated 2nd June 2017, issued by the appellant, there is a clear stipulation. Issued by the appellant, there is a clear stipulation that they are enclosing the rent. They are enclosing the rent and the arrears which became due from September 2015 to be accepted by the landlord. It is clearly indicated in the said letter issued by the appellant that the rent at the rate of rupees 10,080 for the months of April 2015 and May 2017 are also enclosed by virtue of the checks. The subsequent letter dated 20th July, these letters correspondence emanated from the the tenant himself. And that is what really impressed the court. Would reveal that since the rent for the month of February 2017, which was paid by check, was not in cash and the period of validity of the check has expired, a fresh check for the rent for the month is further enclosed, which indicates a sum of rupees so and so. In our case, it is a document issued by my learned friend, creating evidence for the purpose of getting me evicted. Kindly note that these letters, which are there, the June 2017, and my lord, here in our case, the first document in which they have put 10,080 is their document in the month of August. They have become wiser. There's no letter. In our case, there is no letter issued by the tenant saying that I am paying rent to you or 10,000. This is what, my lord, impressed the learned judge. In the division bench, this is what, my lord, after the month of January and February, we cannot ignore the correspondence. This kindly see exchange between the appellant and the respondent.
The letter dated 2nd June 2017 issued by the
Issued by the appellant, that means the tenant.
The tenant.
Tenant. There is a clear stipulation that they are enclosing the rent and the arrears. So, my lord, it is that this kind of letter was not there from our side. That is the difference. And then my lord, there is subsequent letter of 20th July. In other words, my lord, what had been happening is this: in that particular case, the tenant himself had been writing that I am paying you rent at 10,080. And that rent was being accepted, not in one letter, by correspondence. That is why the court says we cannot ignore the correspondence. The correspondence made the difference. In our case, there is no such correspondence as all that. You have raised the bill and I have paid the bill. You have taken advantage of my bona fides. You have taken advantage of my goodness. Well, I am respectfully submitting to your lordship, this is a really malafide attempt to create evidence for the purpose of getting rid of me from the property.
So then why the check has been issued?
Yes, my lord. Page 33, which is your lordship's finding at paragraph 15. Paragraph 15 of your lordship's judgment. Why the check was issued? It's even better than letter.
Check has been issued on the basis of what has been submitted by them. That does not mean I am accepting 10,080 as the rent. Because 10,000, had there been no basis for it, then I could have understood this argument my learned friend is making. The basis of 10,080 is the rent, occupation, and my lord, these charges together. There is a course of conduct. And this has to be explained, my lord, at the time. You are trying to get rid of me from the property. And your lordship has been pleased to consider this. It is not that your lordship ignored this. It is not that that particular division when judgment was not placed before your lordship. You considered it and you said that this is the distinction. And this distinction I made at that point of time. That there was corresponding letter written by the tenant saying that I am going to pay rent to you at 10,080. That kind of a letter is not there in my case. That is the distinction.
And if we add the rent, corporation tax, and commercial surcharge, it will come to 10,080 only.
And my lord, 10,080, my lord, is not something my learned friend has invented from somewhere. It is a conglomerate of rent, occupation charges, and my lord, commercial surcharge. Together, 10,080, that very 10,080 has been put there. I have never written a letter that 10,080 is the rent. You have raised a bill, I have paid the bill. You have taken advantage of my goodness and now you have filed a suit for eviction. This, my lord, should not be permitted. Yes. And you are coming by way of a review. If you are aggrieved, you should have gone up by way of an appeal.
Yes.
This is not a case for
kindly only see it's what taking everything by my learned senior friend to be correct. Kindly come back to Rajshimala, just 1 or 3 lines above paragraph 11. Kindly come to that page, just above paragraph. Paragraph 10.
These things were done.
Yes.
The only difference is, my lord,
the proposition of law as
advocacy of my learned friend.
Oh,
that's the only
thing. Nothing of that sort, my lord. I'm learning at my learned senior friend's foot, my lord. The proposition of law as enunciated in the aforesaid report exposes that the property tax, kindly see, my lord, paragraph 10. Everything which my learned senior friend says to be correct, even then Rajshri covers it. Proposition of law. The proposition of law as enunciated in the aforesaid report exposes that the property tax cannot ipso facto come within the purview of the rent, but depends upon the intentions and the conduct of the parties in relation thereto. It can be safely said that there is no uniform principle that the property tax shall be outside. Kindly see, property tax shall be outside the purview of rent, but it depends on the facts of each case, which can be conceptualized from the examples.
But judgment of the Supreme Court of the AIH, the property tax cannot be included as a rent.
No, my lord, kindly see that also your lordship has considered. Kindly see. Kindly see. Kindly come to this, please, my lord, at paragraph 17.
17 of?
Yeah, 17 of your lordship's decision. Kindly see, your lordship, this kindly see why that is not relevant, and that is why your lordship has not followed it also. It was cited, but your lordship has not followed it. Your lordship has distinguished Rajshri on facts, not on the law. Mr. Mitra relied upon the judgment reported in so-and-so EIH versus Nadia Virji and submitted that the Honorable Supreme Court has decided the issue whether share of the municipal tax due and payable by the tenant under Section 230 of the CMC Act and Section 58 of the West Bengal Premises Tenancy Act shall be included within the expression rent. Or in other words, the share of municipal tax due and payable by the tenant can be said to be a part of the rent of the premises let out, and held that merely because for the purpose of recovery of tax from the tenant, such tax apportioned can be recovered as rent, such tax apportioned cannot become a part of the rent of the premises which is tenanted. So this is a distinct liability, not in my case. He submits that even under 230 of the Municipal Act read with 5A, the tenant is liable to pay tax separately or half of the amount of tax now statutorily liable to be paid. The same cannot be recovered as areas of rent because such tax is to be treated as rent for the purpose of recovery. The same cannot be. This is the ratio that it cannot be recovered as areas of rent. But that is exactly, my lord, after Nadia Virji has been considered by this division bench. Kindly see 2023 because this is of 2023, and your lordship has been pleased not to agree with my learned senior friend's submissions on this. Kindly see paragraph 9 of this division bench of ours, my lord.
Yeah.
The significant difference between the provisions, I'm not troubling that. Kindly come to about 10 lines from the bottom. It is sought to be contended. Your lordship will see exact same argument. It is sought to be contended by the appellant, who is the landlord. I'm sorry, the tenant, that such being a statutory liability or the obligation imposed on the tenant, even if the agreement or otherwise does not provide the payment of the said tax, it becomes a statutory liability and therefore cannot be kept within the purview of the rent. In fact, the reliance is placed upon a recent judgment of the Supreme Court in EIH Nadia Virji. An argument was advanced, so and so. It was thus contended that by virtue of the aforesaid provision, property was not included. Then Nadia Virji is considered, and then comes paragraph 10. After considering Nadia Virji, the proposition of law as enunciated in the aforesaid report exposes that the property tax cannot ipso facto come within the purview of the rent, but depends upon the intentions and the conduct of the parties in relation thereto. It can be safely said that there is no uniform principle that the property tax shall be outside the purview of rent, but it depends on the facts of each case, which can be conceptualized from the examples quoted in the aforesaid passage. It has been held that if the parties have agreed that the amount shall include the tax, then in that event, the tax component will become a part of the rent. So even if my learned senior friend says this includes tax, if the parties have agreed, the last rent bill is inclusive.
It is a part of the rent. It cannot be said as a rent for the consideration of the.
No, kindly read further, minute. Kindly, if it has been held that if the parties have agreed that the amount shall include the tax, then in that event, the tax component will become a part of the rent. So it is no longer split. There is one composite bill, it includes the tax, it will be treated as rent. Thus, there is no scintilla of doubt in our mind that every component in respect of the enjoyment of the premises payable to the landlord may not come within a definition of rent, as it depends upon the intention and the conduct of the parties in relation to the tenancy having been given. An amount, or this is where the test is, my lord, an amount or a component which is variable in nature cannot be regarded as a component of the rent, even if it is paid along with the basic rent. See, there has to be, if it's a variable component, it cannot be decided because it changes with time. Here, my lord, there is no variable component. Learned senior friend has shown your lordship, it is fixed for throughout the years.
Okay.
So that is why, my lord, your lordship was pleased not to follow, not to, Nadia Virji had no manner of application. Your lordships have only been pleased not to follow Rajshri because of the factual distinction which your lordship has drawn in paragraph 16, which with the greatest of respect, my lord, does not exist.
Okay.
1080 municipal tax no.
That's all.
Those are my responses.
Well, after my lord, my learned friend has put on this gown, he has become more eloquent.
High sound.
Yes.
No, my lord. Kindly do not take me amiss, my lord. I started, my lord. I'll make very brief arguments.
Very brief argument. Complete re-argument, my lord. This is not permitted. Your lordship has considered
I have shown your lordship, my lord, from his grounds of review, my argument is
Calcutta, Gujarat society, my lord, that has been, your lordship has been pleased to record that. That says so. That rent means rent. It does not include, my lord, corporation tax and other things. Your lordship is concerned, my learned friend should try his luck in the suit. Then, my lord, I shall meet him there.
He has taken
I
out
would much
another
rather meet him there.
Or in
Yeah.
colder climes, my lord. Try my
December.
luck in colder climes. December, Delhi is very cold.
Well,
You have filed another application for recovery of 2 crore 46 lakhs. Right.
So and so appearing for the plaintiff, so and so appearing for the defendant. The plaintiff has filed the application being GA1 of 2024 for review of the order passed by this court dated 19/12/2023. Appellate side, है ना भी? 19/12. Hearing concluded. CAV. Yes, thank you.
Grateful.
Okay. Yes, next.
Number 23.
Not today. Next.
Number 24.
Hello, this my application is a non-contentious matter. The father executed a will and is a non-contentious matter. Father executed the will and bequeathed the entire property to her only daughter, his only daughter. The will has been proved by the affidavit of attesting witness of wife. So everybody consented. Similar kindly and the probate. Nothing is there.
Who has consented?
The daughters died. Daughter's legal heirs has been consented.
Have you rectified the defects?
Yes, Milord. All the defects have been rectified, Milord.
Where is the report?
Milord, report must be there, Milord. But this is a non-contentious, Milord.
That's correct. But altogether 10 defects are there. Whether the defects have been cured or not.
Then, Milord,
record an order. So and so appearing for the petitioner. Petitioner has filed the present application being PLA 200 of 2022, praying for grant of probate of the last will and testament dated
20th October 1993.
20th October 1993. Huh? 28.
20th.
20.
20.
October 1993. 1993.
Yes, Milord.
1993. Full stop. It is fine from the record. Altogether, 10 defects have been marked through pencil by the department. But there is no report whether the petitioner has rectified the defects as noted by the department. This is not the only case where the court has found that the department has not submitted any report with regard any report whether the petitioner has rectified the defects. Accordingly, the registrar testamentary and insolvency is directed to issue a circular upon the department to submit a report when the file is placed before the court, whether the defects pointed on the application through pen or pencil in the back paper is rectified or not. It is very difficult for this court to ascertain whether the report has been rectified or not. Accordingly, it is adjourned. Let the matter appear on 12th of December 2024. The department is submitted to submit the report whether the petitioner has rectified the defects or not.
I'm grateful.
Yes, my lord, I am praying for not today.
Not today. Yes, come. Last. Not today. Call the appellate.
Before your lordship takes up the appellate side matter.
What can be done?
No, my lord,
Property is coming, the matter is called.
extension of interim order. That's why. This is the order by which, my lord, the date. This is the order.
Who is for the other side?
My lord, Mr. Dotto was appearing for the other side. It is listed in your lordship's list today, my lord.
दो order किए?
$1. 98.
Yes, my lord, my lord. Item
Lordship,
number 90.
I am for appearing on behalf of the defendant. Landed Dotto sir was appearing on the last date, but he is not available today. Kindly adjourn the matter.
No.
What about the interim order?
Only for
Interim
extension.
order is going to appear expire today. So let it be extended. Let
It is to be vacated.
No, that she's saying.
Let it be extended.
Item number?
98.
98.
Item number 98. So appearing for the plaintiff, so appearing for the defendant. Counsel for the plaintiff, though the matter is not reached up till the serial number 98, accordingly, the counsel for the plaintiff has mentioned the matter as the interim order granted earlier is going to be expired today.
27.
Expired today?
Yes, my lord, 28th. The order of 7th November records the date, my lord.
Going to be expired today. Full stop. Counsel for the defendant submits that the arguing counsel is not well and prays for adjournment. In view of the submission made by the counsel for the respective parties, the interim order granted earlier is extended till 8th of January 2025 or until further order, whichever is earlier. Let the matter be remain in the list.
May I disturb your lordship for 1 minute? I was item number 27, my lord. I was hoping. Item number 27, I was hoping the non-contentious matter 1 amendment application, my lord.
Now for my appellate side.
There is also one more matter, 32.
Lordship and 31 also, Lordship. It is also not.
My appellate side.
Yes, Lordship.
4 p.m.
Very well.
If my lord takes up the appellate non-contentious matter in any, I have seen my lord.
I will after December. Next week it will be fixed. 12:30 on 12:30 to before lunch. All the testament will be taken.
There is a notice.
So that you persons all will get the opportunity. 12:30 to up to lunch, before recess.
That will only be 45 minutes, mother. Will you kindly make it a little.
Let us see idea. Then if it will increase, I will increase the time. Because other determinations also there.
Very
Principal bench.
My lord, in appellate side matters, my lord.
Yeah, just a minute. Let my officer settle.
I mentioned, but before taking the lease, my lord, subject to lordship's kind sanction, one contempt application may be listed. Jalpaiguri Circuit Bench matter, my lord.
My order.
My lord, great. Your lordship's right. Your lordship's order. This is the mentioning sleep, my lord. Order is to disposed of matter, my lord.
Contempt not complied with.
Not complied with till date, my lord.
Next Thursday, call for the record from the Jalpaiguri.
Grateful.
Yes.
My lord, in item number 1, my lord, I am appearing for the.
Call the matter number.
My lord, in item number 1, I am appearing for the petitioner. My lord, subject to correction, my lord, the records I think is not available.
Yeah. कौन सा हाँ तो ठीक है मेंशन कर रहे हैं ना क्या हुआ लिस्ट में है ना कौन सा नंबर है आइटम नंबर वो तो इज सबमिटिंग
My lord, I think the records are not available. So, my lord, I was praying for a direction upon the registrar, Jalpaiguri Circuit Bench, my lord, to transmit the records to the principal bench.
Which one? WPA 86?
86, my lord, there's a can 1, my lord.
So appearing for the plaintiff. Plaintiff. Petitioner. Lister. On the prayer made by the writ petitioner, the matter is listed as to be mentioned. It is found that the record is not available. Accordingly, the department is directed to bring the record
of can number 1 of 2024 in WPA 86 of 2024 by the next date fix. List the matter on 5th of December 20.
My lord, may I pray for one indulgence? My lord, the entire subject matter of the my lord writ petition is that, my lord, the petitioners are, my lord, not being given the admit cards of the
When the exam starts?
from 2nd of December, my lord.
2nd of December.
My lord.
2nd of December is. So why you are not?
My lord, this matter is coming up on every Thursday, and because of the resolution, my lord, it was not taken up.
What can be done? One day how the record will come here. Tomorrow record will not come. Then Monday, second is a Monday only.
So if my lord kindly keeps it on Monday, if the record comes, I shall try my luck on that.
Jalpaiguri. Jalpaiguri, how it is?
Then my lord kindly keeps it on. I do not have a choice, my lord. Kindly keeps it
When
on.
the exam starts?
From 2nd December, my lord.
Your client's exam is on 2nd?
2nd, my lord. The 7th semester is going to take place from
Now,
7th.
what subject 2nd? Your client.
I'm not aware of it. I shall take instruction, but from 2nd, my lord, it's starting.
Huh?
From 2nd of December, the examination is starting, my lord.
So every day you mention, why you not mention the record is not here?
My lord, it was appearing, my lord, on Monday. I had mentioned that it
You
was.
mentioned, that's why you kept, but you could have mentioned the record should be called on that day. I can pass an order.
My lord, this was mentioned. Your
flag and your submitting is.
My lord, your lordship had my lord, said that, my lord, these Jalpaiguri matters are taken up only on Thursday.
Okay, I am taking other matter. You talk to your client when his paper is there.
My lord, I shall.
Just take the instruction from me. Yes, next.
My lords, I appear for the petitioner.
Yes.
My lords, none of the parties are appearing, my lords. State also I informed.
Nobody is there.
My lords.
So, what can be done?
My lords, kindly reserve the order, my lords. My lords has heard this matter.
No, but the other party, I am fixing a next week. You issue the notice that they will not come. I will hear you.
My lords, my lords.
Suffering for the petitioner. None appears on behalf of the respondents. Police counsel. Let the matter appear on 5th of December 2024. So the petition is directed to inform the next date of hearing to the respondents and to file affidavit of service. It is made clear that on the date fixed, if none appears on behalf of the respondents, the matter will be taken up for hearing in the absence of the respondents.
I'm grateful.
Yes, next.
Item number 3.
My lord, in item number 3, my lord, I am appearing for the respondent.
Ah.
The petitioner, my lord, in this, my lord, in the CRR, the petitioner has filed a recalling application of your lordship's order that is passed by your lordship on 21st May 2024 while your lordship was sitting in the circuit bench Jalpaiguri.
Ah. What is
My
the
lord, my lord, they have taken the ground in their recalling applications which are not at all maintainable because, my lord, they have taken the substantive ground which cannot be, my lord, done in a recalling application. If there is any procedural defect, that can be done by the way of recalling the order. But the grounds they have taken in their recalling applications of your lordship's order, those are all substantial ground which cannot be, my lord, recalled by the way of a recalling application, lordship. Lordship, kindly see what they have stated in their.
Nobody is there.
Yes, your lordship, nobody is there.
कोई नहीं है. Anybody has joined online? No. None appears on the petitioner. Consistency appearing for the opposite party number.
Yes, my lord, opposite, my lord, sole opposite party. No, lordship. Opposite party number 2. Opposite party number 2.
Number 2. Full stop. As none, full stop. For the interest of justice, the case is adjourned. Let the matter appear on 12th of December 2024. It is made clear that on the date fixed, if none appears on behalf of the petitioner, appropriate order will be passed.
I'm
Come.
grateful to your lordship. Grateful.
Next. Yes, just pass the call. Pass the first. Okay, okay. Call. जरा यहाँ देख लिया करो. Yes, what is the stage?
Stage, my lord. Now, my lord.
Appear for the petitioner, my lord. The appeal is being heard, my lord.
Not
So,
People Justice, my lord. Court number 11. Now change. And matter is to be fixed was 3 तारीख को the fixed.
Maybe.
Maybe fixed.
no, hearing is being
Is going on.
Yes,
Hearing
my
is
lord.
being-
Hearing was almost concluded in one bench, but after puja vacation, my lord, termination changed. So again, the matter has to be heard again.
No parted.
No part heard.
So appearing for the petitioners, so appearing for the alleged contemners. It is submitted by the counsel for the respective parties. The appeal is in the list before the appellate court. Accordingly, the case is adjourned. Let the matter appear on 12th December.
As a lordship says, but my lord, I do not think
19 December.
my lord, may kindly keep it after vacation.
After vacation, that is better.
Hobe na, yes.
Then hobe na.
Hobe na, Shukri.
There is
You
a
will be
three pizza
benefited
that
if it
makes.
is listed.
After vacation, any
9th January.
my lord.
Grateful, my lord.
9th January 20.
Much obliged, my lord.
Yes. Just a minute. Yes, what is the...
I just received instructions, my lord, that the examination has been postponed and it will take from January. So it will not
Then fifth.
Chapter close.
Fifth, huh?
Lordship rises, my lord.
Missed the list.
Miss the bus.
But there was the interim order which was.
Nobody is here to take the dictation of the original.
Item number 123 of today's list,
Ah.
man. The interim order is expiring today, man.
All of us must have missed the list that your lordship has a bench of the circuit bench, my lord, and the appellate head. In fact, I had missed it.
Yeah, I have also missed that.
हमारा कोई है अपील सेंटर है कोई?
Maybe then mention tomorrow in the morning, my lord, upon notice.
But tomorrow you are yes. What is
The
your
interim order is expiring.
all? कोई नहीं है. ARCR को बुलाओ कोई को.
Item 132, your lordship.
Just a minute.
Item number 123.
Because the mentioning is at 4:15, so we thought that we should be waiting till.
No. But I missed that there was a other bench
Mother mentioning the 4:15.
or before that.
Oh,
Lordship has a 4:15 bench.
Yes.
Started rating senior advocates.
Yeah, I am here to oppose a mentioning.
Which one? Which one you are opposing, Mr. Singh? Sharma?
Man, that is CSOS 8 of 2024.
नहीं आज कहना फिर ऑपोजिट पार्टी ड्रामा करे. कोई नहीं है एआरसीआर लोग नहीं है. हाँ बुलाओ. Yes, item number
Item number 123 of today's list, man.
123.
Yeah, 123.
Oh,
123.
Lord, I appear for the defendant in this matter. My lord, I am opposing this extension. My lord, the plaintiff has been enjoying the interim.
I will take the hearing. Ready?
My
I
lord,
will take hearing.
Lord, this is.
If you are objecting, I will take the hearing. The 15 minutes is.
My lord, may I point out one thing? My lord, they've been enjoying the interim order from September 2023. My lord, this pertains to a membership of the plaintiff in the club. My lord, for the past 14 months, my lord, the executive committee had changed twice. They've delayed filing the application. Recently, the application was filed. They've been seeking the extension time and time again for 14 months now. So, on this ground, I am objecting to extension. If your lordship is inclined to grant it, I was humbly praying that your lordship may kindly fix it at the earliest possible date so that this application may be heard of.
Pleadings completed?
Yes, my lord, pleadings are completed.
Pleadings are complete. Tomorrow is the date for the returnable before. The master has given the date tomorrow for the second amendment. Initial, the board has changed. We have carried out the amendment. Amended date has been served. Thereafter, the election took place. We have again filed an application for amendment, which is returnable before my lord on tomorrow. The landed master has given a time around 29, and the interim order earlier extended by interim order granted by my lord was on 13th of November 2024, and it is expiring today, my lord. This is the order.
That's why he is objecting for your interim order.
They've been enjoying this in September 2023. The interim order was to allow the plaintiff to contest the elections. He contested the election, secured a grand total of 5 votes. Subsequently, elections have taken place too. No, that was prior to that. The division bench, if I may be, the division bench allowed the plaintiff to contest the elections. He contested the election, secured 5 votes, and did not become the secretary. Subsequently, another election has taken place. So, that extension is going on till today. So, I was humbly praying that this application may kindly be taken up at the earliest possible date and may be heard of. Pleadings are complete in this matter.
Mr. Thakur is leading me in this matter, my lord. Any day, in the meantime, the interim order may be extended.
And second one? Which was the other side?
Permitted to present and mention
Item 132.
item 132 of
132 is the interim order is still today, but this is that intention on the memorandum of understanding which was executed on coercion on the son of the plaintiff being arrested. Your lordship would recollect, your lordship had stayed the memorandum of understanding till interim order is still today. And we have served the affidavit.
Have you saw the copy?
Yes, I've just now. Both the parties are busy.
আটকানোর দরকার নেই স্যার, প্লিজ ইন্টিমেট করাও যদি কোর্টে বলে কন্ডাক্ট just to mention after knowledge also they are
possibly they are already in contempt of the order despite your lordship's the memorandum of understanding. My lord, they have initiated 156(3) on the basis of that and for the checks.
revision of the against the order of
156(3).
The 132.
163 is rejected before.
हाँ, ये कितना दूर है? फोन करके नहीं बुला सकते? कोई नहीं है? आ रहे?
আগে ছিল before this order 156 যখন ওটা মুভ করে যেটা রিজেক্ট হয়ে before the order, তারপরে ওয়ান রিভিশন যখন করছে ওটাও before the order অ্যাডমিট হচ্ছে এখন the revision application at for what against for investigation is from 156 so to 156 হবে না এখনো পর্যন্ত হিয়ারিং হয়নি, জাস্ট অ্যাডমিট করেছে, but they are not trying to see anything before the court.
Original
Right.
or appeal is not
Right, but they are moving.
If this is allowed, 156(3).
If they
under
right,
156(3),
right, okay. This no, it is.
Till such time, my lord's offices come. One other fact, my lord, I should point out. I think it's my duty to point out. My lord, this memorandum of understanding executed by coercion was stayed. Under this, my lord, checks were issued, which has also been the naturally effect is that it's been. They filed an application under 156(3) of the Code of Criminal Procedure. That was dismissed on the basis of this memorandum. Then after receiving this order, and there's a pleading in their application also, that after receiving this order also, they have, my lord, filed a revision, criminal revision, from the order of dismissal of the 156(3) and are proceeding with that. So, my lord, they're really in contempt of my lord's order.
नहीं है क्या? नहीं हम लोग आए नहीं आएगा तो serial number 123 है
132.
छोड़िए concession suffering for the plaintiff. Who is for the defendant? 123. 123.
Yes, I am for the plaintiff.
Concession for the plaintiff. You are for the defendant. Concession suffering for the defendant. Though the matter is listed in today's list at item number 123, but due to paucity of time, matter could not be reached. Accordingly, counsel for the plaintiff has mentioned the matter on the ground that the interim order granted earlier is going to be expired today and paid for extension of interim order. Counsel for the defendant has raised objection and submitted since the month of September 2023, the plaintiff is enjoying the interim order and prayed for fixing the matter for hearing. In view of the submission made by the counsel for the respective parties, interim order granted earlier is extended till 19th of December 2024 or until further order, whichever is earlier. Full stop. Let the matter remain in the list.
Lord, may I have your lordship's kind leave to mention?
Just a minute.
Lord, will it be lordship's pleasure to fix any date for hearing of this application?
Remain in the list. It may come tomorrow because the one day I am taking the testamentary first. Tomorrow I will take the adjourn motion of the ordinary. It will come tomorrow. It will come. It will be taken because now this court is not fixing the matter in date and time. If you want the date and time, I will fix. Then it will go to the January 2nd week.
No, Lord, let it remain in the list.
Item number 132. Item number 130. Who is for the defendant? Nobody.
Nobody appearing. We have filed the affidavit of
Concessions appearing for the plaintiff. The matter is listed as item number 132 of the today's list, but due to paucity of time, the item could not reach for hearing. Accordingly, the counsel for the plaintiff has mentioned the matter on the ground that the interim order granted earlier is going to be expired today and prayed for extension of interim order. Counsel for the plaintiff has filed affidavit of service showing that the notice have been duly served upon the defendants, but in spite of service of the notice, none appears on behalf of the defendant. Let the affidavit of service be kept with the record. The interim order granted earlier is extended till 2nd of January 2025 or until further order, whichever was earlier. Let the matter remain in the list.
Item number 126, my lord. Similar
Yes.
prayer.
Item number
126, my lord. I have served notice on the other side also, my lord.
126. So and so, item number 120. So and so appearing for the plaintiff, none appears on behalf of the defendant. The matter is listed as item number 126 in the today's list, but the matter could not reach due to the reached for hearing due to paucity of time. According to counsel for the plaintiff has mentioned the matter after notice to the learned. Counsel for the plaintiff submit that the interim order granted earlier is going to be expired today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order granted earlier is extended till 2nd January 2025 or until further order, whichever is earlier. Let the matter remain in the list.
Much obliged.
Next.
My lord, may I have my lord's kind leave, my lord, to mention CSOS number 8 of 2024, my lord.
Item number.
My lord, it's not listed today. It was returnable
Not
today.
listed.
No. No, my
No,
lord.
I am appearing on behalf of all the defendants in this matter, my lord. My lord, we have filed a demurrer application IAGA 1. May it also appear in the list as per your lordship's convenience, my lord.
1.
Yes, IAGA.
That is not in the list.
No.
CSOS.
No, man.
CSOS, my lord.
CSOS.
My interim order is expiring today, my lord. It was till today.
So and so appearing for the plaintiff. The plaintiff has matter. I mean, there is no list. Counsel for the plaintiff has mentioned the matter on the ground that the interim order granted earlier is expiring today. Counsel for the defendant is present through virtual mode and submit that he has filed an application being GA number
1 of 20. Though I'm formally also opposing the extension. For suit is not maintainable, my lord. This cannot be an originating summons suit, and court has no territorial jurisdiction also.
Counsel for the defendant raised objection for extension of the interim order. Consider the submission made by the counsel for the respective parties. This court find that this court has already passed an interim order which is extended from time to time. Accordingly, interim order granted earlier is extended till 8th of January 2025 or until further order, whichever is earlier.
And lordship, my IAGA 1 may appear in the list on any date.
Directed to list the matter being CSOS 8 of 2024 along with IAGA 1 of 2024.
At the earliest, as per your lordship's convenience.
5th of December 2024.
My lord, instead of 5th, my lord, could it be 6th, my lord?
My lord, 11th of December. Lordship.
Rather, my lord, 5th. 11th to 13th. Personal difficulty.
My lord, other than 5th and 6th, any other date, my lord.
Then 17th.
10th, my lord. 10th.
10th is the commercial day.
Then 11th lordship is not.
11 to 13 he will not be available. Then 18th.
Grateful, my lord. Deeply obliged.
Yes.
Just one more thing with this. I was also on behalf of the defendant, Mr. Sharma was leading me. Kindly extends the time to file the affidavit in opposition on behalf of the defendants.
Counsel for the defendants prays for extension of time to file affidavit in opposition in connection with interim application.
CSOS.
Suit. CSOS.
Affidavit in opposition in respect of the suit. Affidavit or written statement.
My lord, originally
opposition.
My lord, it was supposed to be filed within 2 weeks post vacation. My lord, that has not been forthcoming.
Let affidavit in opposition filed within 2 weeks from date. Let the matter appear on 15th. Yes.
Grateful.
Grateful.
Lord, may I have your lordship's kind leave to mention item 90 from your lordship's non-commercial list, my lord, seeking extension of the interim order, my lord, dated 10 September 2024. My lord, it expires tomorrow. My lord, I shall also indicate that the respondents have preferred
tomorrow. You mentioned tomorrow.
Very well, my lord. Very well.